Welcome to the third hearing for the inquiry into the provision of the Voluntary Assisted Dying Bill 2021. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land on which the Parliament sits. I would also like to pay respects to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. Today we will be hearing from representatives of New South Wales Health, in addition to representatives from other medical bodies, such as Palliative Care New South Wales, the Australian Medical Association New South Wales, and the Royal Australian and New Zealand College of General Practitioners. We'll also be hearing from a number of other medical professionals and academics, in addition to groups representing the aged population. Before we commence, I would like to make some brief comments about the procedures for today's hearing. I note that the hearing room is closed to the general public today. This is due to room capacity restrictions under New South Wales Parliament's COVID safe arrangements. However, the hearing will be broadcast live on the Parliament's website. While parliamentary privilege applies to what witnesses say giving evidence today, it does not apply to what witnesses may say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer by the 28th of January 2022. As I mentioned, today's proceedings are being live streamed and a transcript will be placed on the committee's website when it becomes available. In terms of audibility for today's hearing, we have witnesses in person and via the video conference. Can I please ask committee members to clearly identify who the questions are directed to? And could I ask everyone appearing remotely to please state their name when they begin speaking? Could everyone appearing via the video conference please mute their microphones when they are not speaking? Members and witnesses should avoid speaking over each other so that we can all be heard clearly. And to assist Hansard, may I remind members and witnesses to speak directly into the microphone to avoid making comments when your head is turned away. I now welcome our first witness. Dr. McMullen, could you please state your name and position title and swear either an oath or affirmation?
Thank you. I'm Dr. Danielle McMullen. I'm the President of AMA in New South Wales, the Australian Medical Association New South Wales, and I affirm that I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Dr. McMullen. And would you like to start by making a short opening statement?
Thank you. I would also like to acknowledge the traditional owners of all the lands we're meeting on today and pay my respects to their elders past and present. AMA New South Wales thanks you for the opportunity to appear before this inquiry into the provisions of the Voluntary Assisted Dying Bill 2021. AMA New South Wales is the peak professional association representing all doctors in New South Wales across specialties and stages of career. Our overarching position is that voluntary assisted dying is a matter for society and government. AMA New South Wales acknowledges that many jurisdictions in Australia and indeed around the world have enacted legislation for voluntary assisted dying. We see our role as to ensure the medical profession is appropriately represented in the development of any legislation and to ensure that should New South Wales legislate on voluntary assisted dying, that it's the most appropriate legislation. A number of our concerns were addressed in the process of amendments agreed to by the Legislative Assembly. Namely, we're supportive of the removal of the requirement for doctors who are conscientious objectors to provide information to those seeking voluntary assisted dying. And we're also pleased with the amendments made to the eligibility to act as a coordinating practitioner or consulting practitioner. There do, however, remain a number of areas where AMA New South Wales would like to raise as requiring closer attention. Firstly, regards to the initiation by a healthcare worker of discussions regarding voluntary assisted dying. We submit that Clause 10.3 should be removed from the bill, as a discussion regarding voluntary assisted dying is not a discussion for an acute setting and is best undertaken by a medical practitioner, ideally as part of a considered discussion canvassing treatment options, palliative care and voluntary assisted dying. In other jurisdictions, healthcare workers potentially other than doctors and nurse practitioners, are not permitted to initiate conversations about voluntary assisted dying. Secondly, with regard to the time period between the first and final request, we propose that the designated period in Schedule 1 be extended to 9 days to match that in other jurisdictions. There remains the provision in this bill for that period of time to be shortened if, in the opinion of the coordinating practitioner and the consulting practitioner, the patient is likely to die or lose decision-making capacity in relation to voluntary assisted dying before the end of the designated period. We submit that the approach taken in Victoria and Western Australia is the preferred approach, and the opinion of palliative care practitioners that we've consulted is that 9 days makes an accommodation for those patients who may suffer delirium or other short-term conditions that subside after a few days and may subtly affect decision-making capacity. Given there is a provision that allows for the time period to be shortened if death is imminent, there appears to be no persuasive reason for the shortened designated period. Finally, with regard to the assessment of capacity, we question why the New South Wales Bill has chosen to single out psychiatrists as health practitioners who may have appropriate skills and training to make such a decision. Other jurisdictions have not made such a determination, and we encourage consultation with the Royal Australian and New Zealand College of Psychiatrists regarding the appropriateness or otherwise of specifically referencing referral to psychiatrists. Of course, in closing, we'd like to again call for improved funding and resourcing of palliative care in New South Wales. People with life-limiting conditions deserve comprehensive support and access to all information and options for their futures.
Thank you very much, Dr. McMullen. If you're happy, I'll open up for questions now. Just looking around the room, is there any committee members who have got some questions? Mr. Donnelly?
Thank you, Deputy Chair. Thank you for making yourself available this morning so early. Just in terms of your opening statement and the use of a particular phrase, which is also in your submission itself, in the introductory paragraph, just specifically refer to it. And it was in your opening statement, but it's in paragraph 1.2 of your submission, and it's the end of the final sentence. I won't read it out, but all of it, but the second last line says, developments of any legislation to ensure that should New South Wales legislate on voluntary assisted dying, it is the most appropriate legislation. My question to you, Doctor, is on behalf of the AMA, New South Wales, who you're representing today, what do you mean and the organisation mean by most appropriate legislation?
My understanding of our interpretation there is that it's legislation that is safe for both the doctors participating in the scheme and for patients of the scheme, accessible to patients requesting voluntary assisted dying, and also acceptable to both doctors and patients trying to use a voluntary assisted dying scheme.
So just going through that again. So it's safe for patients and doctors. It's accessible. And what was the third? What was the third element?
And acceptable. Acceptable.
Acceptable to who?
So that doctors and patients. So that both doctors trying to participate in the scheme find the restrictions around it acceptable and implementable, and that patients find that it's acceptable legislation to meet their needs. Predominantly, here we are though representing doctors, so our primary engagement in this process is from that doctor perspective, to make sure that the legislation, if passed, is acceptable to the doctors trying to participate in it, keeps them safe medico-legally and professionally, and that it is implementable as well within our current medical framework.
Okay. Just for clarity's sake, the AMA New South Wales branch, who you represent, they don't have a policy position on assisted suicide and euthanasia?
Correct. We do default to the federal AMA position, but as we've set out, the statement that AMA New South Wales has passed from our council is that we consider voluntary assisted dying to be a matter for society and government, but that, and as was in my opening statement, that our role would be to make sure that doctors are adequately represented in the development of legislation.
Could you please tell the committee, either on notice or if you've got it with you, what is the AMA national position, national body's position on assisted suicide and euthanasia?
We can provide that document on notice. It's not hugely lengthy, but there's a document that provides the federal AMA position, and so we can provide that on notice.
And with respect to the World Medical Association, an organisation you'd be well familiar with, do you know that organisation's position on assisted suicide and euthanasia?
I do not.
You've never checked to see what that provision is, I guess? That's what you're saying? You're not familiar?
Personally, I've not checked it ahead of this morning, but again, if we want, I'm sure we could find the document and provide it, but it would be easily accessible.
And with respect to the World Health Organisation, as a global organisation, do you know its position with respect to assisted suicide and euthanasia?
I have not reviewed their position ahead of today.
Okay, thank you. In terms of now looking at the bill itself specifically, and thank you very much for elucidating on a few points, and I'll have to pass over shortly to colleagues. One of the issues in contest, if I could describe it this way, is, and it's around this theme, I guess, of appropriate legislation, is that in at least Victoria, as an example, there's a provision requirement under the legislation that in terms of one of the two participating medically qualified people in the procedure dealing with a patient seeking assisted suicide, potentially, that there is the requirement for a specialist to be involved in that process. Now, that was placed in that legislation very explicitly, and at the time in 2017 agreed in general that this was a safeguard provision, seen as a safeguard provision. And if you review the Hansard debate in the Parliament in late 2017, which went over a period of time, it was all described as a safeguard by both sides, those pro and against assisted suicide and euthanasia, including quite esteemed medical organisations, I have to say. Why would it be the position now that the requirement to have a specialist participating in this procedure, which is obviously a very significant procedure with a finality to it, that is the person either suiciding or being euthanised?
What is this with suicide today? The bill is the assisted dying bill, and that has been the consistent term.
Is there a point of order?
Well, yes.
Okay.
Point of what?
So I think
As I've said, it seems to be an intent to now run a theme which is unnecessary in the terms of just getting to the facts of what this is about.
Okay, Mr. Donnelly, view on the point of order?
Well, the bill provides for providing an individual with the ability to commit suicide. We know this. That's what it provides for. Or for a individual to be euthanised. That's what it provides for.
Well, it's actually a wrong terminology. It doesn't. Euthanasia does not involve a requirement for capacity.
I'll go back to my...
Deputy Chair, I'm happy to rule, and given that the bill...
Move on and ask the question.
Well, I was going to say, given that the bill is titled the Voluntary Assisted Dying Bill, I think it's an appropriate term to use, voluntary assisted dying, and so I will uphold Mr. Khan's point of order. But if you're trying to describe other mechanisms, then you're in order. But if you're referring to the bill and the provisions within the bill, I'd ask you to adopt the terms within the long title of the bill.
So with respect to then, at the time, which is not that long ago, the Victorian Parliament addressing this issue and seeing fit that a specialist be involved, and that was considered part and significantly important part of safeguards, why is it the position now that it's no longer deemed to be a safeguard to involve a specialist and it's okay to have effectively two GPs, both of whom may have no relationship with the patient at all?
So we did consider that it changed to the bill and whether we thought it was vital that one of the practitioners have specific specialty expertise in the condition of the person who is seeking voluntary assisted dying. We felt that other measures in this bill were strong enough, that is, that there is a strong obligation on both the coordinating and the consulting practitioner to ensure that they do have adequate ability to make decisions about the condition that the patient has, that is, whether it is terminal within the next 6 months or 12 months in the case of a neurological condition. And we didn't feel that there was a necessity for one of those practitioners to be of a particular specialty for that condition. The reason being that there is, as I said, that strong obligation for the practitioners to seek referral or other advice if they need more information, and that our feedback from Victoria was that this does in some cases provide significant burden on a small number of practitioners, particularly for rare conditions, and also limits access potentially for people in rural and regional areas.
Thank you.
Thank you, Dr. McMullen. I'll now pass to Mr. Farlow and then after that, Mr. Martin.
Thank you very much, Mr. Chair, and thank you, Ms. McMullen, for being here this morning. Just wanting to seek some elucidation from your submission with respect to eligibility requirements for practitioners. You state there that you've made representations and understand that amendments are to be made that address your concerns. If you could just outline those for the committee, that'd be helpful.
Yes, so that was with regard to the eligibility requirements for practitioners. We had concerns with the initial draft of the bill that included overseas trained doctors still under limited provisional registration here in New South Wales, and that placed an unnecessarily unfair burden on them and also their supervising practitioners. And we thought it was just in its drafting had perhaps been a misunderstanding of the medical system in that those practitioners would still be in some supervised practice, and as with the other categories of eligible practitioners, they're all more senior practitioners who've been practicing in the New South Wales environment for some time, and so we thought it appropriate that that group be removed, and our understanding is that they have been removed there.
Okay, thank you, Dr. McMullen.
Mr. Martin.
Funnily enough, my colleague just went to the same point I was about to make, but would you be able to just elucidate a bit more on the length of time that a doctor's been practicing? Do you believe that the length of time, as per the bill, is long enough?
I think it is now, I'm just trying to find that page in the bill, but my understanding is that it's now at 10 years. Correct me if I'm wrong, and we're happy with that.
Okay, thank you.
I'm just going to check around the room to see if there's any more questions from members. If not, Dr. McMullen...
No. Oh, sorry. It's more opportunity for questions?
Yes. Yep. Mr. Donnelly has the call.
Thanks, Doctor. Just returning, I thought there might have been some questions from other members forthcoming. Just going back to your submission again, if I could just skip through these points. So once again, thank you for it. The matter of a person in their state of mind, if I could use that phrase, it's a generic phrase, a layperson's phrase, their state of mind towards the end of life with a condition that they have which is life-limiting, and also meeting the other criteria under the legislation under eligibility. We've had evidence from witnesses last Friday about the often circumstance where the person may find themselves depressed, actually clinically depressed, and obviously that is related to their circumstances. The matter of that potentially not being diagnosed, that is the person's depression, clinical depression, and the impact that has on their decision making, at least to me, and I think others as well, seems to be of quite significant concern. Because properly understood, if the depression is diagnosed and treated, the person's state of mind may well change in terms of consideration of their circumstances. Why would not the AMA be ventilating issues around this matter of the person's state of mind, particularly around depression and related matters of circumstances, and therefore the need to be particularly careful that the person in fact is not depressed or like conditions, related conditions, and therefore that ought to be all taken into account before proceeding down the path of assisted suicide or euthanasia?
Well, again, I'll take the point. You ruled before, and it happens again.
I am going to uphold the point of order. Mr. Donnelly, I was
following the provisions under legislation.
I was following well, I'm going to make the point just so that we don't have to keep doing this all day. You were referring to the provisions of the bill. The bill is titled Voluntary Assisted Dying. I'd ask that you refer to the acts under that provision by its correct term. I hold the point of order from Mr. Khan. Ms. McMullen, are you able to provide a response to that?
Thank you. So, as has been said, this is about voluntary assisted dying. We would undertake that the requirement for two separate doctors to both consult with the patient about their reasoning, intent, their illness, and to discuss with them all options available to them for their care, including voluntary assisted dying, would, if a clinically significant depression that is likely to be affecting their mental state is apparent there, that would be identified and diagnosed during that process. Because there is a requirement under the bill that patients need to be competent to be making such a decision. So part of that assessment of competence would be to be undertaking an assessment of the mental state in the clinical sense, the mental state of the patient in front of us, and their ability to competently make that decision.
So just if I can press this further because there's still some time, am I right in hearing you just say that, I'm quoting directly from you here, I think, that accessing voluntary assisted dying under the legislation would be discussed potentially with the patient as an option for their care? That's the word you use, their care. Is that the position of the AMA New South Wales?
And apologies, Pat, we see voluntary assisted dying if it's legislated that there is a role for doctors to have to participate in that. Our view is that in general, voluntary assisted dying is best discussed by patients who raise it in the course of them seeking information about what may happen to them at end of life. As we discussed earlier, we don't see a role for healthcare workers other than doctors to be able to raise the issue of voluntary assisted dying, but we are certainly not advocating for doctors to always raise voluntary assisted dying. It is best done as part of a comprehensive discussion of end-of-life management.
Okay, so
that hopefully answers your question.
Well, no, it hasn't, because what you stated, Doctor, was that in discussions with the patient, that it would be discussed in the context of an option for their care. Now, that's what you said on behalf of the AMA New South Wales. Now, I'm wanting to know, can you please explain how accessing VAD relates to the matter of providing care to the patient?
Let me clarify that should voluntary assisted dying be legislated, in general, we expect that it will be raised by patients. We call them by people who want to access voluntary assisted dying, ideally with their usual treating care team who understand all options of care for them. In that context, it can be discussed with them as an option for their end-of-life care management, should it be legislated in New South Wales.
So could you just explain to me that with respect to a doctor having a patient in front of himself or herself, and that patient's health was, let's use the vernacular, not in particularly good shape. Okay, they were dying. They were talking about a patient that had a condition that was terminal. In what circumstances would a doctor, under your description, raise with the patient the issue of voluntary assisted dying as an option?
Very much, until this legislation is passed, we can't answer that question. There's quite strict requirements under this proposed legislation about when and how that can be raised, and I think that's pretty clearly outlined in the draft legislation.
Well, could you please explain to me how that is so? That there is a restriction on the based on the evidence you've just given a moment ago about the raising by the doctor with respect to the patient. You say there's restrictions around that. Can you explain where those restrictions are?
They are in the section of
and listen, this is not an ambush. If you want to take it on notice.
Initiating.
I'm sorry? If you need to take it on notice. Sorry, I'm just saying, I'm not trying to ambush you. If you don't know where the provisions are, you can take the question on notice. But I'm interested, you appear to be suggesting that there are restrictions around the ability of a GP or members of your organisation to be able to raise with the patient the matter of, as you describe it, an end-of-life option, namely VAD. In other words, there is a restriction placed on the individual.
Mr. Donnelly, sorry, I was listening intently to the answer, and I believe Dr. McMullen was referring to currently there is a restriction until the legislation is passed. Is that the correct interpretation of your answer just given before, Dr. McMullen?
No, my answer was that even once the legislation is passed, if it's passed in its current draft form, that there are some restrictions on that doctors, so the section we're referring to is 10.2, where medical practitioners who initiate discussion there are a number of criteria set out there about what other circumstances must also be in place for the medical practitioner, what other information must be passed along for doctors to be able to initiate a discussion about voluntary assisted dying with their patients.
You mind if I just pass it off to Mr. Khan and then I can come back to you? Or?
So just if I'm receiving your evidence correctly, and then I'll resubmit to the chair. So with respect to 10.2 in the legislation, and obviously 10's heading is healthcare workers not to initiate discussion about voluntary assisted dying. Then 2 says subsection 1 does not apply to a medical practitioner. I think that's the point you're making. Who initiates a discussion or makes a suggestion. It continues on. The medical practitioner also informs the person about the following. So what this actually provides for, properly understood, doctor, is not what you're saying at all. What it's saying is, if I read it correctly, is that if the medical practitioner raises those matters in a discussion, in other words, they initiate the discussion with the individual, meeting these matters you've referred to in 10.2 A through to D, they can raise, that is, they can raise the matter of this option you described as care a bit earlier on. Now, is that your understanding?
They can raise, if they meet those criteria and they have the professional ability to provide the answers and the information there outlined in 10.2, that yes, medical practitioners can raise voluntary assisted dying as an end-of-life option for patients if they're also able at that time to provide the detailed information outlined in 10.2.
Mr. Khan.
Dr. McMullen, if I take some of the evidence that we received, particularly on Friday, correctly, some witnesses have proposed that there should be a requirement for the coordinating practitioner to communicate with, in some way, the treating general practitioner prior to proceeding under the provisions of the bill. What I want to ask you is this. if the treating general practitioner had refused to participate or had lost the confidence of the patient for some other reason, what would you envisage would be the nature of a discussion that would take place between the coordinating practitioner and the treating general practitioner?
As that's a matter we haven't considered before, we can take that question on notice and get back to you.
Thank you. If you have a patient, doctor, and that patient says, I want to do this range of care, whatever it be, and I don't want you to speak to my former doctor, are you in a position to, for instance, ignore the patient's request and then consult with the previous practitioner?
We can also get back to you on that one too.
See, I would have thought at the end of the day, if a patient wants to proceed on a particular course and you have undertaken an assessment of that patient, determined that they are capable and informed, you're not, as a general practitioner, entitled to go off on a jaunt of your own with regards to what, contrary to what the patient has requested. That would be consistent with your ethical obligations, wouldn't it?
As I said, we can take the sort of the medico-legal matters there on notice and provide you a response with reference to the requirements under the bill for coordinating and consulting practitioners to have a full and complete picture of the patient's prognosis and ability to make decisions.
Sure. And let me just go one step further and say, if a patient, for instance, says to you, I don't want you to tell a family member that I am undertaking a particular form of treatment, or indeed, if this bill were to pass, to proceed with assisted dying, I would suggest to you that you are ethically bound to maintain the confidence of that patient. That would be correct, wouldn't it?
With that example of telling family members, correct, there are strict confidentiality requirements across all aspects of medical care, and in general, you can't, if the patient has requested that you not share details of their medical treatment with a family member, then in general that is a wish that needs to be upheld.
And you would have seen, doctor, in your own practice, circumstances where the family members of a patient, particularly in the circumstance of a dying patient, can have a range of views as to treatment or what the patient should do in some form. That would be correct, wouldn't it?
That may be correct for some families.
Yeah. So, for instance, you might have, if a patient is in hospital, you might have a patient saying, for instance, I want to go home to die. That may be a decision that is supported by some family members and vigorously opposed by other family members. That would be correct, wouldn't it?
It may be correct for some families, yes.
So that in those circumstances, I suggest, patients will choose a course of action which may or may not be consistent with the views of part of the family, but that's the nature of life and families, is it not?
Correct.
Yeah. So that a suggestion that might be made from some of the evidence that the family should be informed of the patient's decision, in a sense, firstly invites a circumstance where the patient's desire for confidentiality would be breached by such an obligation, would it not?
We've not participated in that segment of giving of evidence, so I wouldn't make a comment specifically on that.
All right. Well, I think I'm done because I'm quite comfortable.
I've got some more questions.
We've got a few more minutes. If there's no other questions from any other committee members, Mr. Deputy Chair, you've got the call.
Thanks, Chair. Doctor, just returning to the matter of the issue of Clause 27. And the issue of assessment, sorry, that's 27, but also earlier back the issue of decision-making capacity. Doctor, do you think that generalists are qualified to make the necessary assessment regarding decision-making capacity without, that is, decision-making capacity and the matter of coercion? The evidence on Friday, and there's been evidence in submissions as well to this inquiry, that the detection of coercion is most difficult. The actual detection of whether an individual is being coerced is most difficult and not something that can be quickly assessed. In other words, some of the evidence on Friday was that it takes, in fact, quite an astute individual, just forgetting about medical qualifications for a moment, but an individual quite astute and experienced in detecting that a person has been coerced. Coerced into anything, but this is obviously the matter of coerced into the issue of the possibility of the matter of voluntary assisted dying. Is it the evidence of yourself and the AMA that generalists, that is the doctors that you represent, are qualified to be able to make this assessment about this matter of decision making and whether or not coercion is taking place or may be taking place?
So we represent doctors across all specialties and would argue that doctors across a range of specialties may have the skills and expertise to undertake an assessment of decision-making capacity and the potential for coercion, and that depending on the specific patient circumstance and the questions around their capacity or around risk of coercion, that may be different specialties. For example, geriatricians are quite often involved in decision-making capacity assessments. So our main point around this was that by narrowing to psychiatrists, that may or may not give a sort of a representation that the whole specialty has specific expertise in decision-making capacity at the exclusion of other specialties, which we would say is not necessarily accurate. And we have suggested consultation with that craft group to further define that and reassess whether that nomination of psychiatrists in these sections of the bill is necessary.
Well, that's not the question I actually asked. And in answering to the question, you're referring to a generalist who may have the skills in terms of the detection of coercion. Now, can I put this to you? What happens if a person with a life-ending illness happens to have a generalist doctor who does not have the skills, and that generalist doctor, picking up the point that you raised in my earlier line of questioning, in their discussion with the patient about, if you've read the provisions in the legislation correctly, 10.2, as part of the care process, as you described it, raises the matter of assisted suicide and euthanasia, or sorry, rather VAD, voluntary assisted dying, with the patient. Where does that leave the patient?
So there is a requirement for doctors participating in the scheme to be able to be confident they have been able to assess the decision-making capacity of the patient and whether they're acting under duress or other influence. So if the generalist doctor did not have those skills, they would be required to highlight that and not participate in the scheme. It is, I would put to you, equally likely that the patient may have a specialist doctor who does not have the requisite skills to assess decision-making capacity in that specific case. Decision-making capacity assessment is a complex assessment that varies depending on the matters that are up for question. And so it is not limited to a specific specialty or indeed a non-GP versus a GP specialist as to whether they are able to participate in capacity assessments.
Thank you, Doctor.
Thank you, Dr. McMullen. We're almost out of time, but just before we leave you, I just wanted to quickly check. There's been a bit of debate this morning about the terms, but can I just, for a layman, is suicide, euthanasia and voluntary assisted dying all considered three separate and different discrete items by the medical specialties?
So certainly suicide without any qualifying factors would be considered different. We can get back to you on notice with what we would provide as our definitions, where it's the overlap of terminology, but for the purposes of this bill, we have also been using voluntary assisted dying as the terminology throughout our communications with reference to this bill and what would be happening going forward in New South Wales.
Thank you very much, Dr. McMullen. We've come to the end of our time. If you've taken any questions on notice, we'll be in contact with you to have those tabled. And I thank you very much for making yourself available this morning. I know you've been very busy, and we thank you for making yourself available. We'll take a short break now, and then we'll have the witnesses in the room for 9:15. I now welcome our witnesses from New South Wales Health. I remind witnesses and members that the committee has resolved that government representatives are expected to not take a position on the bill, but only to provide factual information on matters such as current legal and medical arrangements for those in care approaching end of life and how the provisions of the legislation might work should the legislation pass the Parliament. Could each witness, starting from my left, state their name and position title and swear either an oath or affirmation?
Leanne O'Shannessy. I am the Executive Director, Legal and Regulatory Services at the Ministry of Health, and I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you, Ms O'Shannessy.
Nigel Lyons, Deputy Secretary, Health Systems Strategy and Planning, New South Wales Ministry of Health. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you, Dr Lyons. Would either or both of you like to start by making an opening statement?
We don't have an opening statement, Chair. We're happy to answer any questions the committee might have.
Thank you very much. Just looking around the room, Mr Diadam.
Thank you. Thank you for your appearance today. I wanted to ask about the Health Secretary's role under the proposed legislation. We've just, one of the consistent areas of exploration for the committee is the question about capacity assessments and also identifying risk factors for coercion or duress being present where there's an applicant for VAD. The proposed clause 180 of the bill sets out what should be included in the approved training and other resources, and B is training and suggests that there'll be training and resources about assessing whether or not a patient meets the eligibility criteria. Has Health done any preliminary work in terms of identifying what the training might look like, what the resources might be that assist in that task of assessing patients in terms of the eligibility criteria?
Well, just on the legal side of things, I don't believe we have done any work to date on the matter. It's ultimately a matter of if the bill passes, then we would need to look at it. There are already a range of policy directives and guidelines in relation to broadly to consent, which would form the basis for any work that would need to be adapted in order to deal with that. And there's also extensive policies of end of life about identifying, in relation to end of life management, in relation to identifying people's wishes and beliefs and engaging with people on their decision making.
So if I just add that there is extensive policy guidance already, which we're at the moment, given this legislation before the Parliament, we're looking at that policy guidance and what we need to strengthen, subject to it passing. And we're also thinking about what will be required in terms of ongoing education for all health professionals. We're very conscious that there is extensive work already. We've got examples such as our policy around recognising elder abuse and some of the factors that healthcare professionals might want to consider when they're actually providing care to elderly people, and what action should be taken if they've got concerns. And we've also established a module with our Health Education and Training Institute that provides a module of education that our healthcare professionals have access to, which can give them some further education guidance and support in how to recognise and act on. Now, we'll need to look at not just the policies that exist, the guidance that supports those, but also the education and training that's available. And we're very conscious that should this legislation pass, that we'll need to ensure that that is available not just to people who work in New South Wales Health, but to all healthcare practitioners, whether they're in general practice, whether they're working as specialists in private practice, whether they're working in private hospitals. So it's going to be a very important aspect of our implementation process to go through that and ensure that we've got the right resources in place, and that we can ensure that people have access to that education and training to ensure that they are appropriately skilled and have knowledge to support this legislation. So it's going to be really important work, which is why the 18 months we see is really critical. It seems like a long time, but there'll be a lot of work required from us to develop all of those resources and to do that in consultation with appropriate colleges of specialists and also with consideration to the legal and ethical aspects as well. So I think the benefit for us will be that given that there are a number of other states that have already gone down this path, we're already in contact with them to understand what they've put in place and to ensure that we can build on their learnings and ensure that we have the optimal arrangements in place to support our healthcare professionals if this legislation passes.
Ask a follow-up question to that. What interests me is, and I say this in the context that my father was a general practitioner, but we hear from a lot of doctors about their interactions with their patients, but particularly in the hospital setting and also in the home care setting, the health practitioner, if that be the right term, who has the most and regular and indeed more informal contact with a person, with a patient, is actually the nursing profession. They're more likely to see a patient interacting with relatives, both in the hospital setting and in the home setting, whereas opposed to the doctor who's likely to see the patient with everyone else pushed out of the room, for instance. It's quite a more informal and interactive experience in my perception. So if you're providing training, is it anticipated that you would provide training on coercion and the like also to the nursing profession?
Absolutely. So all of our training is for healthcare professionals of any type so it's not whether you're a doctor or a nurse, allied health, it's available to everybody. And our expectation would be that people who are involved in providing end-of-life care should absolutely be the target for this education and training material, and that it would be applied to all of the healthcare professionals. Now, the other thing is, in our context, we work in multidisciplinary teams, so that everyone in the team is an important part of that team and has a part to play in ensuring that the wishes of the patient, the carers, families are actually met. So if there is an interaction where somebody learns that somebody has a desire or wish or wants to make a choice, then it's that person should be communicating with the rest of the team around that.
So if we go to, I think it's clause 10, sorry. If we go to clause 10, I hope I'm right in saying it's clause 10. Yes, which talks about, and I'll deal with clause 10.2 as opposed to 10.3, where we're talking about a medical practitioner initiating a discussion with a patient. That could be in the context, could it not, when we start talking about multidisciplinary teams, that the patient has already communicated a desire to look at the option with the nurses on, say, on the ward or with a community health nurse. And what really 10.2 provides is that the doctor who's already been informed of the patient's wishes can essentially follow up and initiate the discussion. You couldn't, in a sense, if you didn't have that, a patient could be communicating with nursing staff, and yet the doctor sort of has to sit there plaiting beads without being actually able to have a discussion which he knows is actually already occurring with other health professionals. That's why that sort of clause is necessary, isn't it?
I think from my reading of this clause, the critical issue is not just around the fact that the medical practitioner will become involved in having those discussions, but the importance about the holistic discussion, which is it's not just about one component, it's actually around a range of options that are available, and that the choices that should be available and that those should be shared so there's complete sharing of all of the options, and that then the option around the choice is made by the individual and their family.
Well, I've stolen Mr. Adams.
I'm more than happy for you to
take individual and the family.
Well, the individual make the choice, but of course they usually, as with every situation, people always talk to their family about these particularly important decisions.
But can I invite you to have a look at the questioning from the Honourable Trevor Khan in regard to the earlier part of the evidence today, where he specifically dealt with a line of questioning where there is a rift in family members' relationships, and in fact that...
Not an uncommon thing, Greg.
No, but I invite you to have a look at that, because he's talking about the circumstances where there is absolutely, under the legislation, no necessary obligation of any discussion whatsoever between the patient ending their life under VAD and family members.
All I was talking about is the usual circumstances in clinical care, Deputy Chair. It wasn't a reflection of the particular reference to this bill.
I'm going to allow Mr Diadam to continue his line of questioning, then
I just wanted to come back to the... I mean, you've indicated you've been in discussions with other jurisdictions to try and glean the lessons of their experience. Are you able to just elaborate on some of the feedback that's been provided by the other jurisdictions about the role that's played by the health administrative system?
Yeah, it's early days, and there's an established process for the states that have this legislation to continue to meet and to work through. As you are aware, there are various states are at different timeframes depending on when their legislation was passed, and some of them are still working through implementation processes, as we will be. But there is another meeting of that group scheduled for the 21st of December, and they will be ongoing, and it's our intention to continue to work with them. And subject to this legislation passing, what we would probably do is formalise that through our secretary writing to the secretaries or directors general of the other health departments to ensure we've got a formal process established to ensure we can share openly what has been done in those other states and what we can learn from.
Deputy Chair.
Thank you. Well, thank you both for coming on this morning. Can I just, and the Honourable Chair clarified this in his opening statement, that you're not here today representing the government, you're here as representatives from New South Wales Health. That's my understanding. And I presume that you're both here on the request or the direction of the Secretary, Ms Elizabeth Coff. She has asked you to both attend today.
That's correct.
Yeah. Now, with respect then to the bill itself and the provisions of the bill, which is the substance of this inquiry, can I ask what legal analysis has New South Wales Health done into the bill as a black letter law analysis of a proposed piece of legislation which is going to provide for VAD?
We've looked at the legislation in other states and territories and identified that there's a degree of similarity with those laws, but not to any great degree, because this is a matter primarily for Parliament and the judgment of Parliament, and it is a private member's bill, so we would not usually go into in-depth analysis of matters that are not government legislation and generally proposed through the health portfolio.
So, just to be clear, that at this present point in time, so it's the 13th of December 2021, that New South Wales Health has not undertaken a detailed analysis of the second print of the bill, namely the bill that's currently before the Legislative Council. Is that your answer? It's
been reviewed, yes, but not in detail.
So, with respect to the review, can you outline what that has entailed, please?
It is primarily entailed reviewing the bill and looking at its consistency with other states and territories, because as Dr Lyons has indicated, if the bill passes and if Parliament determines to pass the bill, it will be a matter for us to implement it. One of the main issues from my perspective is the time frame available from an operational perspective for the system to implement the bill. And I must say I'm very pleased it's 18 months because, as Dr Lyons has said, it is an enormous task. Most of our implementation of legislation largely relates to the operations of the public health system. This is a statewide remit. We need to engage very closely with representatives of all the medical groups involved and the community. So it is ensuring we have a process in place for implementation, I think, is the key issue.
So with respect to the review that's taken place, that's the language you used, the review, which...
Well, when I say a review, it's a review with a small r.
Okay, well, okay, a review with a small r, and if I understand your evidence correctly, has involved some or complete comparative analysis with the other jurisdictions in Australia that currently have legislation in place, accepting that only two are operational, namely Victoria and WA, so accepting that. Have documents been produced in regards to that analysis?
No, just there's a table that we have when we're comparing them. And the other thing I think it's important to note, the bill...
Without cutting off, on notice, can you provide a copy of that table to the committee?
Yes.
Yeah.
The witness was continuing to answer when you actually just asked for that clarification. I'll provide you the opportunity to provide complete answering that question.
Thank you. What I was going to say is that the bill is still in the House. The bill has not been settled. I'm not aware, but there may be further amendments in the council. So really, a prudent lawyer and a prudent administrator would be waiting for Parliament to make its call before we went into the detail of the analysis. And that analysis will also help us decide how much we can engage with our colleagues in relation to the provisions they have.
Yes, but can I put this to you? And I'm sure you're both aware of this, that New South Wales Health has a body called the Clinical Ethics Advisory Panel. Is that correct?
Yes.
Yes. And at its last meeting, the members of that committee were provided with a briefing with respect to VAT. Is that correct?
I'm not aware of that. I don't attend the meeting.
Dr. Lyons, are you aware of that?
I'm not aware, Deputy Chair, and I don't attend the meeting either, so I wasn't aware that occurred.
Well, on notice, can you please provide to the committee the details of and copies of, if there was, presentations or PowerPoints or notes or whatever, that were utilised by New South Wales Health officials at the briefing of the members of the Clinical Ethics Advisory Panel most recently?
Well, I'm going to take a point of order at this stage.
I'll hear the point of order.
The point of order is essentially these witnesses are not here on behalf of the government. They are here giving evidence with regards to their knowledge of matters. Now what's being asked is not questions going to their knowledge of matters, but essentially for them to embark on an exercise on behalf of this committee of squirreling through government to obtain documents. Now, I suggest, in the context of a private member's bill and in the context in which these witnesses are attending, that's not an appropriate course of action.
May I speak to the point of order?
Yes.
Well, we are here looking at an inquiry into the provisions of the bill.
Yep.
There's no contest about that. We've established the basis upon which the witnesses are here today.
Mm-hmm.
Okay. They're representing New South Wales Health, and in fact they've been directed to attend by the Secretary, or asked to attend on behalf of the Secretary of Health in New South Wales. Now, there was a briefing that took place very recently,
Which did not involve them.
no, but they're the representatives.
Order. I'm going to hear Mr. Donnelly on the point of order. If you could be succinct on the point of order, please, Mr. Donnelly.
Well, listen, please. They are here representing New South Wales Health. There is a body called the Clinical Ethics Advisory Panel that is under the direct remit of New South Wales Health. It operates that entity. Now, I accept that the two witnesses were not present at that meeting. I accept their evidence in that respect. But the matter of the bill was discussed at the meeting. So it is perfectly reasonable, if the witnesses weren't present themselves, to be invited to, on notice, be asked, could they please establish what was covered by New South Wales Health at this meeting, which discussed the provisions of the bill?
Well, if I could just say to that, it's not just simply a question that they were not there. It seems from the evidence they are not members of this committee.
Well,
and indeed, we don't know who prepared this presentation.
I'm prepared to rule on the point of order now. This is an inquiry into the bill and the provisions within the bill. While the witnesses are representing New South Wales Health, I don't believe it's their remit to provide these documents. Mr Donnelly, there's probably some other ways with which this matter could be addressed, but I don't believe it's the requirement of these witnesses to provide those documents in these circumstances. But I invite you to perhaps look at some other methods. I'd ask you to move on to the next set of questions, please.
Okay, well, just returning then to the questions. And with respect to the review work that's been undertaken with a little r, a small r, you are able to provide a copy of the schedule. I think you've said that you're...
It is a table comparing the different jurisdictions.
Thank you very much. Are there any other documents that you have prepared or are aware of that deal with looking at or commenting on the provisions of the bill?
No.
Held by New South Wales Health? There's not. Okay.
Not that I'm aware of.
Not that you're aware of. And Dr. Lyons?
We've had very preliminary discussions, Deputy Chair, around the implementation requirements. What we're turning our mind to is what would be required of us if this legislation were to pass, and what are the things that we would need to put in place, because we're very conscious that there is an extensive amount of work to support the effective implementation of the bill. So we've had a couple of meetings now, and we've started to have conversations with our clinical teams about the sorts of things that we'll need to put in place to ensure that we do this effectively.
Well, so there's no documents that you're aware of?
Not that I'm aware of.
Okay. Well, may I ask this question? And please, Chair, I want to be very clear. I'm not being clever about this, that you're here today representing New South Wales Health. The government doesn't have a position on the bill. With respect to the bill itself and the provisions of the bill, which are the only work that's been done effectively, if I understand the legal representative from New South Wales Health, is a small r review of the provisions by creating a comparative analysis table. What are we able to actually ask you in terms of questions to do with the provisions of the bill? Are we able to ask you specific questions about what provisions of the bill mean, and you take those questions on notice? Or effectively, based on what you've just said, Dr. Lyon, you aren't able to, in fact, ask about specific questions when we may direct you to about the provisions of the bill?
So it's very early days in terms of our responsibilities to it. The bill hasn't yet passed, as my colleague indicated, we would usually wait till legislation is passed and then look at what the legislation entails and what our responsibilities will be for implementation. We've started to consider that, as always we do, because we're quite prudent to ensure we've got implementation delivering effectively. But it's very, very early days, and I think we can provide answers to the best of our knowledge on the basis of where things are at the moment. But it's not an extensive implementation plan at this point in time. We've got some concepts and ideas about the sort of work that will need to be done and the areas that we'll need to focus on, and the relationships we'll need to establish to ensure we can deliver effectively. But it's very early.
And Deputy Chair, I'm just going to raise procedural fairness. This committee determined itself that the scope with which New South Wales Health would appear would be very limited. So it's not that the witnesses are perhaps not prepared to answer, it's that this committee has been very succinct in its questioning because of the provisions we applied to ourselves in relation to the representatives from New South Wales Health, but also the scope with which we are looking, which was the provision of the bill. So I just wanted to make that clear for the procedural fairness issues, so that there's no suggestion that these witnesses are not providing full and frank answers to any questions.
Well, just thank you, Mr. Chair, and just to be absolutely clear, there was obviously no suggestion implicit or explicit about that. And for the record, can it be shown that at the first deliberative meeting with respect to this inquiry, it was myself who raised the issue about government representatives appearing before this inquiry and ventilated an argument or discussion around the table for about 20, 25 minutes, if I recall.
Very lengthy.
No, this is a serious point. That government representatives would come to the inquiry knowing how this matter's been dealt with in other jurisdictions. And my question was, well, that being so, what would we be able to canvass with them in terms of our discussion? So what I guess a little bit confused about then, that with respect to any, which we'll come on to shortly because we've got plenty of time, some questions about the provisions of the bill, that is the bill that's passed the Assembly, now before the Council, obviously not yet passed by the Parliament. What do you see as the questions I can ask? May I ask you questions and you take them on notice?
Well, I'll take a point of order in regards to that. It's not for these witnesses in that sense to be cherry picking. What we have, apart from any resolution that this committee has made, and I'm taking a point of order, what we also have is the fact that there is a procedural fairness resolution which limits what you can ask public servants. I think the other problem in this is that these are members, in a broader sense, these are public servants with a bill that is before the House.
Right.
Now, if one is going to talk about, in a sense, the comity of proceedings, then inviting public servants to be embarking on essentially a discussion of a matter which is before Parliament and to have them opining on provisions of a bill, I think is highly problematic indeed and unfair on these witnesses.
Well, that's a point of order, so I'm entitled to respond to the point of order.
I will listen to the response.
I think what I put to the representatives here, and let's be clear, they are here under the direct instruction of the Health Secretary of the State of New South Wales to represent New South Wales Health. So we're talking about people at the most, dare I say, elite level of New South Wales here at the table. I proposed the placing of questions on notice. In other words, I could raise a question with you with respect to the matter of the provision of the bill. And please, I think that is a bit unfair to cast my suggestion that, you know, there'd be questions and expecting you to opine on the run. That was never my intention.
And that's not what I'm putting.
I'll ask you to...
I haven't finished. I haven't finished my point of order.
I'd ask you not to talk over me. I was just going to bring you back to speaking to Mr. Khan's point of order.
With the greatest respect, that's exactly what I was doing.
Thank you, Deputy Chair.
Right. So my question is, am I able to...
We're addressing Mr. Khan's point of order.
Yes, that's right. So the position is that Mr. Khan is saying, if I understand him, properly understood, that I cannot actually pose questions either to provide here before us today or on notice questions about the provisions of the bill. That's if I understand what is being said. Now, if that's the ruling, what can we ask questions about? This is an inquiry into the provisions of the bill. And this, not the provisions of the Act.
I'm prepared to rule on the point of...
the provisions of the bill.
I'm prepared to rule on the point of order from Mr. Khan first. I'm going to uphold Mr. Khan's point of order in that this committee is respondent to the procedural fairness resolution of the House, and that does limit the questions that we are able to pose to public servants. I'll also note that the committee itself resolved to restrict the questioning to the terms of reference.
Correct.
And also that the witnesses were to be informed that they were, that this isn't a government bill and the government doesn't have a position.
Correct.
Now, the witnesses are appearing on invitation by the committee through me.
Not representing the government.
Correct, not representing the government, representing New South Wales Health, and they are here to provide responses which may be along the lines of, if this provision in the bill is to be enacted, what are the mechanisms that may be brought through perhaps a process within New South Wales Health, but their opinions and their ability to answer questions on a bill that is before the House and still yet to actually come out of the Legislative Council is, as Mr Khan says, limited. So if we adopt those positions, then that's the parameters with which we can ask questions of the witnesses now. Does that help, Mr Donnelly?
Well, if I understand you correctly, what you're essentially saying, Chair, and sorry, this is not the way to behave, but having a discussion just this way, sideways with the Chair. But effectively, what you're saying is, if Mr Khan's Mr Khan's proposition stands, I'm effectively extinguished in the main, being able to raise questions to either be answered or taken on notice from the representatives, the most senior representatives from New South Wales Health, who are here today on the instructions of the Secretary of New South Wales to deal with what is the terms of reference as this inquiry into the provisions of the bill. My ability to raise questions in regard to the provisions of the bill with these representatives is effectively extinguished.
Well, could I just comment? Look, one of the problems with a private member's bill is, and one of the problems, and let's be frank about this, with abortion reform was that a large part of the criticism is that the minister had jumped into the fray and was expressing a position with regards to various components of that. This bill is entirely different. This is a bill where there's been no expression by a minister or the government as to what is the position.
Well,
just hold on. Individual ministers have expressed views in debate in the House. Right. But the government, the executive, has not adopted a position. What is therefore being sought is, with regards to particular provisions of the bill, for these witnesses or other lawyers somewhere in health to jump into the fray and give expressions as to the interpretation of provisions of the bill. That is precisely contrary to the position of the government does not have a position. You can't use the functionaries of government for the purposes of commenting on something that is before the House as a private member's bill. That is the real problem.
This is the position that I'm going to take.
Sorry,
can I address this?
All I want to say is...
No, I'm actually making...
my position.
No, he's not. And I'm about to comment on that. So if you both allow me, please, and I'm very much trying to keep the temperature low in this room today. My position is that any member of this committee can ask any question they like. It is then up to any other member of the committee or myself to either raise a point of order or myself to rule the question out of order. So, Mr Donnelly, you are entitled to ask any question that you see fit. It's up to any other member or myself to either rule a point of order, to seek a point of order, or for myself to rule the question out of order. I invite you to ask your questions. I just am foreshadowing that if they are outside the parameters with which this committee itself has set, then that is potentially the outcome that will occur. And I'll give you the call to ask your further questions, and I will pass to Mr D'Adam, who has indicated that he has questions.
Well, perhaps pass on Mr D'Adam, we can circle back. So.
Okay, Mr D'Adam, you have the call.
Okay, I wanted to come back to the question around capacity assessments. Perhaps you might be able to advise the committee, are there other contexts aside from voluntary assisted dying where clinicians in the health system are likely to make capacity assessments?
I'll go with the legal issue first. Yes, across the board all the time in relation to if you look at the New South Wales Health Consent Manual, which is a comprehensive document which deals with the taking of consent for medical treatment and medical care, a critical element of that is obtaining consent, and it can occur, the presumption, as I believe you heard from the Bar Association and others in earlier evidence, is that a person has capacity, but it is a matter for clinicians on a daily basis when they're dealing with patients to make those assessments. And obviously, one of the issues with the test of capacity is that the more complex and impactful the treatment is, the greater the assessment about the person's full understanding of all those issues. So it is a daily matter for clinicians, and Dr. Lyons might be able to talk on the practical level.
Yeah, I mean, on a practical level, this is what clinicians do all of the time, because they're in constant dialogue with the patient about decision-making, decisions to undertake diagnostic tests that might have potential adverse consequences, decisions around what the diagnosis is and what treatment options are available to the person, and their choices around what treatment they would like to receive, details around decisions on medications and what medications might be offered. All of those things are done on a regular basis by clinicians all the time. It's part of regular clinical practice.
Is there specific guidance that health provides in relation to making those kind of capacity assessments?
I'd have to defer on if there's sort of clinical protocols, but as I said, the New South Wales Consent Manual, which I think was only published 2 years or 1 year ago, sorry, COVID time, is detailed of all aspects of consent, and it looks at different situations with consent. The fact that simply because someone has a disability doesn't mean they don't have capacity to consent. But I'm
happy for you to take it on notice, and perhaps
look, the document in question is publicly available on our website too, so it would be useful. It's a very big document, and there's quite a bit dealing with capacity. Yep.
Appreciate it. And also, earlier, Dr. Lyons, you referred to the guidance that's been provided around elder abuse. If perhaps you could also provide that.
Certainly.
Thank you very much. I'll just check with Mr. Farlow or Mr. Martin if either of you have got some questions. Mr. Martin.
Yes, thank you, Chair. Just following off that line of questioning from Mr. D'Adam, particularly in regards to elder abuse, it was mentioned in the opening statement. Would there be guidelines provided or established and provided rather for doctors to be able to use when assessing coercion? We heard from a doctor last week in regards to this, that they had concerns in relation to assessing coercion.
Yeah, so there is not a detailed comment around coercion in the elder abuse guidelines, but one of the things that we are conscious of is, given the wording of this bill, our need to review current guidance to ensure that we are providing appropriate support, education, training and capability assessment for our clinicians around these very areas, because this has been emphasised in this proposed bill, that it's very important. It's not just the skill and capability, but my reading of the bill is it's actually around process as well. And there are processes that have been built into the bill to provide additional protections, but it's important that we give our individual practitioners as much guidance, support and direction around those areas and capability as we possibly can. So that will be one area of review.
Okay. Thank you.
Sorry, could I just ask a question that follows up on that?
Yes, Mr. Khan, you got the call.
So if you go to the manual on consent, I think that's what it's called, isn't it? At 4.3, it includes such provisions as, it's a very lengthy part, but 4 core criteria must be met. The patient giving consent must have capacity. The consent must be freely given. The consent must be sufficiently specific to the procedure or treatment proposed, and the consent must be informed. That's the style of thing that's provided in the manual.
That's correct.
Yeah. And it is a very lengthy manual, it seems. It's
very comprehensive.
But very easy to read, having used it myself recently. I think you'll find too there's a detailed description of each of those core components of what consent means in the manual as well.
And indeed, you talked about various medical procedures. The nature of consent, for instance, goes to issues, for instance, of pregnancy and the termination thereof. In a sense, on some at this table would say matters of life and death are already dealt with in some detail in the manual.
Correct.
Mr Donnelly.
Except the position is not that, in fact, the document referred to is a document which is internal to New South Wales Health and applies to the organisation known as New South Wales Health, isn't it?
Yes.
That's correct.
Yes. So, with respect to those provisions that have been just referred to and dare I say, elucidated on by referring to them, those provisions do not apply to, for example, GPs that may be working around the state. Is that correct?
Not directly. However, in my experience, what occurs...
No.
Strict question.
No.
I'll answer the question.
Order. I will allow Dr Lyons to complete his answer.
Not directly, but in experience that I've had working in the system now for 35 years is the guidance that New South Wales Health provides to clinicians working in the New South Wales health system is actually very important in the context of the delivery of care in other settings. And the reason for that is that we are seen often, and this is applied very strongly during the last 18 months, 2 years with responding to the COVID pandemic, that the guidance, advice, direction that we provide to our clinicians is seen as a very important signal to other clinicians about the activities, the practices, the approach that they should take in delivering care in the settings that they're delivering care in as well. In fact, they look to us for that guidance and support. The other aspect, of course, is that in common law, in terms of decisions around if a clinician were subject to some concerns around the practice and their approach, the policies and guidance that apply to practitioners generally would be considered to be the sorts of things that would be taken into account. So it is a very strong, it has no, there is no mandatory requirement, but it has very strong influence over the practice of clinicians outside of the New South Wales health system.
Yeah, I think that's the distinction. It is mandatory within New South Wales Health, but highly influential guide for the broader system.
No,
Yep.
I did understand that. It's well known in the, dare I say, the health ecology of New South Wales, what you've just said. Can I just go back to the point you made in your opening statement, Dr Lyons, about the strengthening of the guidelines? And you'll recall in your opening statement that in light of this legislation passing the Parliament, there would be strengthening of the guidelines. That's what you said. Can you explain what that means?
So what we'll do...
Sorry, just explain which guidelines we're talking about. If we're talking about the same ones or different ones, just be clear about that.
So the guidelines that exist, and they've been mentioned, I think I've made reference to the elder abuse, we've made mention to the consent to treatment. These guidance...
Sorry, order. The question's been asked. Can we allow Dr Lyons to complete his answer? If he then seeks some further elucidation, then Dr Lyons can provide that. But in the first instance, they need to be able to finish their answers first.
Well, may I take a point of order?
Yes, I'll hear the point of order.
The language guidelines was used in the opening statement. Mm-hmm. All I'm simply wanting to clarify, because I think it would just make the whole thing be much more clearly understood, is there a single set of guidelines that you're referring to? In other words, guidelines, and we just mentioned one of them in my previous line of question, or are there a set of guidelines? That's what I'm trying to understand.
The issue that I've got is that Dr Lyons was no more than about 10 words into his answer before he was interrupted. He may have been coming to that. The way that we treat witnesses when they're here is that we ask a question, they provide a response. If you then seek further information, you're allowed to seek an elucidation. Dr Lyons, if you could provide a response, I'd appreciate it.
So I might ask my colleague to respond to the guidance and the sets of guidance.
Just some context, it might be very helpful to give you some context, is that across New South Wales Health there is a comprehensive set of what we would call policy directives, which are mandatory, and guidelines which are supportive of those. What I would suggest we would be doing would be, and I think Dr. Lyons was speaking generally in relation to our guidelines on various issues with the two examples of the elder abuse policy and consent manual. We would be looking at all our current policy directives and guidelines to identify, do they overlap with our matters dealt with by the bill, to make an assessment of them and see if they need to be revised. Plus, in addition, there are a series of matters that the bill requires the Health Secretary to produce guidelines about. So, for example, the consent manual may well have a new part on all the requirements of consent required by the bill, or we may decide to do something separate for that given the specialist nature. Then there needs to be consideration of how then it applies broadly beyond New South Wales Health. So that would be the kind of process. So that's more of a context that hopefully is helpful.
Do got the call.
Thank you. Well, that was the next part, and thank you for that.
Yep.
That's been very helpful. So we have the policy, and forgive me, we all understand this, but I just want to be very clear, you're representing New South Wales Health here. So just want the record to be very unambiguous about this, that there are the policy directives which sit at this particular level. I presume above that is the statute law and the common law of New South Wales. Is that how you would sort of
Yes.
place this in a hierarchy? So you've got the policy directives. What is the actual legal standing, may I ask, of policy directives?
Policy directives are mandatory within the public health system. The legal source is that all entities in the public health system are subject to a subsidy from the Minister for Health under the Health Services Act. That subsidy can impose conditions on the subsidy. It is a condition of subsidy that all entities in New South Wales Health comply with those policy directives and the policy guidance system. We have a number of other entities that are entities of the Health Secretary, and there's also a directive from the Health Secretary that those entities comply with the policy directives.
Thank you very much. That's very helpful. And then beneath them, as described by Dr. Lyons, are guidelines. Guidelines broadly understood, whereas guidelines covering different domains that are believed to need guidelines. I presume that's why they're created in the first instance. What is the legal standing of guidelines?
The guidelines form part of the policy directive system as well, but I think it's important to say there are actual formal guidelines. If you look on our website, all of those policy directives and guidelines are freely available, and you'll see some of them are called PD 2000 and PD Policy Directive 2011-004, and some of them are formal guidelines, GL with the year and the number. But then so they're all applicable across the New South Wales health system, and each of them will tell you on the front exactly the range and extent of coverage. But then there are other clinical protocols which may be internal or guidance documents or developed by statewide clinical groups, which perhaps Dr. Lyons might be able to talk to in more detail.
Yeah, so that they're then supporting those guidances. There'll be clinical pathways, models of care. These are guidance that is developed by clinicians and clinical teams to support the delivery of care in a consistent and evidence-based manner. So they're usually developed as a result of the policy directive and the guidance that exists. Then that flows down into what does that mean for this group of patients, how we provide care is directed by those things, and then there's a development of a more explicit clinical guidance around that particular patient or patient group, and that's developed by the clinicians and clinical teams.
Mr. Martin, do you have a further question?
Look, I'm happy to take one. It's a bit of a different line of questioning. Thank you very much for your attendance here today. Just interested in terms of the voluntary assisted dying substances, and I don't know if you have any knowledge of these, but how many different substances would there be that would fall under that category from your knowledge?
It's not something that I have direct knowledge of, so I would have to take that on notice and provide the committee with that advice.
Thank you very much. There was also a suggestion the other day that such a substance be approved, an amendment to the bill could be that such a substance be approved by the TGA to provide an additional safeguard. Do you see any impediment with that, with such an amendment, or any impracticality there?
Well, let me take it on notice, but my general comments would be that it's almost invariable that medications that we deliver in the healthcare system have been through that process. The only situation where they've not been through a formal TGA process is where they're subject of clinical trials and are currently under research arrangements, and there are heavy safeguards around their use in that context as well.
And just on that point as well, can you take on notice as well whether what voluntary assisted dying substances have been approved by the TGA?
Certainly.
Thank you very much.
Looking around the room, Deputy Chair, you can continue your questioning.
Thank you, Chair. So just returning to the line of questioning about the framework we were discussing before we moved to other questions. So we have the guidelines. I think they've been covered quite thoroughly, so thank you for that. I think in the evidence from you, Dr. Lyons, is that there's going to be work done. This is with the implementation, I presume, in the 18-month window. That there will be work done to strengthen the guidelines. I think they were the words that you used. Is that to also be meant to understand to strengthen the policy as well? In other words, strengthen all of those matters that fall within that remit of what New South Wales actually basically prepares for itself and uses as its documents, be they called policies or guidelines?
So I think once the legislation is passed, it would then be that we would assess the application of that bill and what it means in the context of all of our policies, procedures, practices, education and training material, the systems that we need to set up to support its effective delivery. And we will make that assessment, and we've started to already think about the sorts of things we'll need to do and what processes we'll need to establish to ensure that we deliver on all of those. So we're already thinking about, establishing a steering group for the implementation of the bill and its implications in New South Wales, and then a subset of working groups that would need to be established. We're thinking about who needs to be on the overarching steering group, what their relationships need to be, the sorts of groups that we'll need to involve. We're also thinking about the work program that would fall underneath that to ensure we could effectively deliver. So that preparation work is already being considered. We've already had discussions with a number of our senior clinicians about the intersection with other clinical services and clinical care and the need to assess in those contexts what advice, guidance and support we might need to provide, and in particular the intersection with palliative care. That's discussion we've already started to have, and the criticality of our palliative care services being appropriately supported to enable this legislation to be applied in a way which is about promoting choice, not being an either or, and that our services are supported in assisting people to make appropriate decisions around those choices.
Thank you for that, and it's a matter I'll come to shortly. But before I do so, just to be clear, this was touched on in an answer to your question, or answer to my question, and I'm not cavilling with your answer at all, about the persuasive nature. I'll use that phrase, that's not your words, my words. The persuasive nature or the persuasive value of policies, guidelines, protocols of New South Wales Health to, I'll sort of use the phrase, the health ecology of the whole of New South Wales, if we use that word. That is true. I think there's not anyone that contests that. Well, certainly I don't. But my question is, though, once one's gone through this process of doing all of this work with respect to all that you've described with respect to these matters of the guidelines, or policies, guidelines and protocols, and they're all put into place. They're there. The scheme is operational, so we're looking down the track here. That with respect, though, to being bound, strictly bound, legally bound by the policy, by the guidelines and the clinical protocols, it is the fact, though, that it's only employees of New South Wales Health which are strictly bound by those. Is that not the case? Setting aside what you've said about the persuasive influence, as a matter of law, you cannot bind a general practitioner who might be operating out at, dare I say, Timbuktu in regional New South Wales and argue, and if you are arguing this, please say this before us, that your policy directives, your guidelines and clinical protocols apply to that general practitioner.
So you want to make comment first, and I'll add.
I think you've got to look at it in the context that the bill itself identifies a large range of matters that the Secretary has to produce guidelines under to enforce the legislation that will be applicable and enforceable across public and private sector. The other issue I would say...
Guidelines will be enforceable, will they?
Sorry?
Those guidelines will be enforceable.
Well, that's a matter for the terms of the bill. These are requirements. So that's how the bill would work. You're saying they're required. I'd have to double check. You would know the bill better than I would, what it says about breaching any guidelines. I'm not sure what it says. But beside that is you have a piece of legislation that we have other pieces of legislation. For example, the Poisons and Therapeutic Goods Act regulates the use of medicines in New South Wales. There are lots of guidance provided by our pharmaceutical services as to this is what you need to do to comply. So to that extent, it's directing people, and again, part of that review would be to assess outside the specific guidelines required in the bill, is there other information which is both educative, communicative and advisory about people, what they need to consider when they are, if they're going to be in compliance with the bill or the Act, if it is made. Yep.
Just to seek some clarity, should the bill pass this Parliament, the requirement on a doctor, whether they be part of the New South Wales health system or in private practice within New South Wales, the provisions of the legislation by that stage would cover both of them. The guidelines that are produced apply to New South Wales Health, guidelines and policies would apply to New South Wales Health doctors. However, the guidelines and policies are based off the legislation, and the legislation covers both sets of doctors. Is that correct? Is that effectively my read on it? So
there are provisions from my recollection in the bill that require the Health Secretary to issue guidelines on particular things. Yes. The source of power...
Clause 181.
Yeah.
Oh, well, there we go.
The source of power is the legislation, so that will apply across the board.
So regardless of whether the guideline is, I guess, enforced by New South Wales Health, which is going to the question that the Deputy Chair was asking previously, regardless of whether the guideline or policy is enforced by New South Wales Health, the legislation that where the genesis of those guidelines and policies was from would still be the overarching factor for both sets of private and New South Wales Health doctors. Is that correct?
Where those guidelines are required under the Act. And in relation to enforcement, my recollection as well is there are references that interact the voluntary assisting dying legislation with the existing national registration and accreditation system, and delineating certain things to be matters capable of being dealt with as professional misconduct on satisfactory professional conduct, and other things. So, and there's a whole regime around that with a range of protections, penalties and activities if there is breaches, of what is considered unsatisfactory professional conduct or professional misconduct.
Thank you, Deputy Chair. You have the call. Oh, sorry.
So I was just going to add to that, and so that's that interpretation is my interpretation as well, and that what then flows in practice usually is that the groups that support those doctors who are working in New South Wales in different ways will often come to us to seek the guidance and support that they will then adopt from either their colleges, their organisations, to ensure that they're providing the appropriate support for their clinicians as well, to ensure they're operating consistently with what the legislation requires. And so we're actually anticipating that that's going to be the case, and starting to think about in the implementation approach, who are the groups that we need to start to work with to ensure that that happens almost seamlessly from the outset that those things are being supported, that people are provided the appropriate guidance and advice, and that it is flowing right through to the practitioners who work inside New South Wales Health, but also in other settings outside of.
And can I also add, part of that process would also engage the current health regulators in New South Wales, which would be the Healthcare Complaints Commission and the various health professional councils who would be looking at the conduct of the clinicians.
So it's effectively easier to plagiarise New South Wales Health's guidelines and policies.
Well, we're very influential in that regard, and I think people look to what we're doing in the New South Wales health system because it covers so many health practitioners in so many different settings. So, I think what you can see from just what we've conveyed so far is the extent of work that's going to be involved, consultation required, and the 18 months is absolutely, from our point of view, we're probably going to use every day of it because it's going to be a lot of work involved in ensuring we've got all this in place.
Just on that point then, is 18 months, the provision of 18 months suitable, in your opinion, to what you would envisage the amount of work to be?
I believe so, and especially given that there are other states that are already well advanced. Some already have commenced their own legislation, others are well advanced in the preparation, and so we're very much of a view that we should be looking to what they have done and learning from it. And the other thing we're very conscious of is that as a nation, our clinicians work across the country, and we want to try and ensure that there is as much consistency in the way we are applying the legislation. That is New South Wales legislation notwithstanding, but thinking about the context of the fact that we want to get as much consistency around how that's undertaken as we possibly can.
Now, I'm cognizant the Deputy Chair did have the call previously. I know Mr Diadam obviously wants to ask something else, but we'll come. Mr Diadam, you can ask a question, then I'll come back to the Deputy Chair.
Question, which is, I'm still, in spite of that exchange, unclear about the status of the guidelines, and subject to this question being in order, I would ask on notice that you could provide to the committee your understanding, based on the second print of the bill, of the mechanism for enforcing guidelines under this bill. What would be the mechanism for enforcing based on the second print? I'm happy, if that's in order, then I'm happy for that question to stand, but if...
I'm looking to see if anybody's going to raise a point of order on that, but I think it's appropriate, given that we are discussing the bill and we've actually sent the second print to everybody so that we can ask questions on that.
Could I say, I don't think that's the basis, but clearly because New South Wales Health is developing the guidelines, I think we need to know how those guidelines play in this space. Otherwise, I would take the objection that I take before, but it does seem to me...
It seems essential, if we're going to understand the implications of the bill, we actually need to know.
The question's in order. I'll just confirm. Are the witnesses happy to take the question on notice?
Yes.
Thank you. Is there anything else you had, Mr Diadam? Mr Durnelly.
Thank you. So, might sound trite to say, but that's exactly where I was getting to before I was interrupted. With respect to the guidelines, we were talking about the development of guidelines that is going to be done in the context of the 18 months. I was talking about that at the very start of my back and forth with you. I'm well aware of the provisions within the bill that deal with guidelines. Thank you very much. But we're dealing with, as I understand it, potentially two sets of guidelines here, if I'm not misunderstanding, and that is that we have these, dare I say, existing New South Wales health guidelines that deal with matters like consent and elder abuse, and there could be a number of others as well, or at least some others, which are directly relevant to this legislation that's before us, this, if it becomes an act. I'm sure you're thinking about these matters. And it's in the context of thinking about these matters that's why you've actually turned your mind already to how that is, the guidelines that deal with elder abuse, may need to be, my words, not yours, toughened up or made more clear. Matters of consent may need to be refined somewhat, my words, not yours. So that process is being done. And their guidelines, if I understand it, guidelines that would become New South Wales Health guidelines, that in your evidence, if I've understand you correctly, would in fact flow out beyond New South Wales Health to the medical health community in New South Wales to be persuasive, influential in the thinking of medical practitioners in the state. Is that correct?
That's correct.
Yes. So they're those guidelines. So that's effectively the enunciation and refinement of existing guidelines, but you've seen that they're apposite and relevant to the legislation and therefore work to be done to spread them out in a refined fashion. Now, there are also the provisions in the Act with respect to creation of guidelines and the relevant guidelines that are issued by the Secretary. Now, those guidelines could be on other issues, couldn't they, other than these ones? Is that correct? Well, let me put it another way.
They could.
Yes.
They could.
So what we're talking about here, and I'm just trying to make this clear, this is not sort of some ambushing exercise, I'm just trying to understand this clearly. The proposition as put is that existing guidelines will be deemed to probably have some relevancy with respect to the operationalisation of this legislation, and therefore in advance of that you're thinking about how they, and how not just they, how we can get them out there, so to speak, beyond New South Wales Health, beyond what is currently the position at the moment, okay? So that's what you're proposing. And then there's the second issue of guidelines that may be issued by the Secretary. Now, with respect to those guidelines that may be different from these particular ones that are already existing in a form within New South Wales Health, do you have an opinion or have you turned your mind to what those guidelines might look like?
Not at this point in time. I haven't.
No, I think there needs to be an assessment. The bill is very detailed and very clear on a large number of issues. Very similar, as I said, to some of our other legislation. So the bill will largely, in many ways, or the Act, if it's passed, will speak for itself, and part of our assessment process and engagement with the clinicians both in the public and private sector needs to be where there should be some clarity or additional guidance consistent with the intent of Parliament. But until we look at that, it's quite difficult.
But can we just allow the witness to complete her answer?
Yeah, sorry, until we've done that process and there's a final bill, it's really quite difficult to say how far they will go.
So just to be clear though, just so I understand your evidence, that with respect to the development of these guidelines, prospectively, it's not the case that New South Wales Health, as the primary principal health body in New South Wales, would itself, for example, take legal advice and make a determination about whether or not its own policies, guidelines perhaps need refinement, but that it's with consultation with the sector at large. That's how you create these policies or guidelines. Is that what you're saying?
Yes.
May I ask you then, where does legal advice come into whether or not these guidelines, the policies, the working procedures meet the requirements of the law?
Well, I'm not quite sure, we've gone from talking about whether we need guidelines to whether the guidelines are consistent with the law. Most of the critical policies, including the consent policy and other policies that are developed by New South Wales Health, are reviewed by my team in the legal unit. Okay, so that's in effect, and my words not yours, but in effect a serious check on the validity. Oh, exactly, exactly. No, sorry.
We're talking over each other again.
Yeah. So no, I'm just trying to clarify this because clearly the law operates as what's binding, whether people like it or not, and it is very important, presumably, and without question, that anything that operates under that domain of a policy or a guideline or a working procedure is obviously in complete sync with the law as it is. Yeah.
And the legal advice would also say you don't need guidelines because the law is clear.
So could you repeat that again?
Legal advice would also look on the fact if there's even any need for guidelines, because the law is quite clear in the area.
Right. Well, can you explain why New South Wales has policies, guidelines and procedures?
Because there's many areas where there's no legal... I think this is a bit of a circular question.
Well,
what
no,
I'm
it's not
saying
actually.
is when
Order.
we've been talking about assessing a new piece of legislation, which is very detailed and very clear on many aspects, so there is no need for guidance. If we are talking, for example, about many aspects of our policies, the concepts of consent are very high level. We've already discussed them. The policies and guidance provide detail about how to operationalise them.
Okay, well, can I just change my line of questioning to something slightly different? With respect, but directly relevant because it's been raised already by yourselves, the matter of palliative care and its importance and significance, and specifically in the bill. Now, can I ask a question about two provisions in the bill of the witnesses? Just draw it to their attention.
Absolutely.
Okay. So you would be aware that in the principles clause of the bill, for 1D, there's reference to palliative care. May I just draw that to your attention for 1D? And if you don't mind, I'll just read the leading sentence. A person exercising a power or performing a function under this Act must have regard to the following principles, and lists them down. And then we get to D that says, a person approaching the end of life should be provided with high quality care and treatment, including palliative care and treatment to minimise the person's suffering and maximise the person's quality of life. So that's a clear principle enunciated in the Act. Can I, or Bill rather, through that, can I just take you to page number 4, clause 10. And 10 as headed healthcare worker not to initiate discussion about voluntary assisted dying, but I'd like to, if I could please, take you to 10.2 and 10.2c. Well, with 10.2, you can read the lead-in paragraph. Subsection 1 does not apply, blah, blah, blah. But then it leads down to also informs the person about the following. And then C says, the palliative care and treatment options available to the person. Now, if I can just go back to the clause 4 and the question of the principles. Can you explain to me, if you're able to do so, as the legal representative here, what is the importance or significance or value of principles in an Act of Parliament?
Well, generally you have principles more broadly about the purpose of the Act. For example, the Public Health Act, which has been something on everyone's minds for some time, has a set of principles about what its overall purpose is, and that helps in interpretation. This principle is actually directed at the person performing a function under this Act, and it says they must have regard to those principles. So that's what it's telling the person performing a function under that Act that they have to do.
Now, will there be employees of New South Wales Health? And sorry, I'm not being clever here, but I'm asking it just for the purpose of clarity. They're presumably, if this passes and becomes operationalised, there'll be employees of New South Wales Health, i.e. medical doctors, who will obviously be operating under the provisions of this legislation, wouldn't there?
Yes.
And those individuals would be exercising power, performing functions under the legislation. Would that be correct?
It's a power or a function, yes.
Yeah, no, that's fine.
Yep.
So with respect to those doctors, and let's just take a doctor anywhere in New South Wales Health, who's working as an employee of New South Wales, anywhere around the state, that they will need to have regard for that principle, won't they? The principle specifically for 1D, is that correct?
That's what the legislation as drafted says.
So, can you explain then the issue of the real situation of unavailability of palliative care to certain citizens of this state and what that means with respect to a doctor being able to fulfil obligations pursuant to that provision?
So I'll make a couple of comments. I mean, the commitment to end-of-life care in New South Wales is strong. The New South Wales End-of-Life and Palliative Care Framework 2019-2024 emphasises that all individuals should have access to the best possible end-of-life and palliative care no matter where they live, their condition, age or who they are, and that's a current framework that is in place. In addition to that, New South Wales Health has the Clinical Principles for End-of-Life and Palliative Care Guideline, one of the guidelines that were mentioned in previous evidence this morning, GL 2021-16, which sets expectations for clinical services from the screening and identification right through to grief and bereavement, and has a whole series of priorities. Now we accept that there is a growing need for palliative care as we have an ageing population, and as a result of that, there's been significant investments in palliative care over the last few years. I think back in 2017-18, we had around $200 million per annum spent in New South Wales Health on palliative care, and the government's invested significantly more over a number of the last budget cycles. So 2017-18 budget announced an additional $100 million over 4 years. The 2019-20 budget allocated another $45 million over 4 years on top of that. The 2020-21 budget allocated an additional $56 million over 4 years on top of those further investments. And again, in the 2021-22 budget, there was a further $82.8 million over 4 years announced. So there's been, over that period of time, probably another $100 million per annum. So it's been a 50% increase in the budget and the funding that's been provided for palliative care services. And those investments are flowing out into the system now. We're very conscious of the fact that there are major challenges in delivering those services, particularly as you move further away from metropolitan centres, and the issues around workforce availability. And you and I have been listening to the testimony in the Rural and Regional Health Inquiry, some of the challenges of how we ensure that people have access to the best possible care in those communities. And we've invested additional palliative care specialists, additional community services, palliative care services. But the challenge remains in ensuring that everybody everywhere gets access to that care when they need it. And so we're continuing to think about what further investments we need to make. But not only that, skilling up staff to ensure that we've got people with the capability available in those sites. So scholarships for further education and training for nurses, allied health, GPs who are actually working in those centres already. And we're assessing the benefits of linking our specialist palliative care services with the services that are on the ground in those rural and regional communities. And you heard, I'm sure, about virtual care and some of the opportunities that creates. And I was very fortunate to actually hear firsthand a great story from a person who gave evidence to us at, wasn't evidence, but it was a story at one of our bilateral rural and regional committee meetings in Dubbo about their experience with their wife who died of a terminal illness in a rural centre and was provided the backup of telehealth through that terminal phase, and how much benefit it was to actually have access to that specialist advice over the telehealth to enable care to be provided with support in situ. And so they're the sorts of things that we need to continue to build on and ensure that we're providing optimal care to our patients and communities no matter where they are in the state, and that we use the technology and the linkages that we have to support that care being provided optimally. So recognise the challenges still exist, but we are committed through the guidance, the directions that I've outlined there, and also the investments that are being made to further improve those services.
So I won't read D again, but it says should be provided with high quality palliative care and treatment, including palliative care and treatment to minimise the person's suffering and maximise the person's quality of life. The truth of the matter is that there are people today, tomorrow, next week, next month, probably even next year, potentially, dying in circumstances where they do not have access to not even, and not the question of high quality care, not even the most basic of palliative care, because there just are not GPs in their local town. And that was evidence we found all around the state. You would dole that, wouldn't you, Dr. Lyons?
I've heard the evidence at the inquiry, yes.
So there's not doctors in the town to be able to even prescribe for the basic provision of a syringe driver and pump to associate with pain relief. That's been evidence, hasn't it?
Yeah, so just on that evidence, yes, that evidence has been given, but there are mechanisms for people to access some of those treatments in those facilities through the arrangements that the districts have made, and we've got health nurse practitioners who are given prescribing rights. We're looking at expanding the range of those positions in rural settings to enable people to be able to prescribe if there's no doctor available. And we're also providing linkages through virtual care for provision of medications through an assessment that's being done virtually, and appropriate supports available for the health practitioners on the ground to administer medications in certain situations. So the evidence has been given, yes, but we are acting very strongly and actively to address the issues around access and ensure we can provide the best possible care wherever people are being provided that care.
I guess we'll agree to disagree on that, because as far as I was concerned, the evidence was manifest around the state that the care is just not provided. Anyway, moving on, can I just ask you this question? In terms of the costs to New South Wales Health to implement the VAD scheme in the state, what work's been done in terms of doing some basic calculations in regards to that, the implementation of the scheme?
So we haven't done detailed analysis of the cost of doing that. Our core business is actually ensuring that we deliver on any legislation that's passed by government, any policy direction set by government. That's our task, is to implement effectively and support that being provided. So we see those responsibilities as part of our core remit. And the resources we're provided to do so in the Ministry of Health will be applied to ensure that we're delivering on this effectively as well.
And will it actually do work to establish the cost associated with the implementation of voluntary assisted dying?
We don't usually go through looking at costing exercises for every piece of legislation or policy that we're required to implement. If there are additional requirements in place, so one of the things that this bill requires is the establishment of the Voluntary Assisted Dying Board, and that will need to be provided some appropriate resourcing and support. We would, I suspect, cost that up to ensure that we're provided in a budget ongoing support for that board. So those sorts of things will be costed up in due course, but we don't usually go through and calculate every component of implementation cost.
Just before, sorry, Deputy Chair, just before you continue, we've only got a handful of minutes left, so I just wanted to go around the committee and just see if there are any other members who might have some questions before I pass to the Deputy Chair for a final set of questions.
Thank you. So is it your evidence, Dr. Lyon, that, and once again, take this notice if you need to do so, that the board itself provided for in the legislation may well be, my words, may well be something that may be costed as a cost that would need to be managed by New South Wales Health with this legislation in place. But with respect to everything else other than the board, that in effect is, and once again my words, absorbed within the cost of running New South Wales Health as the sort of primary health entity in the state. Is that your evidence?
That's the starting position, and if there are, of course, during the course of implementation, there are costs where we would argue additional resources are required, there is a process internally for additional support to be accessed within the budget we have. So I think
the health budget,
yeah, within the Ministry of Health budget, and the budgets that are allocated the respective divisions and branches. So we would go through that process, but of course where an entity is to be established which has a series of functions, we would ensure that there is appropriate resourcing for that entity to be able to carry out its functions effectively.
So would it be the case then, based on the evidence you've just given, that on an annual basis, so on a rolling basis, annual basis, that it won't be possible to be able to establish what the cost is of operating voluntary assisted dying as a procedure in the state?
No more or less than any other aspect of the things that we're responsible for delivering on.
So we might be able to see what the board costs as perhaps a figure if we dig down, but essentially it will be absorbed within the overall operational running costs of New South Wales Health.
That's correct.
Can I just return then to the question that we have canvassed a little bit this morning about the question of consent, because it strikes me if nothing's nothing's more important than we can all agree that consent to this is clearly unequivocally, front and centre of our thinking. That with respect to the consent provisions, with respect to the legislation, and legislation being the bill, so there's 6 dealing with the issue of decision-making capacity, clause 6. Concomitant to that, you've got eligibility criteria in clause 16. And there are some others, but they're probably the 2 key ones. From the position of New South Wales Health, and not putting words in your mouth, but just going back to the evidence you've given earlier on today, that New South Wales Health has not done its own examination of those provisions in the bill that deal with consent and formed a view about whether they are robust. Is that the case?
I haven't reviewed them in detail, no.
Well, may I ask you, your earlier evidence was, as I understand it, that effectively, and once again I'm not being smart here, that primarily your review work has been the comparative analysis with other states and other jurisdictions. That's what I took from your evidence earlier today. But are you saying you've done, and once again I'm not playing here, but you've done some review on this issue of the consent provisions? Or what might I say, the provisions in the bill that deal with consent? You've done some work on that?
No.
So have you reviewed it?
Take the point of order.
Yeah.
Same basis as the because ultimately the government is neutral on the bill, so they can't take a position in terms of whether the bill's provisions are robust enough. That's for the Parliament to determine, and so questioning the witnesses about an issue ultimately of policy is out of order.
Well, to the point of order, the witness has just said there's been some review about the matters of consent. That was your answer. Now, it's perfectly within order, if that was the evidence from the witness, to actually say, can you please elucidate on what you've just said?
So I'm prepared to rule that the question from Mr Donnelly was in order, in that he was asking had any work been done, and then I think you asked for an elucidation confirming that you were right in your initial interpretation that there was no work done. Further questioning on that issue is, well, I would believe outside where the restrictions are that this committee itself adopted. So you've asked whether there's been any work done as part of the review.
And the witness has said there's been review.
But
No, I don't think that's actually what the witness has said at all. Her reactions and her body language at the moment indicate that we are at cross purposes.
Well, we'll let the witness
Let me
clarify
elucidate.
position.
We've done a comparison of those laws.
Yes.
Yes, we have done that. We have not gone and done an analysis of the factors in the decision-making capacity in the bill to take a view on whether we think they are adequate or not, because that is ultimately a policy decision for Parliament to make that call. And to be frank, you've had a lot of very eminent people advising and giving evidence on these issues, so I think you're well placed to have a lot of that evidence before you.
So effectively, a comparison has said that this is the requirement in New South Wales as proposed by this legislation. This is the requirement in Victoria. This is the requirement in Queensland.
I would have to check, because my recollection was we were trying to figure out the differences in the decision-making process, you know, from a more an implementation point of view. So we will provide that table.
But you've agreed to provide that, yeah.
It will. I'm not sure if it goes into the comparison of how they've looked at consent or capacity.
And with that, unfortunately, our time is at an end. So I'd very much like to thank our two witnesses today for coming in and providing the opportunity to ask questions of you and for making yourselves available. For the questions you've taken on notice, the Secretariat will be in contact to have those tabled. We'll now have a 15-minute break and return at 11 a.m.
Thank you, Chair.
Welcome back to the next session of the hearing. I'll now introduce the witnesses, starting with Ms. Smill. If you could please state your name, position, title, and swear either an oath or affirmation.
Good morning, my name's Therese Smill and I'm here this morning representing the Palliative Care Nurses Australia organisation, and I'll swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. Ms. Hanson.
Linda Hanson, I'm the CEO of Palliative Care New South Wales, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. On the WebEx, Associate Professor Hesp.
Sorry, just get my up. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And if I could just get your full name and position title, please.
Yes, sorry. Associate Professor Charlotte Hesby, the Chair of the Royal Australian College of GPs for New South Wales and ACT.
Thank you, Associate Professor Hesby. And Professor, I know I'm going to pronounce it probably incorrectly, Pisha. Pisa. My apologies.
That's fine. Professor Carmel Pisa, University of New South Wales Conjoint Professor, University of Sydney Clinical Professor and President of Capacity Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. We'll now move to opening statements, and do either or any of you in the room, Ms. Smill or Ms. Hanson, have an opening statement?
Yes, I do.
On behalf of both...
We were going to make an individual one, if that's okay.
Okay, well, Ms. Smill, I might start with you, if that's okay.
Okay, thank you. So thanks for the opportunity to speak here today, and as I said earlier, I'm representing the Palliative Care Nurses Australia organisation, which is a professional organisation that represents palliative care nurses across Australia, but obviously we're talking about New South Wales here today. I'm sure to define palliative care is not a new definition, but it is the physical, psychosocial and spiritual care of people that are living and dying with a progressive life-limiting illness. For many years, the palliative care context was always connected with the cancer trajectory, and rightly so, but we now know that we are looking after many people also with non-malignant illnesses such as neurodegenerative disorders and end-stage renal, cardiac and respiratory diseases, and the late side effects of diabetes. The importance of access to specialist palliative care is extremely important, and whilst we have grown and developed palliative care in this state, and we've been probably a pioneer in the country around developing specialist palliative care, and that is both multidisciplinary and interdisciplinary, we certainly don't have equitable access, and by that I mean that whether you live in Tibooburra, Walgett, Randwick, Mount Druitt or all points in between, there is no consistent access to palliative care. We know that in the last 4 or 5 years there's been recent surveys done where at least 60 to 70% of people state that if they were to be dying of a progressive life-limiting illness, that their place of choice would be to die at home. And clearly we do not have the services either in the home setting, in the ED departments and of course in many hospitals. So for people, when we talk about informed choice, people need to have access to make that informed choice. It's great in a theoretical model, but in the real world we are still, New South Wales has done quite well in the last 4 or 5 years in terms of palliative care funding, but we are nowhere near what we do need. We know that whilst the GP setting is not a state responsibility, that has to go hand in hand with people deciding to die at home. And so the whole concept of dying at home requires 24-hour access to care. It is not just a 9 to 5. People don't die between the hours of 9 to 5 at home, and they don't die 9 to 5 in ED either. So that access, whether it's in a hospital setting or in the home setting, is so important, and I feel that this debate really does require to fully understand that, so that people then, including yourselves, can make informed decisions about what the residents of New South Wales require. It also goes to the point of the education and support of particularly nurses, but all health professionals, so that all health professionals have at least a primary understanding of what palliative care is. And a big part of palliative care provision is the education and support of carers. And if you ask most clinicians, we'll talk about the fact that it's a 50-50 split of the support and education that is ongoing to carers and families. So I thank the committee for the opportunity to speak and hope the discussion goes well. Thank you.
Thank you, Ms Mill. Just in relation, and I didn't want to interrupt your opening statement, but just in relation to this inquiry itself, it is into the provisions of the bill. Yes. So as much as I've allowed some fairly wide latitude, most of the questions I expect that you'll be asked are around the provisions in the bill, not so much around some of the issues that you've raised in the opening statement. So I just wanted to just foreshadow that so that you'd actually understand why the questioning is the way that it is.
Thank you.
Ms Hanson, if you would like to make an opening statement.
Yeah, sure. And with that in mind, I just would just like to briefly just describe Palliative Care New South Wales as the peak body, and that we represent the palliative care workforce in New South Wales, but we also look to provide support and services to the families and carers of New South Wales as well, as a relatively small body. And just support, I guess, Teresa's statements around the variety of equity of access to palliative care around New South Wales, which I know you're all aware of.
Thank you very much, Ms Henson. Associate Professor Hespy, would you like to make an opening statement?
Thank you. Yes, I'll just make a brief summary. That consistent with the national policies and position of the Royal Australian College of GPs, the New South Wales NSW faculty is generally supportive of this bill, subject to explicitly precluding acts that do not constitute voluntary assisted dying or assisted suicide, such as withholding or withdrawing medical treatment in contradiction of a person's previously expressed wishes, and or where they retain capacity and have refused life-sustaining interventions, withholding or withdrawing futile treatment, administering palliative medication with the intention of relieving pain and suffering with the understanding that the treatment may hasten death, administering terminal or palliative sedation to induce decreased or absent awareness so as to relieve otherwise intractable suffering. And secondly, but most importantly, existing within a framework that actually is first about the dignity, wishes and interests of the dying person, which is to be through decision, and that this prioritises and adequately funds high quality end-of-life and palliative care services that address the needs of all patients at end of life, not only those who wish to request voluntary assisted dying, and that it recognises and supports the role of general practice as central to meeting society's growing need for high quality end-of-life care. Thank you.
Thank you, Associate Professor Hespy. And the Deputy Chair has just asked, are you able to provide your opening statement if you've read it, just so that we can have for a provision for both Hansard but also for members, if that's possible at all? Thank you very much. Professor Pisa, could I invite you now to please make an opening statement?
Thank you. Yes, good morning. I'm speaking as both a stakeholder representative and expert on behalf of both the Royal Australian College of Psychiatrists and the Australian human rights charity Capacity Australia, of which I'm founder and president. I do so because our positions on voluntary assisted dying, may I, with the committee's permission, refer to this as VAD? Is that okay?
Absolutely.
Are aligned, and because Capacity Australia has contributed to numerous related such inquiries, including the New South Wales Legislative Council inquiry and the LRC report on elder abuse, as well as being the nominated capacity and decision-making resource for a number of key national bodies such as Australian Aged Care Quality and Safety Commission. I am also co-author of the major OSCE text, Capacity in the Law. I would like to inform the committee that I have submitted several resources to assist the inquiry, to which I will refer during my statement, and which may I request to be tabled.
Absolutely.
Have you received? Thank you.
We have, Professor.
Thank you. Good. My first point in my opening statement is that we applaud the considered and thoughtful manner in which the committee has dealt with the amendments in the consideration detail, which I have read considerably, and we support many of the stances. In particular, we support Amendment Part 2, Division 16, conferring ineligibility by virtue of dementia due to the complexity and seriousness of the bad decision. Secondly, we support negativisation of Amendment Part 1, Division 3, linking lack of capacity with mental illness, while at the same time preserving Part 2, Division 16, conferring ineligibility based merely on the presence of mental illness. We, aligned with discussions as documented in the consideration in detail, make a distinction between eligibility for VAD being preserved for people with mental illness, providing they have capacity, as distinct from eligibility for VAD being preserved for people with, from VAD being provided merely because of mental illness. Thirdly, we support negativisation of the amendment regarding the actual voluntary dying system substances involved, discussions of which we feel are clinical matters not to be legislated. The complication rates discussed are extremely important and part of the role of the practitioner and capacity assessment or obtaining consent to ensure that the patient has been provided with relevant information required to make the decision, including such things as you have discussed, treatment failures such as prolonged dying and side effects. By necessity, this detail must be included in the requisite training for practitioners operating under the Act. We have outlined these obligations in the paper that I have provided you, the biggest decision of them all. Fourthly, we support the amendments in both Part 12 and Schedule 1 to reinforce abuse safeguarding by elaboration of the meaning of pressure or duress, including elder abuse, and by strengthening recommendations for the training in relation to this matter. Again, to refer to comments in the consideration in detail, while not suggesting that all older people are vulnerable, we have a special duty to make sure that the interests of those older or other vulnerable people are protected, and that there is no suggestion that they might be acting under any duress, or that elder abuse or other abuse of vulnerable people. We refer the committee to the papers, the biggest decision of them all, as well as the paper, The Nexus Between Elder Abuse, Suicide and Assisted Dying. Our only residual concerns are threefold. Firstly, we do not think that Part 1, Division 2, Subdivision 4 principles protects older people and people with disability enough. While we applaud the amendment to Clause 4.1i regarding those living in rural and residential areas, we strongly suggest that an additional Clause J be added regarding residents of both aged care and residential disability facilities having entitlements to the same level of access to high quality care and treatment, including palliative care and treatment, to minimise the person's suffering and maximise the person's quality of life as persons not residing in such facilities. We know that both the recent Royal Commission into Aged Care Equality and Safety and the follow-up New South Wales Legislative Council inquiry into provisions of the Public Health Amendment Bill, Registered Nurses in Nursing Homes 2020, to investigate understaffing and the need for mandated registered nurses in residential care to provide comprehensive care, including management of pain and other forms of distress. These inquiries clearly document the deficits in palliative care for older Australians, which for some constitutes elder abuse by neglect, with violation of the human right to be protected against abuse, torture and cruel, degrading treatment. As we have stated in our international paper, which I have provided you, the human rights of older people with mental health conditions and psychosocial disability to a good death and dying well. As noted in this paper, we also cannot forget the human rights to quality end-of-life care owed to the even more invisible and neglected Australians living with intellectual and physical disabilities in care facilities. From the consideration in detail, I can see we are all in agreement that we cannot be providing access to VAD as a solution to inadequate care, or be prioritising access to VAD over the human right to access to the highest quality of health care at the end of life and the human right to relief of pain and suffering. These issues are even more acute now, as you have highlighted in the consideration in detail, in the face of the biggest public health crisis that New South Wales has ever faced. Our second concern is our disagreement with the negativisation of the amendment to delete Part 2, Division 16, reference to the presumption of capacity. We agree with the arguments outlined in the consideration in detail as experts in capacity in the law, that noting the presumption is contradictory to the starting point used in the Act of this being a rebuttable presumption, appropriately so due to the severe and life-threatening illness faced by patients seeking VAD. Further, we agree that this reference to the presumption of capacity is confusing for capacity assessors. Given our empirical research internationally regarding the deficits in doctors' understanding of law and capacity, I can tell you with considerable expertise in this area that the majority of doctors would never even heard of presumption of capacity. As you have stated in the consideration, to place reference to this common law concept in a bill where the consequences of the decision being made is death, when we are given a mandate of actively establishing capacity, is both unnecessary and unhelpful. And finally, my final point is that we agree with the concerns expressed in the consideration in detail, as stated, that we ensure that proposals to promote VAD do not undermine efforts to prevent suicide for all, particularly for older people, and most so for men over 80, amongst whom have the highest rates of suicide, often due to untreated depression, pain, and medical illness, despite the ageist assumption that advanced age per se renders life not worth living. Thank you, and thank you for allowing me to have such a prolonged opening statement.
No, thank you, Professor Pisa. I just need to clarify, we've got a number of titles with which you've appeared today. Can I just confirm, there were a number of references to we. Under which of your capacities that you're appearing are you referencing the we?
All of them. And thank you for that question, and my apologies for my ambiguity. I was going to clarify that because our positions are aligned, the we refers to the College of Psychiatrists and Capacity Australia. If in the course of this inquiry you ask me a question of which I will be responding as President of Capacity, I'll make that Australia, or versus the College, I'll make that distinct. But my opening statement represents the position of both the College of Psychiatrists and Capacity Australia.
Thank you very much for that clarification. We'll now move to questions if everybody's happy with that position. I'm just looking around the members to see who might indicate they've got a question. I've no doubt the Deputy Chair can take the lead.
Thanks very much, and thank you all for making yourself available today, those appearing in the room and those remotely. It's greatly appreciated. We're sharing questions around members, so I'll just ask a few and then it'll be shared around to the next member, and that's the way we're dealing with it. Can I ask my first questions to the palliative care representatives here today, specifically the Palliative Care Nurses Association Incorporated and Palliative Care New South Wales. And perhaps we can start with you, Ms. Schmiel, and specifically going to your submission, which is submission 71 to the inquiry. Your opening statement made some, dare I say, pretty explicit and clear opinions that you exercised as the representative of the organisation you're here today representing about the state of the availability of palliative care in New South Wales. You made that quite, I think, clear to everyone around the table, certainly myself. I'm wondering, as a starting point, how do you, or how does the organisation, perhaps I should better say, come to the conclusions that you have made today in terms of how you've expressed an explanation of the availability of palliative care in New South Wales? How can you do that? What's your basis of making that claim?
Look, I would say at an empirical level, that is probably one of the real challenges in the state in terms of very clear data. So my account is always probably more anecdotal, but it is no doubt very factual. So if I, look at whether it's a metropolitan area, and there is some level of belief that if you live in metropolitan Sydney, then it's okay around palliative care, but once you go regional, rural and remote, it gets tougher. That is not the case these days. There is challenges of access everywhere. And if I could just sort of use the example of someone that is perhaps, in the last 3 months of their life, choosing to be at home if possible, we know that, for a start, there are impositions on people if they're choosing to have their care at home rather than in a hospital setting. Once you're in hospital, of course, in our, very good public health system, it is free to you. You are paying, through your Medicare, etc. Once people come home, and that's where, as we know, at least, 50 to 70% of people want to be, there are impositions just financially for a start. So we discharge someone from a hospital, we talk to them about the fact that there will be a cost for at least the delivery of the equipment that's required. You cannot care for someone dying at home without a baseline of equipment. You don't need a hospital ward full of equipment, but at a very practical sense, you need, a hospital bed. You may need some toileting requirements if people are still mobile. There's other things you need. That all costs people in most LHDs, and that's one of the challenges that we are so inconsistent across our LHDs. The cost of pharmaceuticals, whether we like it or not, many, many people that are dying of a life-limiting illness do tend to have quite a plethora of medications to manage their physical symptoms. When you're in hospital, they don't cost anything. Once someone comes home, they are therefore then paying for those medications, some of which are not PBS listed. There's the access of even getting medications. If a person has, one carer, and that carer has the 24-hour responsibility of their spouse, if we use that as an example, they've then also got to be able to get out to their retail pharmacy to, gain those medications. They've got to, normally it's the PALCare team that ensures that retail pharmacy has access to those medications. So there's a myriad of challenges that if we had a more holistic service, that a carer didn't have to do those things for a start, that we could let that carer concentrate on being a carer, but not the logistical coordinator of that care at home, which once you go to hospital, carers can be just the spouse, the sister, the mother, whatever. So that's the sort of practical examples. I think the other issue is just that it is a 24-hour burden for carers. Now, carers take that on willingly and lovingly on the whole, but most services have a fairly 9-to-5 provision, and that's just because of what they're funded for. And, frankly, as you all know, that things don't just happen 9 to 5. Now, there are some LHDs that perhaps have an extended service from, say, 7 in the morning till 9 at night, but again, that is not consistent across the state. And for many areas, come 6 o'clock at night, shops shut. Yes, you may have access to a phone line support service, but frankly, if I'm, at home looking after my husband and I'm, whether I'm 45, 75, whatever, I probably need a bit more than that to do this successfully, to then be able to say people have been provided with every opportunity to then make decisions, whatever they may want to make, rather than perhaps choosing to make decisions because they're not in fact receiving what they should be entitled to.
Thank you. So it's very clear from the opening part of what you just responded to, Ms Muir, that it's very much being at the coalface of doing this work, that is palliative care nurses, the specialty of that, that's informing your understanding of this issue about the matter of palliative care in the state. Can I please take you to the bottom of page 1 of your submission? And you've touched on it, but I think it'd be helpful for us to ask you to, or at least anyway for me anyway, to elucidate. You say, in New South Wales, successful community models of care rely on a resourced and accessible specialty multidisciplinary palliative care team working with an adequately resourced primary team of nurses and GPs. In some parts of New South Wales, 40% of the workload in palliative care, yet they do not have the capacity to meet the current patient needs. Just taking it in parts, first of all, just to help me understand, the explanation of what a specialty or specialist multidisciplinary palliative care team, what does that mean as we understand it today?
So in a community setting, in terms of community nursing setting, you have a team, dependent upon which LHD we're talking about, of a group of specialist PAL care providers. So they are people that have got postgraduate qualifications in palliative care, and I'm talking doctors, nurses and allied health. But they are obviously a small percentage of that workforce that would be looking after, you know, the population of that particular LHD. So you have to rely on what's called the primary level workforce, which for the home setting would be the generalist community nursing teams and the general practitioner. Those two teams of people are integral to the care of people at home, particularly the GP, but definitely the community nurses. I mean, in a perfect world, every client, patient requiring palliative care could be seen by a specialist palliative care nurse, but in fact they probably don't need that because a lot of what the specialist palliative care teams do is educate the community nurses, the GPs, the local, you know, clinical psychologist practice, whatever it may be, the volunteer services. And so that is often their role, as well as being at that clinical coalface providing expert care.
I'll just, if you don't mind, Deputy Chair, just check to see if any other members actually have any questions at the moment before allowing the...
I'm happy for the Deputy Chair to continue from my part.
Deputy Chair, you've got the call.
Thank you. Well, thank you for that explanation about the team. And in terms of just the membership of a specialist team, in terms of the categories of medical people within the umbrella of that, just for my own edification, what would that look like in terms of the medically trained professionals, those who specifically completed a medical degree, and then perhaps just spilling on to talking about the nursing, and then perhaps beyond that, how that might articulate to enrolled nurses and the community network of work done by Ms Hanson's...
I'm just going to flag, Deputy Chair, that while I've provided the ability for members to have, I'll say, some wide latitude in relation to this, I'm unsure as to how that question or how it would potentially lead into questions that relate to the provision of the bill.
Mr Chair, can I take you specifically to the bill? And can I take... and I'm sure the witnesses have a knowledge of this and may even have the bill in front of them, that Clause 4 principles of the bill, 1D, deals specifically with a person approaching the end of life should be provided with high quality care and treatment, including palliative care and treatment to minimise the person's suffering and maximise the person's quality of life. And that is the overarching principle that emanates the whole bill. And then if we go to, and this is just my second example, I can find more if you wish, 10.2c deals specifically with palliative care and treatment options available to the person. That's precisely what I'm elucidating from my questioning.
While I accept that, I'll allow it to continue, but I'll be closely monitoring exactly how we are relating to the terms of reference and the provisions within the bill. I'm yet to be convinced that discussing the makeup and the training of the teams for palliative care are related to the provisions of the bill.
Inviting me to respond to that, or are you just making a point?
I'm just saying I'll be monitoring it closely. So I'm just guiding you to actually direct your questioning in this instance once you've got an answer towards the provisions of the bill, if you wouldn't mind.
Okay, well, perhaps if I preface all of my questions by referring to the principles in the bill. Does that deal with it? Specifically for, because on the issue of high quality care and treatment, that's a principle in the bill. The issue of who makes up the teams in terms of the medical specialists and the nurses, palliative care nurses, registered nurses, enrolled nurses, and the community volunteer network go to this very issue of provision of high quality care. That's specifically the point I'm actually seeking to elucidate. What does that mean?
I've indicated that the question's in order. However, I am foreshadowing that I am keeping a very close eye to ensure that we are abiding by the terms of reference and the principles with which we've been conducting this inquiry to the point. So the question's in order. I'll let you ask it, but I would just ask you to bring the answers and your further questioning back towards the provisions of the bill.
Well,
Deputy Chair, you've got the call.
The position is my question.
You have the call.
Yeah, no. So my questions are very specific to the witnesses, all witnesses. They are in complete conformity with respect to the provisions of the bill, and I draw your attention to clause 4(1)(d). I've drawn that to your attention. So with respect to the provision of high quality care and treatment as expressed in the bill, my question, a line of questioning was about the medical staff, medically trained, the nurses, the voluntary network. Could you please elucidate about what that looks like and how that operates, please?
Again, I would say it's extremely different right across the state, and therein lies an issue that, you know, a resident living in one LHD may in fact have access to a team, whether it is a large tertiary hospital as an inpatient or in the community setting, where you will have specialist doctors that have done palliative medicine training, some of whom will be physicians in the first instance, and then therefore palliative care nurses who again have done, you know, postgrad masters in palliative care. And, you know, those two positions particularly do a lot of education to all the other providers of care to that palliative care patient. But the challenge relating to the bill around that provision of palliative care that anyone requesting must have had access is that currently they don't have access. So I'm talking about the ideal team, but I can also tell you where, you know, there is perhaps one specialist palliative care provider, often not a doctor, but a pal care nurse, having responsibility still for a large area where in fact those residents can't possibly have had that access to that quality palliative care.
So if I could take that, and thank you for that answer, and follow on to a question to Ms Hanson about the work done, the remit of Palliative Care New South Wales and the work that it does with respect to the volunteer network that operates to, across the state, augment and assist the provision of palliative care in the state. Could you please provide an explanation of what it is at the moment, how it exists, how it operates, just an overview for the committee, please?
Sure. So palliative care volunteering exists where there is a service that supports the palliative care network. So their palliative care volunteers are recruited by a palliative care service usually, or there's a healthcare provider or an LHD will support a palliative care volunteer manager, a manager of volunteers, to recruit and train and support palliative care volunteers, and they have a range of roles depending on who they're supporting and what that person needs and what the interest of the volunteer is. So there are a range of different volunteers across the state. Now, as for all of the other issues around palliative care around the state, it's not, each service looks different depending on who's running it and whether there's any funding for it. So volunteers are there to support the palliative care team with the provision of some of their expertise, but mostly it's time. So spending time with families and carers and the person who's dying in whatever setting that is. That can be in hospital or it can be at home. So as with the other issues, it is about the access to volunteers is a huge benefit to every palliative care service where those volunteers exist. So the gaps are where there is no palliative care volunteer service, and that's because there is no person funded to run that volunteer service.
And as we move away from the large population centres, and for convenience sake we'll say Newcastle, Sydney, Wollongong, just for convenience, could you provide please to the committee an overview of the first of all, I guess the level and the size of the network and the challenges associated with operating as a volunteer network away from the large population centres, particularly in the remote parts of the state?
Yeah, look, in some areas it's easier sometimes to run a service in rural and remote areas because the communities are very close and everybody knows everybody within, the 20,000 kilometre radius of some of those services. But there are thousands of palliative care volunteers across the state. There has been a really serious impact on their ability to provide service over COVID because, just for health and safety reasons, but all of the services are so, there are no services in some areas, no palliative care volunteers at all, just because there is no funded volunteer manager. So, and it doesn't really matter whether it's, Broken Hill or on the Murrumbidgee somewhere, it doesn't matter where it is. If there is some kind of focus on the importance, if people understand, the people providing health services generally understand the importance of the role of volunteers, there is generally a volunteer manager funded and supported to try and recruit and manage those volunteers. These volunteers are very carefully selected, I should say. These are people who have to go through, there are rules about how long. They're usually a bereaved person. It's usually somebody who wants to give back to their community and give back to the palliative care service that supported their person who died. There are rules about the length of time that person has had to be bereaved, because a lot of people just want to charge in there and get straight into it, and really they need to be given time to deal with their grief and bereavement. There are rules about the type of person that might be appropriate for palliative care. This is a quite different area of volunteering to anything else. Because for their sake, as well as the person that the persons that they're going to be caring for and the different families that they go into. Bear in mind, these volunteers are helping a team look after someone who's going to die. So they can get close to people, they get close to the families, they get close to the person who's going to die. They have to be a kind of person who can manage that and deal with that, and they're always supported to do that. So it's quite a different role to some people, I think, often misunderstand palliative care volunteering as being sitting with somebody and holding their hand. It's very much more than that.
I'm just going to take this opportunity, if that's all right, to ask Associate Professor Hespy and Professor Pisa in turn. We've heard from New South Wales Health this morning that with changes in legislation and policy that are typically large and complex, as the potential introduction of VAD legislation would be if it passes the Parliament, that a number of health sectors would look to New South Wales Health to and their policies and guidelines that they develop. Are you able to provide some insight as to how a private GP or perhaps psychiatrist might look to the guidelines and policies of New South Wales Health in developing how they formulate their work and provision of any VAD on the work that's done by New South Wales Health? I'll start with you, Associate Professor, and if that's all right, then I'll go to Professor Pisa.
Yeah, thank you for that question. Can I just point out that for GPs, we work across all of Australia under the terms of Medicare, so therefore, sort of in terms of GP stuff, we're not constrained to just New South Wales in terms of guidelines, etc. And voluntary assisted dying has been introduced for GPs in other states already, with West Australia and Victoria being particularly large in terms of the GP environment. So as a result, GPs have actually been very well educated and across the issues that have been rolled out with changes in legislation for voluntary assisted dying. And so there's been a lot of education to GPs about what this means, and in particular about the ability for them not to be in any way involved if that doesn't align with their own ethical stance, at the same time as making sure that they actually deliver high quality care for the patient in front of them. Which I just wanted to go back to the previous question, which I didn't have an opportunity to put in for. It's really important to know that the services that each individual patient accesses is very individual. There is nothing, it will depend upon their own GP, their own specialty team, what the actual illness is that means that they don't expect to live over the next 12 months. And it's very difficult to actually put one individual, a formula out there for everybody. And I'd just be very mindful of that. And that's where, from my position, GPs are very good at being able to help people in terms of decision making and understand what services they might need to get, knowing that access to services, not just in the rural setting, can I say, but also in an urban setting, can sometimes be extraordinarily difficult to access. And I think we sometimes forget the very vulnerable population in cities who also have great difficulty accessing appropriate services. And because they're not in a rural setting, then there sometimes isn't an advocate for them to get the appropriate access to services. Back to the alignment with New South Wales Health, what we do for general practices, we have a thing called Health Pathways, which is absolutely fantastic, can I say, and it's about making sure that GPs know exactly what the evidence is about what they do, how it aligns with sort of the legal framework, and accesses to appropriate documentation for wherever it is that they absolutely are. And so this is one of those particular cases where for GPs who may not otherwise know, there will be access to a very clear set of guidelines around what are the legal requirements, what the guidelines are, which would link to the current documentation from New South Wales Health, as well as the national sort of guidelines for them, and assistance in terms of actually accessing the required education if that's what they would like to do. Noting that I don't think any doctor should be part of this process unless they have actually fulfilled the requirements of the education package.
Thank you for that, Associate Professor. Just before I do pass to Professor Pisa, I'm just going to foreshadow that I'll come back to you with a question around GPs and specialist care, if that's right, because you've just touched on something that I want to come back to. Professor Pisa, are you able to provide a response in relation, I guess, to the College of Psychiatrists?
Yes. Well, in relation to training and guidelines with respect to the Ministry of Health, which I understood to be the first question, as the person who was consulted for the Victorian for education and training regarding the Victorian legislation by the primary providers of that legislation, which was the Queensland University of Technology team of Professor Ben White and Lindy Wilmot. There's absolutely no need to reinvent the wheel, and that rather there is already a template for a substantial and validated and evidence-based training around voluntary assisted dying. And in fact, the paper that I've asked to be tabled, the biggest decision of them all, which I co-wrote with Professor Ben White, was actually written specifically with the purpose in mind of educating practitioners about the assessment of capacity. So I strongly suggest that you revert to the existing education, mindful of the jurisdictional variations in the legislation, and of course it would have to be adapted and tweaked in relation to specific New South Wales legislation, but the general principles still apply.
Thank you very much. And we've got that paper here, and we'll make sure that that's tabled with our papers when we've completed the hearing.
And may I also, I could be put on notice, may I take on notice some kind of reference or to the link or to the description of the existing education that Queensland University of Technology does provide. They provide an extensive end-of-life law education, but they also provide specific education around the Victorian legislation.
Well, to aid that, Professor, I'm going to ask you if you could provide a link to the training and the items that you've just identified from the Queensland University of Technology, and it sounds like you're happy to take that question on notice.
Yes, please.
Thank you. Thank you very much. Associate Professor Hespy, I just wanted to come back to you on something you touched on around the that palliative care issue with GPs, and noting that, as I've said, we've got a little bit of wide latitude, and it's been discussed, I guess, openly this morning between the Deputy Chair and our witnesses in the room. But there's much talk about who makes up the team, and I noted that you sort of started to touch on the importance that local GPs and doctors with knowledge of their patients is important in that palliative care end-of-life treatment. There's a lot of talk about the requirement to be a specialist palliative care doctor. In your opinion, your members, GPs out in remote rural areas, are they providing adequate first-class palliative care to the people that they're looking after, or is there any difference in the care that they're getting from their family GP or the GPs who are looking after them compared to what they might get with a specialist palliative care doctor?
That was a highly controversial way of wording that question, can I say?
That's
okay,
me.
So the first thing that needs to be clarified is that GPs are actually specialists. There are still doctors who are practicing in the specialty of general practice who are not specialists. But general practice is actually a specialty under the medical board registration. So we need to be very clear about when you use the term specialist, that GPs with a fellowship are actually regarded as a specialist. So that's point one. Point two is that a lot of, there is also then the added rural generalism or sort of remote medicine specialisation that some GPs will also have who actually do practice, general practice in a remote environment. They're not required to have the extra specialist qualifications for remote and rural, but they can do, and they can get that both through the College of Rural and Remote or through the College of GPs. Both of them give equal level qualification to being there's a few different terminologies around it, but the term for actual rural generalism is coined by many. And if you actually do that specialty, then it will depend upon what they actually specialise whichever sort of specific, they have to do 2 extra streams of training. So some will do obstetrics and gynecology, some will do palliative care, some will do, anaesthetics, etc. So there were a number of different things. And again, just that qualification doesn't necessarily say what extra training they may have done. So that's point number 2. Point number 3 is that there are an awful lot of GPs who are specialist GPs who have done palliative care as an extra stream of training anyway, and it's a bit like, so someone like myself, I've done extra training in obstetrics and gynae, I've done extra training in paediatrics, I've done extra training in palliative care, and I've done extra training in dermatology, but you don't necessarily see that in my fellowship as a title, okay? But they'll have done a level of diploma, etc. So if we're talking about what different GPs can offer, there's an awful lot of GPs who do palliative care as an offering. So my practice, for instance, takes referrals from the local palliative care team to actually manage patients in the community as a partner of the palliative care team to oversee the care that's delivered until actually that patient dies. Not all practices do that. So you can't, again, it's always that difficulty about what different people can access. So your own GP may or may not do that, but that GP can hand the care over. If you're talking about what level of care they get, I would hope that if you have a GP who knows you, then you obviously should be able to access all of the care that you need at any time, and there should be no difference in the quality of care, knowing that that is coming from if I'm pragmatic, I understand that not all patients access the quality of care that I would espouse everybody to be able to access, and that's due to a number of access and affordability criteria, particularly if want to get onto my hobby horse, it's about the defunding of primary care services, which has unfortunately been a body of good work being done from high levels of finance for the last 15 years in particular, where the sustainability of the provision of good quality primary care services has been totally destabilised because it's no longer financially sustainable under the current Medicare model. But that aside, the GPs are trained and there usually is someone that you can do. And now with telehealth, can I say, it makes the ability to have the right person being consulted and being able to provide the services much, much better for some of the more remote issues. Not taking into that account, obviously, the issue about access to the telehealth portal that you might use, whether that be a video platform or less optimally phone.
I've just got one more question before I pass back to the Deputy Chair to continue his line of questioning. But Associate Professor, for people that are in their end stage of life and are about to receive palliative care, how important is it that, say for example, that it's their GP who will be providing that palliative care support to them? How important is it that the patient has confidence that that GP is able to provide them that care? And do you think that perhaps can be slightly eroded by the discussion around whether it's a specialist palliative care doctor that they're seeing as opposed to a GP, and is that eroding of the confidence perhaps in a way unhelpful to the patient, do you think?
Thank you for that question. I think that's a really good sort of way of actually approaching this issue. From my perspective, the GP is absolutely key in assisting a patient navigate the pathway of treatment that they need to access. Whether that GP be the person who actually provides the palliative care services or not doesn't take away from the most important person that patient have to be able to discuss what it looks like being able to continue to be in their care. So it actually comes back to how we actually support team care, shared care, and what sort of gets talked about a lot about integrated care, but really it's about having really good communication portals and good communication mechanism between the GP who might know that patient to be able to be an advocate for them about the services that they get from a specialty palliative care service, being appropriately for them culturally, with a background of what their other sort of stuff that might be part and parcel of their mental health, previous health issues, etc. So rather than it eroding, I think it's very important to actually understand the role of the GP, which doesn't need to be the palliative care person, but still needs to be part of the palliative care service provision for that patient. Does that make sense to you?
It absolutely does. Thank you very much for that. I'll pass to the Deputy Chair.
Thank you, Chair. Can I ask Associate Professor Hespy a direct question, and I don't wish it to be taken the wrong way, but you're here today representing the Royal Australian and New Zealand College of General Practitioners.
No, just the Australian, not New Zealand. We're at the Royal Australian College of GPs.
Okay, I'm reading from the document placed in front of me by the Parliament, so I withdraw that. But is it New South Wales ACT branch or division, or?
We're a national organisation, so the psychiatrists are Australia and New Zealand, so that may be where some of the confusion arose, but it's the Royal Australian College of GPs, and I'm the head of the New South Wales ACT faculty, but we're one national organisation.
Thank you very much. Now, I'm wondering why a submission was not made to this inquiry by your organisation.
That's a good question, and I think it's because we've just had a changeover of management, and because we're a national organisation, it went to national and it slipped under the radar, I think. That's one of the difficulties of when you have a national organisation and you've got multiple states putting in.
Okay, that's fine. That's your explanation. I accept your explanation, and I'm not reflecting on you. But you would be aware that various other professional health bodies have made a submission to the inquiry. You would know that, wouldn't you?
Yes.
Yes.
Obviously, I became aware when it came in. Nobody actually notified me that there'd been a request, so hence the...
No, that's okay. Now, have you had the opportunity to read the submissions from some of those other peak medical bodies?
No.
No. So I gather you wouldn't be aware that a number of them have made some explicit recommendations in their submissions about some proposed amendments to the legislation that's being proposed to deal with some of their concerns? You wouldn't know that?
I wouldn't know what they look like, no, that's right.
So can I ask you, so for example, we had the Australian Medical Association New South Wales this morning, and they made a detailed submission, and they've raised a series of issues of concerns that they have with respect to the legislation, and in fact they've gone a step forward and proposed wording amendments, and even in some cases to ameliorate some of their concerns. Does that organisation cover GPs? The AMA?
GPs, yes, that's right. But they've got less members, probably. I mean, you know, they're like the union versus the college.
Right. Okay. Well, that's an important distinction, I suppose. So, with respect then to the college, which is the professional body, is that the terminology that you're comfortable with? Yep. So, with respect to the college, so this is the principal college for general practitioners. You've got no particular views about any amendments that could be made to the proposed legislation to improve or enhance or make it a better piece of proposed legislation?
As I said, we're very mindful about the legislation that's already rolled out in other states and how the wording of that and the numbers and how it's affected the GPs, and the numbers have actually been quite small. And so we've been as comfortable as you can be that those current sort of frameworks have worked, with due care, noting the concerns that I've read in terms of making sure, absolutely explicitly making sure that palliative care is appropriately offered, and high quality palliative care is actually part and parcel of any patient's care before they actually would need to be having a conversation about voluntary dying, because from my perspective and my members, that if appropriate palliative care was offered, then voluntary assisted dying would hopefully not actually be relevant to really very many patients at all.
So on that very point about the availability of palliative care, the provision of palliative care, does the college have a view or a position, or is able to provide us on notice with a view or a position about the state of the availability of palliative care in the state of New South Wales?
Do we have a statement? Well,
sorry, not a statement in necessarily words, but can you give an assessment to us? Because what logically follows from what you've just said, Associate Professor, is pretty significant. And it seems to me that one can only really move forward, potentially, on thinking about voluntary assisted dying. This could be an argument, of course, that there's issues around this unless there is the ready availability of high quality palliative care around the state. Indeed, can I draw to your attention that in the actual bill itself, there is a very specific provision. I presume you've had a look at the bill?
Yeah, so, and that's what gives me reassurance that the bill does actually have that as part of it, yes.
Well, just to be clear, with respect to the bill itself, the specific reference, which is perhaps the most significant about palliative care, sits as a principle of the bill. You understand that?
Yeah.
And you understand that a principle is not definitive per se in the actual requirement to provide palliative care, is it?
Okay, well, we can get into all sorts of pedantics around it, but in terms of patient choice and options for what they actually know and understand to be able to access, you've actually got to have a service that's there for the person to access and to know and understand what it means. I've certainly found for a lot of patients don't understand the difference between voluntary assisted dying and access to palliative care.
Yeah.
And often it's about guiding them down the pathway and understanding in terms of health literacy and what I call health activation, about understanding what it is you're talking about. And the vast majority of the time it is actually about having access to appropriate palliative care services rather than actually accessing voluntary assisted dying that people want. And so that's where, from my perspective, the conversation with the GP is key, because a lot of people don't actually understand it. And there's also a lot of specialists, particularly in cancer services, where they don't like talking about palliative care because they see it as a failure of their service provision rather than seeing it as part of really the whole what I call spectrum of care, that, you know, palliative care, we're all going to die, so we all need to understand at what point do we talk about the service that we're getting is part and parcel of our end of life versus this is actually going to get rid of or cure a condition.
Yes, indeed. Your evidence would be that the general literacy in the community presently with respect to palliative care is quite modest. Would that be your evidence?
Yeah, and I think there's a lot of conversation around, well, obviously core provision of service, and so people may not understand what options they do have and how do they ensure that it actually meets the needs of either them or the person they're caring for.
So, Doctor, you no doubt have been following quite closely the inquiry being undertaken by the New South Wales Parliament into the provision of health care and health services, or health and health services and health outcomes in regional and rural and remote New South Wales. That would be the case, wouldn't it?
Great chair on that committee. Yeah.
You have? And
Yep.
in your capacity as representing the college here today, you would be no doubt following it closely and presumably reading the Hansard, and you would have seen that in many, many places that we've visited, we've had witnesses come along and explain that, in fact, in their local communities, there aren't even general practitioners in town, so to speak, to provide basic GP health care in many parts of regional and rural New South Wales. You would know that, wouldn't you?
Yes, it's part of a very big advocacy conversation that the Royal Australian College of GPs is having both at a national and a state level about possible solutions to how we deal with those issues.
So, and please, my raising it's no reflection on the college. I'm sure they're advocating it hard as they possibly can, no doubt, along with the AMA. But my question is, that follows directly from that point, is this: that if there is no GP in town at all, how is it possible for these discussions around palliative care, as you've articulated so well, be able to be engaged with in any meaningful way with a person who might have an end-of-life or terminal condition? If there is no doctor in town, how can that be undertaken?
It's a bit more complex than just saying whether there's a GP in town or not. There's a lot of different services and ways in which people access services. And I understand the premise on which you're based that on, but most people would be able to have access to a GP to have a conversation with. And as I say, I mean, the good news about COVID has been the access for GPs to telehealth, and we just had an announcement this morning which has been received very well by the GP community, that telehealth will be funded in an ongoing fashion from the end of this year, because it does actually mean that we can access people who are in remote areas appropriate healthcare with a good GP who may not be in the same geographical location as you at this point in time.
Can I just...
This might not be ideal, but, it's about actually having access to the services and the right person to talk to.
But on that very point, and now may I direct my question to the other witness participating remotely. Doctor, in your submission from the Royal Australian and New Zealand College of Psychiatrists, and thank you for the helpful submission, take you to page number 5 of that submission, if you've got it accessible, and perhaps invite you to go to that specifically, page 5. And about halfway down the page, on page 5, you make the following statement. The organisation makes the following statement. Funding for properly developed palliative care services must be provided prior to the introduction of VAD in order to provide an equitable alternative to people suffering with terminal illness. Goes on to say, without adequate resourcing of and access to palliative care, VAD legislation arguably presents a perverse incentive for patients to choose to end their life instead of being offered adequate palliative care. The RANZCP has concerns regarding funding of a VAD scheme at the expense of making improvements to other end-of-life care options for Australians. Now, my first question, I guess, to you, Doctor, is that paragraph was put in there quite deliberately and clearly by the college. That has application to the state of New South Wales, which is the remit of this inquiry?
that has application to the state of New South Wales, to the whole of Australia, and in fact globally, as evidenced by the submission, my opening statement, and the papers that I've submitted to you.
So the words speak for themselves. It seems to me that they're very clear. With respect, if I could just move on to the next point, point number 8, because it's actually separate but related. There can be a drawing of an issue here, of a connectivity, about VAD and people with a disability. So a class of individuals that we've heard precious little from, I have to say, as a voice in this inquiry. Have you been following this inquiry, by the way, Doctor?
Well, they've made a submission, Greg. You
Not in detail. Not in detail, sir.
No, okay, no, that's fine. That's fine.
The principles, I understand. I've read in detail the consideration in detail. I know the original Act and I know the amendments, but, sir, I haven't followed in detail all of the submissions.
That's okay. Well, perhaps if I can draw your attention to the Bar Council of New South Wales submission, which I'll just draw it to you. I don't expect you to be able to access it readily, but they make some specific comment about the matters of disability and voluntary assisted dying. So I'll perhaps draw that to your attention to look at a later time. But I gather from your point number 8 in your submission on page 5, you are signalling a particular concern about a class of a person and VAD. That's what you're doing, aren't you?
I reiterated that in my opening statement, that certainly work we're doing nationally and internationally about the equitable access to end-of-life care, not only to people with in residential care with disability, with people with dementia, but in particular people with intellectual and physical disabilities at the end of life. We've addressed that in the paper that I provided you about the human rights. It actually specifically refers to that issue with a number of publications documenting the international, like there's no question about there's this empirical evidence about the neglect of people with disability at the end of life.
No, sorry, just Deputy Chair, I'm just going to note that we've only got about 15 minutes left, so seeing as the Deputy Chair and I have had the lion's share of the questioning, I just wanted to make sure that all the other members had the opportunity to ask some questions if they felt that they wanted to address some points. Mr. Diadam?
Yeah, I might just come back to this paragraph that my colleague, the Honourable Greg Donnelly, has referred to about an assertion around providing a perverse incentive for accessing voluntary assisted dying. From the Victorian experience, is there any evidence that this is occurring? Can you cite any evidence, Associate Professor, or Professor, sorry, Professor Pisa?
I'm not aware of, I haven't looked in detail of the analysis of the Victorian legislation, but I'm not aware of this happening from the Victorian legislation. I speak now with expertise of 30 years providing end-of-life care as a psychiatrist for older people specifically in nursing homes, and as well as academic expertise in this area.
But there's no evidence from our Victorian experience that this is operating as you assert, is there?
I'm not aware of it, no.
Thank you.
Well, I've got a follow-up question.
I'll let us a follow-up question, then I'll go around. Just before we do, actually, can I just get an indication from any of the other members if they've got any questions?
I've got a couple, but I'll let Greg go with the follow-up.
Okay, I'll allow the Deputy Chair to ask his follow-up question, then I'll pass to Mr. Farlow.
And sorry, Professor, I was referring to you as Dr. earlier. I do apologise, Professor.
That's all right. happens. I'm a doctor as well as a professor.
No, I'm sure you're both. But
It was a matter of some contention last night.
We don't want to get it wrong. We don't
Yeah, won't make that mistake again.
we understand. Listen, it's a bit of an insider position because we actually had some debate last week about titles, but it's appropriate. We reflect. So please.
Preferred pronouns.
It's not on. Yes, it's about pronouns, I suppose. It's got nothing to do with you. But listen, just off the back of what my colleagues just questioned you about the evidence, open quotes, evidence, close quote from Victoria. You would be aware, though, that the collection. Well, first of all, the Victorian law has been operational for, I think, about 2 years, or perhaps a bit over 2 years. And within the collection of information that is mandatory, this is under the Victorian legislation, are you aware that there is a mandatory field to catch information or select information, dare I say, with respect to the possibility of this scenario whereby, without providing resourcing, you could end up with this perverse incentive? Would you be aware that that's a field of information that's caught?
I'm not aware of this field, but I think that's an important safeguarding approach.
So that's fine. So perhaps we ourselves can establish that and perhaps invite you to have a look to see if that's a field of information that's caught. Because if it's not captured, and to the best of my knowledge that information is not captured by the reportage in Victoria, there would in fact be no way to establish whether or not the situation that's being discussed in your paragraph can be reasonably assessed, could there? If information about the perverse incentive, if that's not being collected actively by the Victorian government through Vic Health and the provisions of the legislation about reportage, how could anyone possibly know one way or the other? Is that not the correct answer or the correct position? If the information is not being collected about the perverse incentive?
It's a really good question, a very complex question. My concerns, the question needs to be asked. My concerns are that whether such a question on a tick box actually addresses and excludes such occurrences.
Sure. No, that's okay.
As a researcher in this area, yes. I mean, the issues addressed by Associate Professor Hesp, I would totally reiterate, and everything she has given evidence about, I would totally reiterate. So I'm not sure. Yes, I think that's very complex to me. I don't think I can answer that. Whether a question, a tick, whether this perverse incentive has operated or not would actually preclude whether it did in fact. Yes.
Could I just ask a question that flows from there?
May I just add that as Professor Hespe has been, as a psychiatrist working in end-of-life experiences, particularly for older people in nursing homes, I too have been asked inappropriately for requests to end people's life in the context of extreme suffering, with untreated end-of-life suffering and inadequate access to good quality end-of-life palliative care. So I would just echo everything Associate Professor Hespe said.
Thank you. Mr. Khan's seeking an elucidation, and then after that I'll pass to Mr. Farlow to ask some questions. Mr. Khan.
Sorry, Professor. Just on this question of the ticker box, when a coordinating practitioner and another practitioner are dealing with a patient who's seeking access to VAD, what they're doing, are they not, is, I don't seek to use the word only, but what they're doing is assessing the capacity of the patient, determining whether the patient is going to die within a specified period of time, and explaining to the patient their various alternatives. That's essentially the task that's put to the practitioners that are involved, is it not?
in a general sense, but it depends on the legislative requirements, yes.
Of course. But what they have in that circumstance, hopefully, and indeed it's what they're assessing, is a voluntary patient who's in extremis. That's regrettably the circumstance that they find themselves in, is it not?
A voluntary patient in extremis who's been provided with maximal access to palliative care.
Yes, well,
a voluntary competent patient in extremis has been provided with adequate, equitable access to quality end-of-life palliative care.
Yeah. Now, I'm not doubting. I'm not doubting anything that you're saying, and I'm not trying to be tricky. But, for instance, we've received evidence from, for instance, a Ms. Fleming, a nurse who talked in terms of her experience. And the reality is, isn't it, that even with the best of palliative care, some patients suffer unfortunately untreatable pain and experience all forms of suffering.
Absolutely.
Right. So
over and above adequate provision of palliative care, and in fact that would be the role of the practitioner, for which patients that there remains untreatable suffering, who's a competent voluntary patient. Where is there suffering for which maximal service has been provided? Absolutely, and they are the candidates. That's what we seek. That's what we would seek to, would be ideal candidates for VAD, which I think that's what Professor Hess, if I may clarify with you, if that's what you were saying, that would filter down to what's left over, the small minority of patients, which I imagine, and again, my apologies, I haven't looked at detail in the, and I know there's been analysis.
No need to apologise, Professor. Yeah.
But I would imagine so far to date, that's what's been the experience, I hope, with the Victorian legislation, that small handful of patients for who are competent, who are providing voluntary, who are providing consent, who are competent, who have been provided, who are suffering from a life-threatening illness within 12 months, who have been adequately provided with palliative care. That's the kernel of people that you really want to be providing that for.
Sure. And in that context, the bill as drawn, can I suggest to you, meets that criteria of helping that quite discrete group of patients.
Not in relation to, as I pointed out in my opening statement and our college submission in regards to patients in residential care. I do not think that the principles of the bill cover patients in residential care, and there's no debate about that issue anywhere, and I think that doesn't cover their interests sufficiently. But notwithstanding that, I think it does.
Thank you.
Mr. Farlow.
Thank you very much, and thank you. My questions will be directed again to you, Professor Piecer, so apologies for keeping you on the clock there. Just interested with respect to your submission, the comments you made in terms of excluding dementia from neurodegenerative diseases. Just, is that something which is done in other jurisdictions, VAD legislation, which is around at the moment?
I'm not aware. What concerns us at the college and myself as a subject matter expert is that my understanding from the original Victorian legislation is that the neurodegenerative diseases referred to or made allowance for in the original legislation was for motor neurone disease. The issue around dementia, which is, in fact, a neurodegenerative disease, is that the complexity of the VAD decision, as defined in our paper, makes the decisions, which is the biggest decision of them all, using the threshold concept, the common law threshold concept of capacity, would be the hardest decision to make, that it might be precluded, that it would be precluded by a diagnosis of dementia. And I'm speaking as an international expert in this area. That I would have the backing of my colleagues and and around the world, with the exception of it, because of the complexity that's arisen around in the Netherlands and in Belgium around issues around dementia and voluntary assisted dying. The nature of the complexity of the decision for voluntary assisted dying renders dementia as a diagnosis not an appropriate neurodegenerative disorder that would render eligibility for VAD. And that's the position of the college and myself as President of Capacity Australia.
Thank you very much.
In the 2 minutes we've got left, the Deputy Chair has a final question.
Thank you. And just returning to our witnesses from Palliative Care Nurses Australia and Palliative Care New South Wales, I've got some other questions, but time's run out, so I'll submitted as supplementary questions. But before we go, though, and I'll just invite both organisations to make a response to this. If you want more time to respond, so be it, you can take it on notice. But we've heard much of the provision of care or care that would be available or would be provided. That's the intention by general practitioners. In the event of legislation coming into being in New South Wales, and that's been ably discussed today about what that would look like. But my question to you both is, you obviously have some dealings on a regular basis with people who are involved in working with GPs, or in fact yourselves may be working with GPs and have observed a lot through your respective experiences. But there's this very important matter of decision-making properly understood under the legislation to make a decision around whether a person wishes to go down the path of voluntary assisted dying. And this significant matter in play about coercion and what coercion might be and might look like, or might not, or might look like, as the case may be. But the issue of coercion. And there's no disagreement that no one believes that there should be any coercion associated with that decision. I mean, it would turn the whole act upside down. It would be no longer voluntary. I'm wondering, from your own respective experiences as organisations, whether you could quickly comment on the matter of the challenges that may exist or do exist with respect to identification of coercion or potential coercion of an individual making a decision, particularly a person at the end of life, perhaps a person who may have not all their faculties, may be suffering enormous pain, etc. The possibility of coercion and the possibility of that happening just would be helpful to inform us about what your experiences are.
I'd say as a clinician of 35 years in palliative care that I haven't seen evidence of that level of coercion at all, to be honest. I think what I see at times is the desperation of a person living with a life-limiting illness and the distress they believe that the care they require from often a single carer is enormous. Now, I don't think in reading the bill that would be defined as coercion, but at all. So, and I only have a small avenue within the dementia area, so I'm not going to comment on that particularly, but I don't see that coercion in my practice, particularly over many years. Now, of course, that's been without the context of a looming VAD bill. So I think it's something that I think all health staff now need to have some healthy understanding of, to in fact, reflect on what they may or may not observe in the future.
Might they go to questions of defining what that is? Or could look like?
I'd invite you, Deputy Chair, to put those on notice, because we are already over time. So,
okay. Ms. Hanson, quick answer?
Yep. Look, I think it just goes back to really, for me, it's about providing better support and education ongoing for GPs. I think GPs need to, and it in fact goes to education from undergraduate education about end-of-life care, communication, pardon me, and training.
It's okay.
Sorry.
You take a drink. We are out of time, and I'm sure the Deputy Chair can put some more questions to you on notice if required. For those witnesses who have taken questions on notice, the Secretariat will be in contact with you to see those tabled. And I would like to thank all the witnesses for appearing today. We'll have now a lunch break, and we will return at 1:30 p.m. Thank you. Well, welcome to the afternoon session of the hearing today, and I'd just like to welcome our witnesses. I'll start with the witnesses in the room. If you could please state your name and position title and swear either an oath or affirmation, and I'll start on my left.
I'm Dr. Chris Abu, and I'm the Policy and Project Manager of PM Glynn Institute, the public policy think tank of the Australian Catholic University. So, I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. And it's helpful for the witnesses in the room to actually bring the microphones nice and close so that your audibility is assisted to Hansard and the witnesses that are viewing online.
I'm Michael Casey. I'm the Director of the PM Glynn Institute at Australian Catholic University, and I work with Chris. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And online we've got Dr. Fleming. If you could state your name, position, title, and an oath or affirmation, please.
I am John Irving Fleming. I am a retired academic. I swear that all the evidence I give today will be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Dr. Fleming. Now we'll move to opening statements. Could I ask for the witnesses in the room, do you have a statement each, or are you combining your statements?
I think we both have a statement.
Wonderful. Well, I'll start with Dr. Abu, please.
Okay. Around a month ago, we did a study on access and equity of palliative care in regional and remote New South Wales. So we wanted to look at equity and access. In doing so, we analyzed one of the primary considerations of access and equity, which is the workforce. Our underlying question was really, were there any palliative care service in regional New South Wales? And we look at a trend data from 2013 to 2020. That's 7 years. That's important to take note because we did not just do a one-shot, single-year analysis. And there were significant findings, which we have written in our submission to you. So foremost of this was, while the numbers of palliative care doctors have increased through the years in the cities, the regional areas, particularly the outer and remote regions. In those years, from 2013 to 2020, there was no palliative care services in most years. There were only 2 years, 2017 and 2015, which had around 3 in the outer regions, but the remote regions had nothing. So in the cities, the number increased. The number of palliative care doctors, in fact, increased from 68 palliative care physicians in 2013 to 100 in 2020. So in fact, the bulk of palliative care doctors were in the cities. More than 90% were in the cities. This alludes to what the AMA had said, the Australian Medical Association had said, that the absence of such service delivery has resulted in some very poor and sad outcomes for those in the regional and remote New South Wales. The second point that we made in that report was that while palliative care doctors in the cities work the standard hours of 35 to 40 hours a week on average, those present, although very small number in the regions, work for up to 70 hours a week on average. And they were older too. If you look at age categories, they were female and much older than those in the cities. Now, why is this important? This is consistent with what we had found out when we look at the national situation with palliative care services, and in our report that was published early this year. And we said there that these doctors are getting old, and they had said that around 42% of them are planning to retire in the next 10 years. So the implication is really on the absence of such services plus the continuity plan, the succession plan when these doctors actually retire. So the same situation is with the nurses as well. In major cities, we had many, from 568 in 2013 to 649 in 2020. But in outer and remote regions, for outer regions, there were only from 2 to 45 palliative care nurses. For remote regions, there was really none. So we looked at this in the context of, is there a gap in provisions? Is there an absence in provision? And clearly, we had in those years from 2013 to 2020. And our position is that these gaps must be addressed first and foremost before considering VAD.
Thank you, Dr. Abu. Dr. Casey.
Thank you for the opportunity to give evidence today. In the covering letter to my submission, I set out a public policy proposition. The proposition is that before a community decides to take a momentous step such as legalising assisted dying, governments and lawmakers should ensure that everything possible has been done to address the significant inequities in the provision of palliative care and in access to it. As you know, our submission includes an analysis of workforce trends for palliative care doctors and nurses in New South Wales, about which Dr. Abu has just spoken. This analysis highlights workforce shortages in palliative care, which means, of course, significant inequities in the provision of palliative care and in access to it, particularly for people living in outer, regional and remote areas of the state. The proposition that before contemplating the legalisation of euthanasia and assisted suicide, we should focus our energy and resources on doing everything possible to ensure access to high-quality palliative care for everyone who needs it, irrespective of where they live. This proposition is based primarily on the momentous changes which the legalisation of euthanasia entails for our shared values and for both the function of our laws and the practice of healthcare. The nature of these changes is perhaps encapsulated in Part 9 of the Voluntary Assisted Dying Bill. These clauses provide protections from criminal and civil liability and from any sanction under the professional conduct principles for health practitioners and other people who, in good faith and in accordance with the provisions of the bill, provide assistance to people in accessing assisted dying. These protections extend to ambulance officers and other qualified people who do not administer life-saving treatment to someone who's dying as a result of accessing the provisions of the bill and who does not request the administration of life-saving treatment. The necessity of these provisions follows logically, of course, from the purpose of the bill. If euthanasia and assisted suicide are made legal, it would defeat the purpose of such a law and be unfair if those who assisted people in accessing assisted dying were then subject to criminal or civil penalty or a professional misconduct process. The point, however, is not about what's logically required if euthanasia is legalised, but where this logic takes us. Protecting people, all people, including the weak and the vulnerable, from having their lives taken from them or ended prematurely is the cornerstone of our laws. Caring for people when they are chronically ill or dying, with no intention of causing their death, and trying to save people when they've been hurt are, of course, fundamental principles of our healthcare system. These fundamentals are not going to be abolished by the legalisation of euthanasia, but the fact that euthanasia can only be made legal by creating an exception to the otherwise unconditional prohibition on deliberate taking of life and an exception to the fundamental purpose of healthcare based on doing no harm demonstrates how we enter radically new territory with assisted dying. Proposing that we focus on making high-quality palliative care available to everyone who needs it, people with chronic illness as well as people nearing the end of their lives, children and adolescents as well as adults and the very old, people in the major centres and people in the remote parts of the state, is not to claim that palliative care is the solution to all suffering. Rather, it is to suggest that before we start experimenting with exceptions to the law's prohibition on deliberately ending someone's life, and healthcare is imperative to help and never harm, we should see what difference universal access to high-quality palliative care can make for those who are suffering and dying. As a matter of prudence, precaution and good public policy, consideration of euthanasia should only arise, if at all, once the possibilities of palliative care have been made universally available and the evidence of its impact on end-of-life care and the experience of patients at the end of life has been analysed. A further reason for pursuing this course rather than the legalisation of euthanasia arises from the emphasis placed on choice and autonomy, both in the principles of the bill in Clause 4 and, of course, in public argumentation in support of assisted dying. Some amendments to the bill have helped to raise the importance of access to palliative care. As our analysis shows, however, much needs to be done to ensure the same level of access to palliative care for people in outer, regional and remote areas as for people in the major cities. As noted in our submission, the bill places some emphasis on ensuring that people in regional areas can access voluntary assisted dying. For example, Clause 1742 also requires the Health Secretary to include in the access standard specific information on how the Ministry of Health intends to facilitate access to voluntary assisted dying for regional residents. However, if people in regional areas do in fact attain the same level of access to assisted dying as people in the cities, without also having the same level of access to palliative care, can this really be described as something that respects choice and autonomy? Unequal access, in some cases no access to palliative care, paired with equal access to assisted dying is not a real choice. How does offering this sort of choice respect the dignity and autonomy of gravely ill people at the end of their lives? As I say in the submission, it's a false choice, one that is unjust to offer, particularly to people who are suffering terribly. The legalisation of euthanasia and assisted suicide is dangerous and wrong because it authorises the deliberate ending of a person's life, either by themselves or with the assistance of others. It represents a tectonic shift for our society, our institutions and our shared values. Laws, of course, are a matter for Parliament and legislators to decide, but this step should not be contemplated before everything that can be done to enhance the care of people with terrible illnesses or at the end of their life everywhere in our state has been done. We continue to be a long way from achieving this. Thank you.
Thank you very much, Dr. Casey. And before I go to Dr. Fleming, I'll just, and I didn't want to interrupt you, Dr. Casey, while you were making your opening statement, but we had some discussion this morning about terminology, and it was made clear that this bill isn't euthanasia or suicide, it's voluntary assisted dying. So some people may or may not understand the differences, but it's just that terminology and that that we've adopted. So,
you're providing some view. I've got a different view that I'd want to put forward.
Deputy Chair.
Well, the individuals, I can't speak for the third one yet, have made submissions to this inquiry, along with a number of organisations and individuals. Many have. And replete throughout many of those submissions, is the use of words euthanasia and assisted suicide.
And in fact, we heard evidence of assisted killing on Friday.
Yeah, and physician-assisted suicide.
I just don't think it necessarily helps their case, but I think they can use any term they like.
Well, that's my very point. See, the idea that witnesses to this inquiry who've presented today are being told they can and can't use certain words and phrases, I have to say to you, I find very distressing. Very distressing. The language is clear in their submissions.
Well, I'll take a point of order. If Mr. Donnelly is taking a point of order, that's fine, but now is not the time for speech making. So,
I heard it as long as you like here. The idea that witnesses appearing before this committee...
Well, I'll take the point of order again. Now's the time to question these witnesses. Okay. And Mr. Donnelly making a speech does not advance the cause of anyone.
Well, as long as the witnesses are not going to be treated that they have to proscribe certain words
well,
and
I
terms.
have joined in with you, and I agree with you, Greg. Okay. They can use whatever term they like.
As long as that's clear.
On that note, I'll now pass to Dr. Fleming for an opening statement.
Members of the Standing Committee on Law and Justice, the case I brought to your attention in my written submission may be simply expressed in the following propositions. Firstly, that Division 2 of this bill, which enunciates the ethical principles upon which this bill relies, is seriously in error. The bill asserts that every human life has equal value, but makes no reference to the inalienable right to life. Nowhere does the bill tell us what this equal value is. That can only be stated based upon what the Universal Declaration on Human Rights, which we in Australia have agreed to, describes as the first human right, namely the right to life. The bill asserts that a person's autonomy, including autonomy in relation to end-of-life choices, should be respected. Why should this be so? The bill doesn't tell us the answer to that question. Why should anyone respect a person's autonomous decision to drive a car under the influence of drugs, including alcohol, or to defame another person, or to defraud the government? The elevation of autonomy over all other considerations is a novelty in our culture and legal system, runs counter to laws in relation to our system of criminal justice, and defies common sense. The first human right, which governments are duty-bound to protect, is the right to live. Without that right, we have no rights. That entire Division 2 runs clear counter to the fundamental duties of the Parliament to the citizens of the state. According to the Constitution of the State of New South Wales, first paragraph of Section 5, the legislature shall, subject to the provisions of the Commonwealth of Australia Constitution Act, have power to make laws for the peace, welfare and good government of New South Wales in all cases whatsoever. Well, the first duty of parliamentarians, as everybody knows, is to secure the citizenry from threats to their peace and security. Threats which may come from outside the country, threats which may come from within. The United Nations Bill of Rights makes it clear that the right to life, the sine qua non of all other rights, is an inalienable right. This means that we cannot alienate the right to life. An innocent person's life may not be taken away, and nor may citizens give away their right to life. A parallel case is that of the human rights to freedom and autonomy. No one may sell themselves into slavery even if they want to. The state cannot in any way legalise the slave trade. No one, Article 4, no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms, says the UN. In the same way, until now, we have prohibited the homicide of innocent persons even when they want to kill themselves or helped by others to do so. Assistance in dying is a euphemism, and the reality of it is that it is suicide and is self-killing. Making legal exceptions to the law against killing fellow innocent citizens compromises the capacity of the state to protect the lives of all its citizens impartially. People, politicians included, may legitimately disagree on whether euthanasia or physician-assisted suicide is morally right or morally wrong. It doesn't follow from that disagreement that this bill should be passed. Parliamentarians need to set aside their personal moral opinions and look at the evidence before making public policy. The issue at stake is the inalienability of the right to life and the duty of the state to protect impartially the rights of all citizens, and especially the weak and the vulnerable. There is a superabundance of evidence to show that voluntary euthanasia and physician-assisted suicide are accompanied by as many or a very large minority of cases involving the killing of patients without their knowledge and consent. I ask you not to be swayed by emotional appeals to hard cases, which can be ameliorated by good palliative care. I ask you not to ignore the overwhelming evidence of people being killed without knowledge and consent whenever there is a practice of euthanasia. The existence of such abuses should persuade you that you cannot safeguard the rights of citizens once the obligation of government to protect the personal security of the citizenry is in any way attenuated. There have always been doctors who think that the law doesn't apply to them, and I refer you to pages 6 to 13 of my submission. The state cannot supervise acts carried out by doctors, since firstly they're done privately, secondly doctors will not always fill out the forms accurately or even at all, and thirdly there has been and still is a long history of many doctors and nurses protecting each other from accountability when things go wrong. Moreover, if some doctors are prepared to break the law on homicide now, and oftentimes without the knowledge and consent of their patients, why would anyone imagine that those same doctors will be any more law-abiding once a bill like this is passed? It is beyond delusional to imagine that this bill will in detail be followed by healthcare practitioners. What the bill will achieve is a protection of the medical profession. If you must persist with wanting to provide a place for people to go who want to be killed or assisted to kill themselves, then it should not be doctors who do the killing in violation of the Hippocratic tradition. Instead, appoint a special class of persons, such as the executioners where capital punishment is concerned. This special class of persons cannot call themselves doctors or healthcare practitioners, call them what they are and let the deed be done in facilities which are not hospitals, aged care facilities and the like. Approving killings as a medical act by bona fides healthcare practitioners stops the accountability of the medical killings which we saw in Germany in the Weimar Republic well before the coming of the Nazi regime. We may each of us differ as to whether euthanasia or physician-assisted suicide is morally acceptable, but this bill needs to be faced fairly and squarely as a public policy issue, not an issue driven by stories of hard cases and personal ideologies. I conclude using the words of the New York Task Force on Lifeline and the Law. Some task force members do not believe that assisted suicide is inherently unethical or incompatible with medical practice. On the contrary, they believe that providing a quick, less prolonged death for some patients can respect the autonomy of patients and demonstrate care and commitment on the part of physicians or other healthcare professionals. Nonetheless, these members have concluded that legalising assisted suicide would be unwise and dangerous public policy, and voluntary assisted dying is simply a euphemism for what we would ordinarily call suicide, assisted suicide, and even euthanasia.
Thank you, Dr. Fleming. We'll now open for questions, noting that we've got about 20 minutes. Looking round to the committee members to see who would like to kick off the questioning. Deputy Chair.
Thank you. And thank you all for joining us today. Appreciate it very much. Thanks, first of all, for your submissions and an opportunity to provide some supplementary information through your oral evidence today. In terms of the research, perhaps first if we start with that, from both of our representatives from the PM Institute, can we perhaps start from this preliminary point of actually asking what is the general quality of the information that currently is able to be looked at and studied about the provision of palliative care, specifically in New South Wales. In other words, you've done some work, you've referred to some previous research, but the starting point is what is that information out there and your views about that information to enable one to move towards some reflections and conclusions which you've done in your report.
You're asking about the quality of the data?
Yes, what's out there to help us understand, yeah.
Well, these are data from the Department of Health and the Australian Institute of Health and Welfare. So we just collated and accessed their raw data. So it's very, there are problems in terms of consistent reporting, but it does not negate the fact that the insights from what those data or information are giving us is correct and significant.
Yes, so. I was going to come to the matters of reflections and conclusions in due course, but we've had evidence from other witnesses, even earlier today, I have to say, that have reflected that the detail and information that's readily available to make judgments and assessments about the provision of palliative care is somewhat sketchy and very general in its nature. And the reason I'm asking the question, because if this legislation is to proceed, and I've noted specifically, as I'm sure you're aware, and Mr. Casey's referred to this in his, Dr. Casey, I'm sorry, referred to this in his opening, well, actually it's in the actual cover letter to the submission, specifically with respect to the references of some of the principles in Clause 4 of the proposed legislation, specifically for 1D, which is, and these are underlying principles for the legislation about the provision of high quality care, including palliative care. Then jumping down to H, which is also referred to the issue of genuine choice, and I, with respect to consideration for regional residents. So all that comes together. So on the New South Wales Health information you're able to gather and interrogate, was that satisfactory for you to draw some of the conclusions, or it was? Okay.
It was, because they had published data in the reports, but that's not where we got the data from. We asked them, and particularly AIHW, to access the root data in their, it's unpublished, but we were given clearance to access it, so we actually accessed the rawest of data and then analyze it. So these, in the submission that we gave to you, all the data there are not published yet. Because if you look at their reports on palliative care, it's just national figures, but they did not go into nitty-gritty on regional and remote New South Wales by state. So what we did at PM Glen is to ask for the permission to access the raw data, and from there draw out what belongs to New South Wales. What's the picture in regional New South Wales? So it's the first time that I actually published this information, but yes, it is very, because it comes from the what they call table builder, which has the raw data, and we collated it and analyzed it. Yes, it is. It has data integrity, if you have to say it.
Using an analogy, one can go to the Australian Bureau of Statistics and make application to access specifically drilled down granular data that's otherwise not published, and use that to conduct your own research. That's effectively what you've done.
Yes.
Can I, because I've got to share the questions around, with respect to the ageing population.
Don't feel there's any rush.
No, I've got some.
Yeah.
I will.
Yeah. With respect to the ageing population of our doctors and nurses in New South Wales, something that we do hear about from time to time. You've picked up some commentary on that in your report about
on average, they were around 50 years old and above, and this coincided with our national finding, which we did in another report, that doctors were saying, we're about to retire in 10 years' time, so who will take over? So the question of who will continue their work, considering also the small number of palliative care physicians available. So that alone is a problem. And if we are saying that in the regional areas, there's much wider gap between the number of palliative care physicians and nurses in contrast to cities, then all the more it becomes a problem. There, in the 7-year period that we were studying, only 1 year, I think 2015, had a palliative care physician in the remote region. The rest of the years it's zero, as well as the outer region. In the inner region, there were a few, but most were city-based.
And with respect to nurses, palliative care nurses, was it? I think that was made up in your, or reflected on in your opening statement. That was the case as well.
That's the case as well. 0 for regional, especially the outer and remote regions, while you have a number in the cities. I think the problem also is enticing, and it has been said in many reports, enticing the uptake of physicians who specialize in palliative care. So that's a big problem as well. So our position really is, if there's 0 there in outer and remote areas, there's really no choice, right? Because choice assumes that you have an alternative. But it seems like there is no other alternative because it's blank, it's absent.
Okay, thank you for the moment. Yep.
The Honourable Trevor Khan.
Dr. Casey, I take it that your doctorate was in sociology?
Correct.
And your undergraduate degrees were in law and arts?
That's correct.
So you're not a medical practitioner in any shape or form?
Certainly not.
So your assessments on the capacities of palliative care and the like are based on, in a sense, second or third hand information?
Well, they're based on, as Dr. Abu has explained, they're based on analysis of data sets which various instrumentalities use to report on provision of palliative care and access to it.
Well, we'll just talk about that. You're aware that we had nurses who came along to give evidence to us?
Yes, I am in general, yes.
Right. Well, I'll read you a little bit of what Ms Fleming, who's a nurse who works, I think, for 10 years in palliative care, said to us in evidence, and here we go. There are occasions where patients' suffering cannot be relieved, whether that is emotional suffering, whether it is physical suffering through symptoms of pain, breathlessness, or nausea. It's really hard. There have been a lot of cases recently where people's suffering has not been able to be relieved, even with really high doses of opioids. It is very distressing for the patient, for the family and the staff. Indeed, in another part, another nurse made the observation, as referenced in our submission, this is Ms Candish, to this committee, a recent survey of almost 4,000 members found that more than 85%, that's of the members, are in support of voluntary assisted dying reform. Meanwhile, 84% indicated having professional experience in providing care to terminally ill patients, and over half of those have been asked by a patient for assistance to end their life. And what I essentially, Mr. Casey, Dr. Casey, I want to put to you is this. It seems to me that your argument is, well, under no circumstances should there be voluntary assisted dying, but if there is, we should wait until some indeterminate time in the future when somebody determines that there is adequate palliative care across the state. Is that a reasonable summation of your position?
I think the position, as I said in my opening statement and in the covering note to our analysis, Dr. Abu summarised for us very nicely. If a lot of the argument for assisted dying is about choice, there has to be an alternative. And all we've done is look at the data to see just how well Australia is served in terms of palliative care services. And looking at published data and other data collected by government instrumentalities, we've found and highlighted that actually there's quite a long way to go in making sure that everyone who needs high quality palliative care has access to it. It just seems to me.
Point of order.
I'll hear the point of order.
Well, we know we don't talk over a witness who is answering a question.
Sorry,
Mr. Casey.
if I've talked over Dr. Casey,
Well, I'll allow Mr. Donnelly to finish his point of order.
Yeah, thanks very much. Mr. Casey clearly hadn't finished giving his answer.
Dr. Casey.
Dr. Casey. So the witness must be permitted to complete his answer.
I'll uphold the point of order. Dr. Casey, you have the call.
Just to finish by saying, as Dr. Abu highlighted, if there is to be a choice, there has to be an alternative. Our concern with palliative care was just to see whether, to what extent it is actually equitably and generally available for people. We've discovered, looking at the published data, that it's not as much as we would like it to be. So it does seem to be, there's a threshold question about whether, given the absence of choice for people when it comes to end-of-life care or care with chronic illnesses, that it seems like a big jump to sort of go straight to assisted dying when there is still much to be done to actually relieve people's suffering, which could make a significant difference to people who are suffering chronic illness or at the end of their lives.
Dr. Casey, just on that point, and to it's a question that the Honourable Trevor Khan was asking, if the provision of palliative care was 100% across the state, gold standard, would your organisation be in support of voluntary assisted dying?
No. As I mentioned, perhaps I think in my covering letter, I think there are other reasons still to have reservations about and objections to assisted dying. But it seems that if legislators and parliaments are to move in that direction, the appropriate threshold to approach it from is one where there is more or less universal access to quality public palliative care for everyone who needs it. Because it seems then that everything that we can do to help people who are suffering within the parameters of our existing approaches to healthcare and law, everything that can be done has been done, and that then might be, as a matter of policy, an appropriate threshold to then consider something which goes in a different direction.
Because his issue I've got...
Just hold on. So, Dr. Casey, does that mean that for those patients, terminally ill patients, who, even with the assistance of the best palliative care, are suffering unbearable pain and suffering, the answer for them at the present time by you is, well, you're just going to have to grin and bear it? That's the consequence of your proposition, isn't it?
I'm sure with everyone in this room, I don't want to see anyone suffer at all, least of all at end of life, least of all from some sort of terrible or intractable illness. I think no one wants to prolong that sort of suffering or see it go untreated or unmediated. But I think the fact of the matter is, with assisted dying, there are consequences for us as a society beyond the immediate relief that such a measure might give to a particular patient. And I mean, with the greatest respect, I'm sure you understand this better than I do. Of course, legislators and lawmakers have to attend as well to the social consequences or the broader consequences for a community, as well as to how we best look after those who are vulnerable or suffering.
Well, do I summarise that, Dr. Casey, by saying you agree with the proposition? It just means that some people will have to grin and bear it.
No, I would not put it that way at all.
May not, but that's the natural outcome of your proposition.
Well, it's point of order. I mean,
I'll hear the point of order.
I mean, just because you don't get the answer you want, Trevor, the proposition is that Dr. Casey agrees with the proposition that people grin and bear it. Now, I think from the answer, in fact, sequence of answers he's given, there isn't the wildest suggestion in the tone and the way in which he's communicated it to the committee. Now, let me finish, please.
Excuse me. No, Deputy Chair. One thing, I had not said a word.
You're about to cut me off.
I was about to uphold your point of order, but okay, continue, please.
Okay. So, with respect to Dr. Casey,
I just upheld your point of order. That was my point. Dr. Casey, continue, please.
Thank you. Mr. Khan, with respect, you offered an interpretation of my comments. That is not an interpretation that I would adopt or accept.
So what do you say we should say to Abby Egan, whose partner Jade died in the following circumstances? This is what Abby Egan said. I want you to remember that we are talking about a 32-year-old woman at this point. We're not talking about someone who is 80, not that that is any better, but at 32 years of age, this is not something that she should have gone through. She had a permanent catheter in to help her go to the toilet. Because of the pain medication she was on and because of the tumours, it was impacting her bowels so much that she wasn't able to go to the toilet that way, so she would end up vomiting her own faeces on the regular. The way that her tumour was positioned in her body, when I would have to change her, parts of her tumour would fall out from her, which was horrendous for everyone involved, especially Jade, obviously. The tumour was so large in her back that it cracked her vertebrae. In terms of her being in bed, when we would have to move her so she wouldn't get bed sores, trying to roll her over, she would scream in absolute agony because of the cracked vertebrae. You could only imagine. Dr. Casey, is that the sort of person who should not be assisted by a voluntary assisted dying law?
Point of order. Point of order.
I'll hear the point of order.
I think in all fairness, Dr. Casey, he is entitled to read the full transcript with respect to that witness and what that witness had to say, along with, if he wishes to do so, 2 other witnesses on that panel, and consider the full and totality of what got said before he answers the question, if he wants to take it on notice.
I was about to say,
I'll respond to that. That is an accurate description. That is an absolutely accurate description. I could read more in terms of the death of Jade, but for a point of order to be taken,
yes,
this is the style of person that we're dealing with here.
Start the table, Trevor, please.
This is the style of person, and for Mr. Donnelly to be running cover on these matters is appalling.
Well, I won't. Well, no. I'm not going to respond to that taunt.
No. Look, we've been very good today.
Yeah.
And we are not going to descend at this late hour. Whilst I accept Mr. Khan's point, I will allow Dr. Casey to either answer the question as Mr. Khan has asked, or if he feels that he needs further information, I would ask that you take it on notice. Although I can confirm that Mr. Khan has read the transcript verbatim.
Only with respect to that paragraph.
Oh, I'm happy to read more. If that assists.
I would order. This is not helpful today. Dr. Casey.
No, I'll read more. I
want you to go to the start and start at the very beginning, if that's what you want to do.
No.
The witness is entitled to know the full evidence.
First of all, I want to say that I'm incredibly honoured to be here, said Ms. Egan. It's not every day that you are asked to come and talk about life and death, and such a good death, in hopes that after we are here talking about our loved ones having a bad death. I think it's really good that you guys can talk about the safeguards and the legislation and the hoops and the paperwork and everything you need to do. But I do not think you guys would have to have been able to have the full picture of what this bill would mean to people unless you were to meet people like us who have had their loved ones go through this. My partner Jade was diagnosed with cervical cancer in March 2017 and ended up dying in October 2018. So she lived for 18 months. Jade was misdiagnosed for 12 months in the lead up to receiving that diagnosis, which means that when she was finally diagnosed, it was pretty progressed. She was stage 4 and we were told that she had 12 months to live from then, so it was fairly downhill from there. Jade was probably the best person I have ever known. Her family and friends love and adore her, and still do. She, and from the get-go, was a real advocate in terms of wanting voluntary assisted dying. I think because she was so sick from the get-go, she knew that this was not going to end very well. In her journey of having cancer, she met other people with her disease and with other types of cancers who had died horrible deaths. And she really did not want that to happen to her.
In the last 6 months, her disease progressed so much and the tumours in her body became so large that it impacted her on a daily basis. She had up to 5 kilos worth of fluid in her legs a day, which was immensely painful. And no pain relief could relieve that towards the end of her time. She wanted to die at home. Unfortunately, I was able to grant that wish for her and make that happen with the use of palliative care. They were unbelievable, but again, could not relieve all of Jade's suffering. In terms of her emotional and spiritual suffering, which is just as important as physical pain, not only could her physical pain not be relieved, but her emotional and spiritual suffering could most definitely not be relieved at all. Jade's last week on this earth was nothing short of hell, not only for Jade, but also for her family and my family, who were here to watch her leave. She was so dosed up on pain medication that she was hallucinating and thrashing around on the bed. She did not know where she was or who we were or what was happening to her, which was immensely distressing, not only for her, but for us. I was going to give some gory details because I think it is really important that you hear it. Otherwise, it is like I said. You guys can have all the paper and all the facts, but until you hear the actual things, you do not really know. The tumours in her abdomen was so large that it was impacting her ability to use the toilet. So we had a catheter in permanently to help her go to the toilet. And then I read the other paragraph. I hope that assists you in your analysis, Dr. Casey.
Well, I'm happy to take the question on notice. I'd just like to say, obviously no one can read or listen to that evidence without being deeply moved and sorry for the terrible suffering that it describes. It's a horrible situation and a horrible picture. But I'm happy to take the question on notice, and all I can do, I suppose, in general is to say what I said before, that I realise just how strongly people feel about this issue, often exactly for experiences like this. But there are other factors involved for us to consider when we look at the possible consequences of legalising assisted dying for the rest of society.
Dr. Casey, I have no further questions.
Dr. Casey, Dr. Abu and Dr. Fleming, unfortunately we have just gone over our time, so I want to thank you.
Could I make one?
Dr. Fleming, if you, we are out of time, so
Yes, be very brief.
I'll permit you.
I want to ask us in relation to the lengthy speech just given to us about a particular case.
I'm going to take a point of order. Mr. Fleming doesn't have the right to just, take over. He's been given the opportunity for an opening statement. He's used that opportunity. The time has expired. We have other witnesses that we need to hear from. Time to move on.
Thank you. I'll hold the point of order.
We can put questions on notice.
We can put questions on notice. Thank you. The Secretary will be in contact with the witnesses to enable the tabling of questions that have been taken on notice, and I thank those witnesses for appearing today. Thank you. We'll have a very short break while we bring the next set of witnesses in. Well, welcome to the next session of the hearing today, and I'll welcome our next two witnesses. I'll ask, firstly, the witness in the room, if you could state your name and position title and swear either an oath or affirmation. Thank you.
Gregory Bondar, Family Voice Australia, New South Wales. I'm swearing on the oath, Chairman. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr. Bondar. And via the WebEx system, we've got Ms. van der Linden. If you could swear either, name and position title and swear either an oath or affirmation, please.
Sure. It's Branka van der Linden. I'm the Director of HOPE, Preventing Euthanasia and Assisted Suicide, and I'll swear the oath. Now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. We did just have a slight dropout with your system just then. It'll be fine for the moment. What we'll do is we'll monitor it and we'll see how we go. We may have to go to audio only and turn off the camera. Perhaps that may assist the bandwidth, but we'll see how we go during the opening statements, which I'm assuming you'll do one. But I'll first go to Mr. Bondar. I assume you've got an opening statement, and now's your opportunity to provide it if you'd like.
Okay, thank you very much, Mr. Chairman. I do have a short opening statement. Mr. Chairman, members, thank you for the invitation to voice our concern regarding the Voluntary Assisted Dying Bill, second print. Family Voice Australia is a non-denominational, national, pro-life, Christian-based organisation advocating on issues of family, freedom and faith. Family Voice has for nearly 50 years been calling for government to respect the sanctity of life, of all human life, in particular from conception. Whilst we oppose legalised assisted suicide on religious grounds, we do believe there are strong grounds for maintaining the status quo and hence a legal ban on voluntary assisted dying. The bill before the House is not only a bad bill, but also a dangerous bill, especially to those considering suicide, disturbed youth, the lonely and the depressed in our society. The bill will result in greater deaths through suicide, especially the young, as it legitimises death through state-sanctioned legislation. If the Canadian experience is anything to go by, we will see similar results in New South Wales. In 2016, Canada legalised euthanasia for terminally ill adults with 1,000 medically assisted deaths, which jumped in just 4 years to 7,595 in 2020. The source is Canadian Health. And now in 2021, under medical aid in dying, laws have been expanded to include non-terminal conditions, and as predicted, Canadian euthanasia laws will have an added mental illness provision in 2023. Is this the future for New South Wales? In the Netherlands and Belgium, euthanasia is now legal not only for those who are terminally ill, but also for those with mental illness. Whatever the euphemism advocates of the bill use, the truth of the matter is that voluntary assisted dying is actually death by assisted suicide. There is no dignity in dying. Ethically, death by any means other than natural cause and involuntary accidental causes is immoral and makes a mockery of the medical Hippocratic Oath. Like any government legislation, there will be loopholes, and this bill has so many unanswered questions that it really needs to be the subject of an in-depth government inquiry that also considers and/or clarifies the following, Mr. Chairman. Will due and proper consideration be given to Indigenous peoples? As a former Chief Executive of the Tharawal Local Aboriginal Land Council, I can attest to the fact that Indigenous people do not support assisted suicide. So much for Black Lives Matter rhetoric. Will the bill allow assisted suicide for prisoners? If there is support for voluntary assisted dying through legal injection, then those same advocates must surely approve of capital punishment through lethal injection. Will there be subsequent amendments to end the life through telehealth? Will legislation protect patients, for example, who have not elected to partake of voluntary assisted dying, against health funds that refuse to fund continued medical hospitalisation, which is the case in the USA at the moment? And does VAD nullify death insurance cover? Will New South Wales follow the Netherlands, where the Dutch government has approved plans to allow euthanasia for terminally ill children aged between 1 and 12? Will it be mandatory to be vaccinated if you want to undergo assisted suicide, given it is a medical procedure, which is now the case in Germany? I'm appalled to have read that New South Wales MPs have been urged not to add further safeguards to a voluntary assisted dying bill. It was said on Monday, I believe there is nothing uniquely special or vulnerable about people dying in New South Wales to warrant adding additional requirements and safeguards above and beyond those already in existence. That was dying with dignity. Mr. Chairman, the arguments in favour of voluntary assisted dying are insufficient to justify it. The bill places the burden of proof onto those who value life, which is unjustified. The fact is there does not seem to be a compelling reason or reasons why VAD should be legalised. This is a public debate. Government needs to be reminded that its primary role is to make public policy, including laws which protect the life and sanctity of its people. Australia is a signatory to the UN Charter on the Universal Declaration of Human Rights. These rights to life and liberty are inalienable rights, rights of a person which cannot be deprived by others or by the state, a right of which person cannot even deprive himself or herself. Finally, euphemism used by advocates of VAD try to make the unpalatable seem palatable. VAD euthanasia, and the term is used interchangeably by many, literally means killing according to any dictionary you pick up. Euthanasia and assisted dying are not the way to ensure a dignified and compassionate death. The choice should always be life. Whatever individual MPs consider to be morally acceptable, or what opinion polls may seem to favour, it does not settle the issue. A responsible parliament must attend to enunciating public policy which meets the criteria for responsible government, chief of which is the obligation to impartially and objectively pass legislation which secures for all people their rights to life and security, and especially for those who are most vulnerable. Any legislation which weakens the capacity of the state to protect its own must be voted down. Thank you, Chairman.
Thank you, Mr. Bondar. Ms van der Linden, I'll now offer you the opportunity to make an opening statement if you so choose.
Okay, thank you. Can you hear me okay?
Yes, we've got you fine.
I'd like to thank the committee for allowing me this opportunity to appear before you this afternoon, and I'd like to particularly thank the parliamentary staff for their very able assistance to me in all matters administrative leading up to this. HOPE has 25,000 supporters nationwide. We work with medical professionals, disability advocates, palliative care specialists, multicultural and ethnic groups, religious organisations, lawyers and academics, and others opposed to euthanasia. What unites us is a desire to relieve the suffering of those approaching death by ensuring that everyone has the best end-of-life care possible, no matter where they live. The current inquiry being conducted by the Health Portfolio Committee in New South Wales has already uncovered the unequal access to healthcare, including palliative care, and a lack of GPs and specialists in regional, rural and remote parts of New South Wales. Deficiencies in healthcare mean people are currently not able to access basic end-of-life services, and treatment should be addressed as a priority. Death is a deeply personal matter, but it's not private. It has a profound impact on those close to the dying person and broader cultural implications. A society that accepts the view that some lives have become too burdensome eventually becomes a society that abandons those most in need, and ultimately the choice is available to those at the end of life. In countries where euthanasia or assisted suicide has been legalised, Categories of people who are eligible to be killed are expanded. Affordable care is denied to those who would otherwise want to live, and those tasked with enforcing breaches of legislative safeguards are unwilling to do so. These laws reduce choices for people like Stephanie Packer, a mother of four from California. In 2012, when Stephanie was 32, she was diagnosed with scleroderma, a rare condition that involves the hardening and tightening of the tissue. She was given 3 years to live. In 2016, a week after California's assisted suicide law came into effect, Stephanie received a letter from her insurer that told her that her life-extending treatments would no longer be covered. California law prevents insurers from denying insurance coverage for treatment in the same communication as it provides information about coverage for assisted suicide. The patient has to initiate the discussion about assisted suicide coverage. When Stephanie inquired, she was told that while it would not cover her chemotherapy, her insurer would cover assisted suicide drugs for a payment of $1.20. It almost forces the poor people, the sick people, the scared people, the people who are alone, to kill themselves because what other choices are they given, Stephanie told Hope. When California passed this law, they took away my choice to live. I'd like to briefly clear up some misleading information put to the committee so far. The claim that 20% of suicides in people over 40 are associated with a terminal or debilitating illness has been repeated several times. The National Coronial Information System report from which this data is taken tells us that this included reduced mobility and inability to work, a requirement for nursing home admission or other suffering. Many would not be eligible for assisted suicide under this bill. The report goes on to say that the data does not indicate that the condition suffered was the sole or even primary contributing factor to the deaths, nor does it infer a correlation between the condition and the self-harm. There is no justification for concluding that these deaths would not have occurred if assisted suicide was available, and the committee should take note of the full report in its deliberations, not just extracts provided by activists. The second misleading claim is that the expansion of laws in other countries is not relevant to the Australian situation because of several distinguishing features contained in, for example, the Canadian legal system or the wording of euthanasia laws in the Benelux countries. The conclusion we're being asked to reach is that the Australian parliamentary and legal system is so different from these that our laws will be immune from expansion. That we don't have a Bill of Rights in Australia does not mean that the laws won't change. Activists will just use whatever legal means are available to them in this jurisdiction to challenge existing laws. We already see it happening in Victoria, with proponents recharacterising Victoria's safeguards as barriers to access. Finally, references to the established law in Australia grossly overstate the tried and tested nature of euthanasia and assisted suicide laws. The Victorian legislation has been operating for 2 years, and the West Australian regime has been in place for 6 months. The voluntary assisted dying board in each jurisdiction only publish minimal data based on information provided by the very people that they are policing. End-of-life choice occurs with heavy investment in health and palliative care services, particularly in regional and remote areas, increased education amongst doctors and patients about palliative care and advanced care directives, and good communication amongst healthcare providers so care is holistic. New South Wales has an opportunity to show true leadership on this issue and legislate to care for its terminally ill, not to abandon it. Thank you.
Thank you, Ms. van der Linden, for that opening statement. I'll now turn to the committee to see if there's any questions from committee members. And, the Deputy Chair, I suspect, will have...
Yeah, thank you.
Call.
Thank you very much, and thank you all for making yourselves available today, and thank you in the first instance for your submissions. Ms van der Linden, if I could go to you first, please, and take you to your submission, which I presume you've got a copy of close by or within reach.
Yep.
So it's got a cover letter on page 1 and the submissions attached, dated November 2021. Can I take you to page number 4, where on page number 4 in fact, going over to top of page number 5, you make some comments and reflections about concerns with the bill, specifically with respect to the matter of coercion. So I take what you've got there, it stands as read, and we understand that. But can I invite you to elucidate any particular aspects of this part of your submission that deals with your concerns, or more to the point, Hope's concerns about coercion with respect to a person provided for a framework for voluntary assisted dying as provided for in the bill?
Sure. Well, the bill itself, in its principle, states that there is a need to protect persons from coercion or who are operating under pressure or duress. But the way that the bill is drafted actually doesn't make it possible for this to occur, and we're very concerned that coercion won't be detected by the doctors who are assessing patients under this bill. Coercion is an extremely difficult thing to detect, and in the legal profession, of which I'm one, it's a very important skill, but it's really difficult to detect. It can be overt, it can be subtle. We know that, say for example, parties entering into a contract need to do so freely. If it can be found after the fact that there was pressure to enter into the coercion, the contract will be found to be unenforceable. Similarly, say with somebody's last will and testament. And then what the legal parties are restored back to the situation as if they hadn't entered into the contract or they hadn't made their last will and testament. In the case of assisted suicide, though, a failure to detect undue influence is not capable of being restored back to the position that the parties were in before the decision was made, because the person will have died. Coercion can be suggested, it can be implied. People feel a burden that all of us don't want to be a burden on anyone else, and particularly elderly parents, grandparents. The smallest remark made by a family member, even the thought that my daughter finds it a little bit hard to care for me, could make me feel that perhaps I should take this option.
Following on from that, and with your legal experience, and with perhaps other learned minds around the table here who have legal backgrounds can sort of help us here as well. In terms of understanding the way in which the law, I say that the law as a statement can protect a person, an individual, from coercion. How does the law generally do that as a statement of explanation? How does the law protect against coercion?
I'm going to take a point of order. So
I'll hear the point of order.
Is Miss van der Linden here as an expert legal witness? I don't think she is. Why are we asking her for legal opinion? That's not the capacity that she's appearing before this inquiry.
For the point of order?
I'll hear the point of I'll hear you.
It's my question. I can ask questions as I see which fit within the remit of the inquiry, which is the inquiry into the provisions of the bill. The matter of coercion, it has been covered on numerous occasions over the last 2 days of public hearing.
I'm prepared to rule in your favour, Deputy Chair, and I do so. Ms van der Linden, did you indicate that you had a legal background? Was that what I
do, yes, I'm a lawyer.
So in that respect,
would give us some details about her legal
point of order.
Yeah, no, Mr. Diadam, I'm ruling in. I'm ruling in favour of the Deputy Chair. The Deputy Chair can ask the question. I'm prepared to accept the bona fides of Ms van der Linden, and the Deputy Chair can continue.
Thank you very much. I'm happy to repeat my question if it's necessary, but I was...
could you...
Yes. So the matter of coercion is raised in your submission on page 4 going on to page 5 is quite a significant matter that's exercised the mind of Hope in the preparation of their submission. We're talking about what coercion may look in the context, or potentially look in the context of interfacing with this proposed bill or the proposed legislation. You've already talked about potential overt or covert or obvious or less than obvious coercion. We understand that line. But my question is, in terms of the law, how does the law, as broadly stated, deal with identifying coercion as a general proposition?
Can I say I'm not an expert on this area?
That's okay. That's okay. And you can take it on notice if you want.
Look, yeah, I might take that on notice rather than wasting everyone's time.
No, that's just fine. No, that's just fine. Can I take you then to page 7 of your submission, and at about point 5 on the page, the heading, very little detail recorded by the Voluntary Assisting Dying Board. You see that heading?
Yep.
Now, I won't read it out, but you make a particular salient comment, I thought, there, about noting what is provided for as requirements of information with respect to the proposed New South Wales legislation and the Voluntary Assisted Dying Board. And the state of Oregon in the United States, which often receives some comment and reference in the course of discussions around this style of legislation. Your understanding is that in Oregon there is a range of other, I'll use the phrase, pieces of data that are, or fields of data collected as part of their data collection with respect to their particular end-of-life legislation?
Yes.
And with respect,
yes, that's correct.
Yeah, and with respect to the collection of those particular matters, psychological assessment, and I won't read them all. I mean, have you formed a view about whether you think a collection of similar data may be relevant, or would be relevant perhaps, in the context of the debate we're having in the Legislative Council about the current provisions with respect to board information that's collected?
I think it would be very prudent to have much more data collected about this regime. So at the moment, as far as I understand, the bill only requires the person's relevant disease or illness, their age, and whether they live in regional New South Wales. If as a society we're going to track this, we're going to really ensure that people are not falling through the cracks, we're understanding who's taking it up, relationship with their physician. It would be so helpful to be able to collect statistics such as this, especially when it's combined with the fact that certificates are falsified under this bill. So we have, the way the bill's drafted at the moment, the person is said to have died of their underlying illness or condition rather than by way of euthanasia or assisted suicide. So down the track, we'll have no way of knowing apart from the data that's collected by the Voluntary Assisted Dying Board.
I've got some more questions, but perhaps others might not have questions.
Thank you, Deputy Chair. I'm just going to look around the room to see Mr. Farlow has indicated he'd like to.
I also have.
And Mr. Khan.
Thank you very much, Chair, and thank you very much, Mr. Bondar and Ms van der Linden, for being with us today. Ms van der Linden, just wanting to turn to something I found relatively concerning in your submission, if you've got any further detail on, which is at page 16, which is with respect to doctors being very rarely prosecuted for breaches. You make the claim in there that in Quebec, 62 deaths were deemed by the Commission of End-of-Life Care to have been a result of abuse by the doctor who prescribed and administered the lethal injection, but none was recommended for prosecution. Do you have any further information you could share with the committee with respect to that and the reasons that there was no action taken in those instances?
I couldn't speak to the reasons no action was taken, but that is the case. And that's from the government's own reports. The fact is that there's very, very little prosecution of any decisions made, no matter what country you look at, after the fact when it comes to prosecuting doctors. In the Netherlands, we saw the case of who had written a living will and said that she would like to receive euthanasia when the time was right. She had dementia. As it transpired, she went into a nursing home and there was a decision made by the doctors that perhaps it was time for her to receive euthanasia. So the doctor gathered her family around, put a sedative into her cup of coffee, and when the woman resisted, the doctor asked the family to hold her down while she administered a lethal injection. This went all the way to the Dutch Supreme Court, who ruled that this was within the law, within the Dutch law. Very, very rare to see a prosecution of a doctor in any jurisdiction. And in fact, I'd go so far as to say that the laws are drafted in such a way that the safeguards protect the medical professionals, not the patients themselves.
And just one further question. With respect to the Voluntary Assisted Dying Review Board, you make the criticism that there are no medical specialists who are required to be on that board, and I think refer to actually the Khan Bill of 2017 with respect to its requirements. I'm honoured. That was a criticism. That was a criticism that was made from some of the medical representatives with us today as well. Just wanting to see whether any of the other states have that in place in terms of their voluntary assisted dying regimes, from your knowledge, and also, if not, why you think that it's important to have medical professionals on that board.
I actually don't have the information at hand about the other jurisdictions, so I can take that on notice. I do think it's really important to have medical professionals on board, and especially, particularly not ones that necessarily are ideologically supportive of euthanasia and assisted suicide, so that you can have proper oversight and checks from a medical professional, given it is a task given to medical practitioners.
Thanks, Ms van der Linden.
Thank you. Mr Khan, you've got the call.
Ms van der Linden, are you aware that under the law in New South Wales, even when a person commits suicide, there's not a requirement that suicide be listed on the death certificate?
I wasn't aware of that.
Indeed, if one is to appear in the coroner's court, one of the questions that will be asked in closing submissions will sometimes be, in the case of a suicide, what is proposed, what submissions are made on what should be shown on the death certificate.
Yep.
So what I'm essentially putting to you is, even though you say that it should appear, would you not agree that actually the death certificates are not a source of the collection of information for the purposes that you seek data collected?
Sorry, could you repeat the question?
Well, the death certificate is for the purposes essentially of use for other purposes, including for the family, not for data collection purposes.
But if voluntary assisted dying is a compassionate and really positive development, as proponents of this bill would say, what is the problem with having it on the death certificate?
Well, let me suggest to you this, Ms van der Linden. I don't think anyone thinks that somebody who is forced into the predicament of a terrible death through one way or another, that it's particularly something that anyone should be proud of. I'm not quite sure. I'm not quite sure, as a proponent of these laws, that I see why it's necessary for the purposes of recording a death for that material to appear on the death certificate. You tell me why. If it's not for data collection purposes, what other purpose is it for?
Because it's factual. The person doesn't die from their underlying illness or condition. They die as a lethal injection or by taking a lethal substance.
So, Ms van der Linden...
Can I just take, I don't want to cut into time, but just for a matter of clarity's sake.
No, you are taking my time. You are taking my time.
Well...
I'll take the point of order, Chair.
Well,
I was given the call.
Mr Khan has the call.
Now, with regards to this issue of prosecution, that you were asked questions by Mr Farlow about, I take it prosecution refers to criminal prosecution. Is that right? He was referring to page 16 of your submission. Doctors are rarely prosecuted for breaches.
Well, there's criminal and civil prosecution, but yeah.
Well, is it a criminal prosecution that you're referring to?
I'm referring to...
Sorry, Ms van der Linden, I think your audio just dropped out again. It's perhaps when you're too far away from the computer system that it may just not pick you up.
Beg your pardon?
I'll just ask you to repeat your previous answer, if that's okay.
In the submission, we say no doctor has been successfully prosecuted for violating a safeguard in the Netherlands. My understanding, and I need to go back and check it, but that is criminal and civil in the Netherlands.
Right. Well, look, could you take that on notice and get in touch? Because it seems to me the use of the term prosecution normally refers to a criminal matter as opposed to disciplinary action, which is called precisely that, professional disciplinary action. You'd agree?
Yep.
So in terms of, and I think because it's got a footnote of IBID, I go back up, and so this is referring to the Oregon Public Health Division. Is that right?
I thought it was the Quebec one.
Netherlands.
Yeah.
And then Quebec. So the paragraph refers to the Netherlands and Quebec.
Ah, right. So that's 29. Fair enough.
Yeah, Martin A.
Yeah. Now, you referred to the question of the doctor in the Netherlands.
Yes.
That doctor was prosecuted, was he not?
She.
Sorry, was she not?
She was.
Right.
She was successfully prosecuted, but she was prosecuted.
Yes, that's right. But she was prosecuted for whatever she did or did not do.
Yeah.
Yeah. All right. So that there are circumstances, notwithstanding whether it's successful or not, where even under the Dutch provisions, prosecutions have been launched.
It's very rare, Mr. Khan. It's extremely rare. And the only time it happens is when the family is unhappy and has to go through the courts, and it takes years. It's very, very rare, though.
Indeed. Indeed. All right, I've got nothing more.
Thank you. I know the Deputy Chair does. I'm just checking if any other members do. If not, the Deputy Chair has the call for the next few minutes.
Thank you, Chair. So I've got a couple of questions for
Mr. Bondar.
But before, can I just go back to Ms van der Linden? And if you need to take this on notice to clarify matters, do so. But I have to say I was a little bit confused with respect to the previous line of questioning about the collection of data, which in my line of questioning was relating specifically to page 7 of your submission, and data with respect to the collection by the Voluntary Assisting Dying Board, and data, or dare I say, information that may or may not appear on a person's death certificate. And I must say I wasn't quite sure whether the questions were going to questions around information on the death certificate, the information collected, which was my line of questioning, or whether or not there was some conflation there. Not implying anything.
To the death certificate. Yeah.
Okay, so you understand then, just so you're clear, that your answering of all those questions that just emanated from Honourable Trevor Khan's questioning relates to death certificate information, not VAD board information. You understand that?
Yes.
That's fine. That's good.
I'm not cavilling.
No. I just
to the to information collected by the board.
Absolutely not.
Not at all.
No, Mr. Bondar, thank you once again for your submission and coming along today. The matter of decision-making capacity and the significance of that, and with respect to your submission, whilst the page is not numbered and I'm not critical of that, it just turns over to, after the start of the substance of the submission, the heading decision-making capacity, open brackets, DMC, close brackets. You've got that? It's just in from the start of the...
I've started it.
Yeah, go to the front. So it's after those links, useful links that you've got. There's a heading, like 2 pages in.
Yeah.
Decision-making capacity. So you've got supporting submission. If I can just hold that up. I got that? Okay. So with respect to the matter of decision-making capacity and the matter of consent to the decision, presumably being made the person in consideration of what's before them of going down this particular path of voluntary assisted dying. Is it the evidence of Family Voice Australia that there are concerns that exist with respect to as you understand it, what will be the operations of the bill if it was implemented, around clarity and certainty with respect to decision-making capacity and matters of consent, particularly if the issue of coercion is added as a dimension to the whole matter, and that coercion being either overt or covert coercion. I'd ask you to express a view about that if you would.
Yeah, thank you, Deputy Chair. The concern over decision-making capacity is an issue, and the best example I can give you really is in the case of my own brother, who's an ex-Vietnam vet, where I went to his bedside, and some years ago, mind you, where he was just drugged up, and the doctor said, what do you want to do with him? And I said, well, I certainly can't ask him because he's not capable of making a decision. He said, what do you want to do? And I said, well, I want to hold his hand and pray with him until he died peacefully. So the point I'm making here is, Deputy Chair, that decision-making can be impaired, it can be coerced, it can be indirect, and it all depends on how one defines the ability for a person to be able to make a decision. The patient needs to satisfy that they have decision-making capacity. That's very difficult, Deputy Chair, very difficult, and I suspect no legislation will be able to clearly define what capacity is. I know legally, legally there are dictum that say that, does this person have a capacity to make a decision, as in the case of minors, for example. So it's very difficult, so that's what I'm referring to, that it's going to be very hard to prove that the patient has been able to make a valid and concerned and considered decision.
With respect to... Sorry.
Yeah. Oh, no, I was going to say, we've only got about a minute left, but if you've got...
Time's up.
Yeah, I apologise to the witnesses. We are very tight on the schedule today, but we have reached the end of the session, and I wanted to thank both witnesses for appearing today. For the questions that have been taken on notice, the Secretariat will be in contact with you to organise the tabling. And once again, thank you for taking the time and making the submission. And we'll take a short break now and return at 3:15. Thank you.
Yeah.
Well, welcome back to our afternoon session. We've got 4 witnesses in the room today, and I'll ask them to swear either an oath or affirmation and give their name and position title. Thank you.
Karen Appleby, Manager Policy and Campaigns, Council on the Aging, New South Wales. I'll do the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Ms Appleby.
Megan Lawson, CEO of COTA New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms Lawson.
My name is Beverly Baker. I am the Chair of the Older Women's Network New South Wales and the President of the National Older Women's Network. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms Baker. And finally, Ms Wright.
I'm Shannon Wright and I'm the Chief Executive Officer of Seniors Rights Service, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now's the opportunity to make some opening statements. Does every member have an opening statement, or
doing COTAs?
So you've got the one for the for COTA. If you would start, please, Ms Lawson.
No worries. Thank you. Thank you very much for the opportunity to be here today. Council on the Aging, or COTA, New South Wales, is a not-for-profit consumer-based organisation. We've been working with older people in New South Wales since 1956. I'm the CEO of COTA New South Wales, and I'm also joined by Karen Appleby, the Manager of Policy and Campaigns. COTA New South Wales supports this bill and the legalisation of voluntary assisted dying in New South Wales. The question of voluntary assisted dying is fundamentally a question of autonomy and agency. Every person deserves the right to make informed choices about their end-of-life care, and that includes older people. COTA's position is based upon the strong and ongoing support for VAD that has been expressed by older people in New South Wales. Our most recent findings, published in the State of the Older Nation report in June this year, indicate that 72% of older people in New South Wales support the introduction of voluntary assisted dying. COTA New South Wales supports the provisions within the bill in its current form, including the amendments agreed to in the Legislative Assembly. The bill builds on previous work in other jurisdictions and contains robust safeguards to ensure that people seeking voluntary assisted dying are protected from coercion or malpractice. The current bill balances the rights and choices of the terminally ill person with the necessary protections for healthcare workers and those institutions seeking exemptions. Opponents to the bill have raised concerns regarding the possible coercion of older people and assessment of adequate decision-making capacity. The bill contains multiple safeguards to ensure that no one is coerced or pressured into a premature death. This includes independent medical professionals, strict eligibility criteria and penalties, including criminal offences. Additionally, the Victorian Voluntary Assisted Dying Board has found no evidence of coercion in that state with the individuals who have died under the Victorian legislation. If anything, family members are actively discouraging their loved ones to undertake VAD. The question of assessing decision-making capacity has also been raised as a concern. The bill defines several measures on which to determine decision-making capacity before an application to access VAD may proceed, including escalation of the coordinating practitioner to other health practitioners with different skill sets and qualifications if there is any uncertainty. In the discussion around decision-making capacity, it is important to be alert to the assumption that older people are by definition vulnerable and may be impacted by reduced cognition. This is just ageism. All applications to utilise VAD and subsequent eligibility should be determined by each individual's unique circumstances, including their level of cognition and decision-making capacity, and not be influenced by age-related biases and conjecture. It is COTA's belief that older people in the last stages of a terminal or incurable illness have the right to make informed decisions on their end-of-life medical care, including the choice to receive medical assistance to end their life peacefully and at a time of their choosing. Thank you.
Thank you very much for that. Ms Baker, could I invite you to make an opening statement?
Yes, you certainly can, but I have to wing it. I'm afraid my written opening statement is sitting on the bench at home where I rushed out.
Sometimes the ones that are winged, as you say, are the best. So I'm looking forward to this one.
We never do that. We never do that.
As I said before, I'm the chair of the Older Women's Network New South Wales and the president of the National Association. Both organisations, even though it's not a national matter, apart from in the broader sense, support the legislation and the amendments that were accepted and passed through the lower house. Now, I don't do that off the top of my head or off the cuff. We have just recently had 2 annual general meetings, and at both annual general meetings, these were passed unanimously, the agreement to support the voluntary assisted dying bill, with the checks and the balances that are absolutely clearly in there. We do not believe that anyone should be subjected to someone else's interpretation of a religious law regarding what happens in terms of their health at their end of life when they are in a situation that there is no other way out but pain and isolation. Older women are not afraid of somebody stealing what little money or what lot of money they have. They are more afraid of being locked into an absolute routine of prodding and poking and loss of humanity, loss of dignity and insult as they live out what will probably be some of the worst days of their lives. We would much prefer to be able to negotiate with our loved ones, with our medical practitioners, to determine for ourselves the time and the manner of our passing when we know that we are at those last stages, so that we have the opportunity of saying farewell when we still have capacity to do so to our loved ones, when we can actually negotiate, debate and argue about the terms of the will so that there's no misunderstanding about who gets what, and that we are then able to pass in the loving arms surrounded by people we know love and care for us and are sad to see us go, but would prefer that than have us suffer in absolutely unmentionable and abject pain. The reason that I know this is that my mother died in such a way. She had Merkel cell skin cancer. I was powerless to help her because I would have gone to jail had I. Yet she begged me to do something as she lost her capacity to swallow, her capacity to, her pain. I don't know whether anybody knows about Merkel cell skin cancer, but it is the most hideous form of skin cancer. It manifests itself in the blood and it ends up anywhere. And when she first had her diagnosis, we were told she had 6 weeks, 6 months or 6 years. Nobody knew what, but they did know she was going to die in agony, and die in agony she did. It was devastating for the family, and it was devastating for her, who was a strong woman, who had always lived her life independently, to be subjected to being completely and utterly dependent and at the mercy of a nursing home that A, she didn't like and didn't trust, and not be able to go when she wanted to. So thank you.
Thank you very much, Ms Baker, and that was a 10 out of 10 for if that was off the cuff. Ms Wright, I'll invite you to make an opening statement, please.
Thank you, and thank you for the opportunity to present at today's hearings. I'm Shannon Wright, as I said before, and I'm the Chief Executive Officer of Seniors Rights Service. We're a community-based organisation that's been representing, supporting and advocating for the rights of older people across New South Wales for the past 35 years. Our vision is for a society that respects and upholds the rights of older people. We have a free legal service and also an aged care advocacy and education service. Last year we responded to around 9,500 inquiries, including close to 3,000 to our legal service and over 5,000 to our aged care advocacy service. A third of all these inquiries came from older people living in regional and remote areas of New South Wales. We've got a network of regionally based New South Wales advocates, and we're one of a group of 9 similar organisations across the country that are members of OPAN, the Older Persons Advocacy Network. Unfortunately, the people who seek out our services too often bear witness to appalling breaches of the most basic of human rights, the right to be safe and lived free from harm, the right to be treated with respect, the right to make independent decisions about care and treatment and end-of-life arrangements, the right to be listened to and have their culture and beliefs recognised. Today I'm speaking on behalf of Seniors Rights Service, and we support the Voluntary Assisted Dying Bill. We acknowledge that dying is a normal part of life that all people in Australia should have, regardless of where they are living being access to high-quality specialist care, including holistic palliative care, and the same choices available to them at the end of their lives. People have the right to make decisions about medical care and end of life, including voluntary assisted dying. We recognise that VAD enables eligible adults who are in the end stages of terminal illness and suffering intolerably to end their suffering at a time and place of their choosing and with their loved ones if they wish. We believe that it is imperative that older people's wishes and beliefs be respected. Voluntary assisted dying must indeed be voluntary and sought by the person themselves, not by carers, families or other individuals. Medications can be self-administered or they can be administered by a suitably trained medical practitioner. Only those people who are already dying from an incurable, advanced and progressive disease, illness or medical condition should be able to access voluntary assisted dying. However, we caution that advanced age, mental illness or disability alone should not make a person eligible to access voluntary assisted dying. We note the criteria for demonstrating eligibility to access VAD is made voluntary may differ across jurisdictions and generally include life expectancy, residency and demonstrating that a decision to access VAD is made voluntarily. The importance of ensuring that any decision on voluntary assisted dying is based on a person's wishes cannot be overstated. Our legal service encourages people to have in place an advanced health directive that could indicate a person's wishes regarding treatment options under certain circumstances. The existence of an advanced health directive indicates the person has thought about quality of life issues as they age and may be affected by certain medical conditions. More education and information on these instruments needs to be available throughout the community, with special care taken in how this information is provided to culturally and linguistically diverse communities. With regards to palliative care, we agree that every person living with a life-limiting illness should always have equitable access to quality needs-based palliative care at any point in their illness journey, with timely referrals to specialist palliative care if required. Palliative care has a key place in supporting people at the end of life, and we note the significant high quality of supportive care that many palliative care nurses provide to people and their families at the end stages of life. However, we also acknowledge that for some individuals, palliative care is not sufficient to ensure a dignified death. Our society must ensure that human rights of older people are respected and acknowledged, that these rights may include the right to a good quality of life, not a life of pain and suffering. Indeed, even the best palliative care services cannot always alleviate all the suffering experienced by a person. Some older people may not want to access palliative care, and this wish must be respected. We must also be careful not to assume that everyone is living in cities with ready access to quality palliative care and other medical facilities. Indeed, many people in outer regional, rural and remote areas of Australia simply don't have access to those services. Seniors' Rights Service recently spent some time in far west New South Wales talking with older people in towns from Broken Hill to Bourke about their experience of aged care and other services. And what we repeatedly heard was that there was a lack of access to various medical services and also to doctors and other allied health professionals. So palliative care options might be very limited for people in rural and remote areas. Therefore, any requirement to first access palliative care before being able to access voluntary assisted dying may be problematic if the services do not exist where the person is residing. In addition, the requirement for 3 medical practitioners to be involved in any decision about voluntary assisted dying could prove problematic in regional and remote areas where often there is only one medical practitioner in a town. The proposal to expand the number of medical practitioners to be involved in any decision about voluntary assisted dying for a particular person could prove extremely problematic in regional areas where there just aren't that number of medical practitioners available. And it's our experience that while many of the people we assist reside in aged care facilities, we do provide services to many people who are still living at home. And we know that many of these people want to die at home and would not be willing or able to travel to larger cities in order to access the proposed medical assessments by a psychiatrist, for example. We believe that the proposed legislation does set out the preconditions to provide dying with dignity, and that the checks and balances outlined are sufficient to ensure the person understands the decision they are making and can exercise choice. However, specific information about voluntary assisted dying must be provided by medical practitioners and allied health professionals. We also note the legislation there is a reference to family and to consulting with family. The notion of who constitutes a family needs to be broad enough to include those people designated as family by the individual. As noted in the LGBTIQ Health Alliance submission, protection from unwanted involvement by biological relatives is important given the lack of support and acceptance that many LGBTI people experience from their biological relatives. The widespread and ongoing use of exclusionary definitions of family that presume the default authority of biological relatives and the default lesser status of non-biological relations, whom people designate as their family, is a major problem in Australia. Again, we found when we consulted with older people in remote regional locations that their biological families had often moved away and lost contact with them. Therefore, it may not be possible to have biological families present at the time of making a decision to request VAD, and other people of significance to the individual may need to be involved and included. We believe dying with dignity, the right not to suffer immeasurable pain or anguish, and the right to self-determined agency are fundamental human rights of all people, and that these rights must be respected. Thank you for your opportunity to be a witness here today.
Thank you, Ms Wright, for that opening statement. Just noting the time, we've got a little bit less than half an hour in order to question. So looking around the room, Mr Khan, you've got the call.
Good. Ms Baker, I'll start with you.
Thank you.
Because you spoke in terms of your experience with your mother. I'm not going to ask you to go through in detail that we've received a lot of evidence with regards to what I'll describe as bad deaths. But some of the evidence that we received, particularly on Friday, was from a number of actually specialists who said, look, all you're doing is hearing from the family. Self-evidently, the deceased was gone. And it seemed to me that the suggestion is that the family had a different view as to the wishes of the deceased than actually the deceased may have expressed. So are you certain that your mother had a view as to what she wanted to do towards the end of her life?
As clearly as she could say, is make this stop. Get me something so I go to sleep and I never wake up. I think that's about as clear as it could get. We were fortunate. My mum was a very religious woman. I'm not. She was. When she was at the end, we called in the priest who offered her absolution, and she died in my arms. But she died in agony. We had to give her morphine to try to relieve the pain. I wouldn't wish that on someone I absolutely loathed, let alone someone that I adored. And my mum is somebody who's been dead for 20 years now, and I miss her every single day. I would never swap that. I currently have two girlfriends, one suffering from pancreatic cancer and the other from cancer of the liver. We all know that those things are not curable. We know that they are heading towards the end. And both of them have said, if you can get this through, get it through. Because whilst we will try everything now when we're fit and able to do so, when we're told the time is off, we can't do anything more, we want the opportunity to be able to die with dignity. With dignity was not their words, but we want to be able to choose our own time when we go and how we go, and be surrounded by those who we invite to be with us. And I think that's basically, and those women are, one of them is 10 years younger than me and the other's 10 years older than me. So that's a pretty broad cross-section of a generation that actually believe that they don't want to go through the pain and the agony that they have witnessed their parents, their loved ones go through, and they don't want to subject their family to that. And I certainly never want to put my children in the position that I was in as I watched my mother go through that dreadful experience.
Thank you. Seeing it's been used today, back in 2017 when I was promoting what's been described as the Khan Bill, somewhat unfortunately, one of the experiences that I had in moving around a variety of meetings was that and this is my estimate, in the order of 2 to 1 of the audience of groups that I addressed were women. Now, if I'm right in that assessment, that the interest in VAD seemed to be proportionately stronger amongst women, Have you got a theory as to why that might be? I do, but I'm not giving evidence.
Well, again, only from a girlfriend who 15 years ago died from cancer of the liver, when she asked if I would look after her husband because he would never cope with what she was going through. And I think that there is that strong will for women to protect those who they love and who love them. And I think that's very, very strong. I haven't had any men die in a painful way. My father was 99 and died in his sleep. Not very painful, I don't think. But I have not had any close male friends who have gone through this. It's been close women friends, and they think long and hard and very, very deeply about what they're going through and the impact that will have on their family. And that's why I'm not surprised that it went through both the National Conference and the State Conference unanimously to support voluntary assisted dying.
Ms Wright, Ms Lawson, Ms Appleby, do you have any views on the matter?
Go. No, you go.
Oh, I would, as I think about this, I think that women access healthcare much more often than men do. Women are more vocal than men are. Women fought to have women's health services. Women tend to have more to say on these issues than men who kind of let that happen. I just think, yeah, I don't know what sort of meetings you had, but maybe the representation is around...
Most of them were good.
Maybe the representation was about women coming out and being vocal about that stuff. I think about my dad. My dad would never, I mean, yeah, he would never have gone to anything that spoke about this, but my mum quite passionately would. So, yeah, that's my thoughts.
I'd agree. I think, though, when we speak to men who volunteer with us or men who are engaged with us, it still breaks in the same kind of numbers in terms of who supports it and who doesn't support it. I just think that there are more women who are more engaged in community groups and who do that kind of thing as part of their, general being, really. But when I think I had a meeting last week with a group of volunteers and they were all supportive, and that was across both genders, and it seems to be across that way. When we get people to write, again, when people write in saying that they don't agree with voluntary assisted dying, again, it's a pretty equal number of men and women. I think you tend to have more women engaged with these kind of debates.
So what will be my final question, at least on this tranche, is this. If my perception of the evidence is somewhat like this. Nurses Association comes along and says essentially its members strongly support assisted dying. I don't want to verbal anyone, but that seemed to be where I got to on that evidence. Various palliative care specialists have come along and said, no, don't need it now, small issue, too many dangers involved. Have you got a view as to why the nurses seem to have a very clear and articulated view, and yet amongst the specialist cohort there seems to be greater caution in terms of legislation such as this? Is right?
Look, I would think that the nurses are at the coalface. I would think that the nurses are dealing with this day in and day out. Yeah, that would be my thoughts.
I agree, and I think, as much as we have strongly lobbied for accessible palliative care everywhere, it isn't, and nurses see people day in and day out, and that's certainly been the discussions that we've had with the Nurses Federation as well.
And I know that when my dad passed away at home, the nurse came out, like he was in hospital, he came home, he was very unwell, he was not awake, and the nurse came around the day before, she came, the outreach nurse, gave him his morphine, gave him his everything, and then the next day, he was breathing very badly, and she came out and said, okay, so say your goodbyes, and it'll probably be about 20 minutes, and administered that last dose. So, I mean, she's on the coalface of this.
And I think nurses are actually forming relationships with people at that stage of their life much more than a specialist would. So they get to know the experiences that they're going through, what their state of mind is, their attitude to passing on. So I think it's just a much more personal relationship, and they've got a much more bigger handle on things, I think.
So I'd like to ask you more questions, but I can't monopolise the conversation, so I'll hand over to others.
Well, I'm going to pass now to the Deputy Chair, and the Deputy Chair has asked that we provide you with some documents, which are just about to come around to you. Deputy Chair.
Thank you. Just passing around to you submission number 57 to this inquiry. This is a submission from the Australian and New Zealand Society for Geriatric Medicine, New South Wales Division. Now, perhaps in some sense, through the answering of the question, in fact, almost the last one or the penultimate one from the Honourable Trevor Khan, you may have formed a view about this anyway, but I'd like to press on and just raise it with you, if you don't mind, just 2 or 3 questions because we need to share it around. So the organisation is the college, the specialty college for geriatric medicine in Australia, the specialists. And as you'll see from the second paragraph, they've got 1,300 members around Australia. So it's quite a relatively large college. And these are individuals, men and women that have done the specialty training to enter the college, to be recognised, or pass through the college and ultimately be recognised by the college as geriatric specialists. Now, I just want to raise some of their comments because they are approaching this from their point of view as specialist doctors who their whole life is treating older people, geriatric people. So if we go down to the bottom of page number 1, and you'll see in that paragraph above the number 1, which is the first point, the college says, having reviewed the 2021 New South Wales VAD bill, we recommend that honourable members of the New South Wales Legislative Assembly and Council consider the following in their deliberations. So they're asking us to think about these things in our deliberations. Now, we obviously know it's passed through the Assembly with some amendments, but this is directed to members in the Council which are represented around the table today. So I'll just skip through some of these. The first one says, so this is the college, we are concerned that frail older people, so it's talking about frail older people, may be put in a position of considering VAD because they feel they are a, open quote, burden, closed quote, on others, in brackets, such as family members, carers and the healthcare system. Such feelings are often due to underlying depression, lack of availability of community services or family dynamic. It is possible that someone may consider an old, frail, older person eligible on the grounds that they have a limited life expectancy. Now, that's a statement from the College of Geriatric Doctors in Australia. Do you have any comment about that paragraph that I just read about the concern of frail elderly? So I'm not talking about the ones that, you know, are obviously in pretty good shape and all of that, so to speak. But we're talking about the frail older person and these specialist doctors' specific reflections of their concerns with respect to those individuals. Do you have a comment about that paragraph? I mean, we'll start with Coterie in the first instance, if you like.
Yeah, look, I'm happy to say that I think there's already a kind of process and a framework in place for assessing capacity and the capacity for people to make these kinds of decisions. And those kinds of things are made routinely in healthcare as people are going through treatment. So if someone's going through cancer treatment, for example, there'll be an explanation of what the process is and whether or not the person wants to go through that next step. So I think that medical practitioners, like legal practitioners, we run a legal service, for example, for people to make wills and powers of attorney and enduring guardianship, and those legal practitioners are required to make an assessment on the capacity of the person to make those decisions. So I think there's a routine and a process in place that covers that already. And I obviously have not read this entire document because I've just had it handed to me here, but there's, you know, if you look at the second paragraph where it says we have a predominant role in the management of dementia in each of these settings, and people with dementia wouldn't be eligible to access VAD under the bill that's before the Parliament at the moment, and so I don't think that's something that, you know, and I would suggest that if you are dealing with those people who are at that frail end of life, that you're probably coloured by dealing with people who are at the frail end of older people who are at the frail end of life. And I think that we have to rely that there are routines and processes and procedures in place across medical and legal fraternities which cover this every single day now. Right. And it's just an extension of that to do it under the legislation in this that you're considering.
So your evidence, if I understand you, sorry, Ms.
Megan Lawson.
Okay. is that it's an extension of what's being done now. Is that what
I believe so, yeah.
So not your, that's your position of CODIS, it's an extension of the provisions now?
Yeah.
Okay. I'll just continue on. The bottom of that page, an older person requesting VAD should have, so this is the position of the geriatricians. An older person requesting VAD should have access to comprehensive clinical assessment to address medical, psychological and social aspects of health to ensure management options for conditions amenable to treatment, to be discussed. Then they go on to say, we do not believe that the proposed bill has adequately addressed this issue.
Look, I'm not a geriatrician and I can't tell you what they think. They have obviously stated what they think, but we have looked at this bill and we believe that there are 17 steps in place and that is adequate for people to be assessed as being competent and able to make that decision for themselves.
Okay, well, let's go on to point number 2. So these are the specialist doctors who look after our geriatric citizens in New South Wales. Point number 2, the risk of potential coercion of vulnerable patients by family members, carers or health providers is a significant concern.
Sorry, I was going to say to whom? Certainly not to...
No, I haven't finished.
No, it's fine.
You did pause, so I mean, it wasn't that she was interrupting, it's just that you...
Coercion, a form of elder abuse, can be subtle and difficult to detect. Patients are often subject to subtle coercion, for example, to accept admission to residential care or to control the finances. So these are geriatricians making this statement. So you would have to at least give some weight to them making their submission based on what they've observed and seen. I mean, that's what one does with respect to making submissions to the inquiries, like you obviously have done. I mean, that's a pretty strong statement by geriatricians, that risk of potential coercion of vulnerable patients by family members, carers or health providers is a significant concern. So what do you say to that?
Can I just say, so I mean, to be eligible, there's pretty strict criteria in the first place. You have to have a life-limiting illness, and you have to be diagnosed as only having 6 months to live.
Or 12, yeah.
12, yeah.
Yeah. So at every stage there is opportunities for the coordinating practitioner to escalate to external experts if they don't feel they if the person doesn't have capacity or they're not in a position to adequately assess whether they can go forward. That would include picking up issues of coercion. I would also say that there has been no evidence of coercion in the Victorian situation. There's a report from the board there that actually says they were looking out for it very carefully and there was absolutely no evidence. So I think there's the fear there, but there's no evidence that it actually is occurring.
So on this point, just that paragraph I've just read, so the second sentence says, so these are patients of these geriatricians. Patients are often subject to subtle coercion, for example, to accept admission to residential care or to control, the word of is missing, of their finances. So that's what these medical specialists are saying goes on. That's what they're saying goes on. Now, is your evidence that, in fact, that putting aside for a moment, if you could, what you've just said about the Victorian report, if you could just for a moment, are you saying that what they are saying is not your experience, not right?
I think there's a big difference between possible coercion about going into a residential aged care to coercion about ending your life earlier than is natural. It's a really big leap.
And I'd add to that there are mechanisms in place to ensure that you get the actual position of the person rather than the family. No lawyer would make a will for someone where there was a question of capacity without having a meeting on their own with that person rather than when having family present. And I would assume that that's the kinds of things that are in place at the moment to make sure that you're getting the view of the person, not the view of the family.
Well, my time's going to run out shortly, but may I just take you to point number 3, because my time's going to run out. There's plenty more to come. And I'm finding your response is interesting.
Oh, well, that's actually...
No, because I want to come back around.
Order. Mr. Carney, you raising a point of order?
Well, no.
Okay. Mr. Donnelly, you've got the call.
Oh, thank you. So point number 3. So point number 3, can I just take you...
the point he's making.
Can I just go down three paragraphs? It commences, patients may be prescribed medications capable of impairing incapacity. So these are obviously reflections from geriatricians that have been around the block, have seen the way in which our elderly, particularly the old infirm ones in particular, are treated by even people's closest family members. It says there in the next sentence, there is no requirement in the bill for the coordinating or consulting practitioner to actually have expertise in capacity assessment. In other words, the bill provides for capacity assessment, but there's no requirement in the bill that the individual undertaking the capacity assessment in fact has that expertise to undertake capacity assessment. So
my understanding was that there was, and that the person would be trained, that people would be trained in capacity assessment.
Well, the geriatricians are saying there is no requirements.
Well, but I think they're wrong. I think there is the requirement in the bill as it stands at the moment for people to be trained in capacity assessment.
Well, can I invite you to take that question on notice and just...
Certainly, but I think you should also go back to them and ask them to review their understanding of the bill.
I'm inviting you to take it on notice.
Yes, and the witness was doing so, but then the witness was also addressing part of it, which I'll allow her to do. Ms Lawson, you've got the call.
My understanding is that there is a requirement in there for people to have training.
Mr Donnelly, please allow the witness to...
Sure.
And I would suggest that they're incorrect. I'm happy to take it on notice and I'll come back to you about it, but that is my understanding and I will come back to you with the reference.
Right.
But I would suggest that you also need to speak to the geriatricians because I think they're wrong in what they've said in their submission.
I guess it's a matter of fact what's in the legislation. Either the legislation, that is the bill...
I think it's a pretty important fact at this point, given what you're asking.
Yeah, most certainly so. That's why I'm pressing it. I'm talking about a requirement, an enforceable requirement, not some training that they may receive as part of the rolling out of the VAD procedure in New South Wales.
But that's precisely what she's saying. That it is a requirement of the rollout that they receive training.
Training is a requirement.
No. This is... No.
Mr. Deputy Chair, look,
anyway,
I'm sorry.
Taking it on...
It has been taken on notice.
Yeah.
We've only got 5 minutes left. I know Mr. Diadam has a question, and I potentially do as well. So the call's with Mr. Diadam.
I was going to cover the issue of burden, but Greg's obviously traversed a lot of that ground already. But I will ask about the issue of the experience of palliative care of older citizens in New South Wales, and I suppose your view about this argument that if we improve palliative care, then the need for VAD disappears.
Look, I think for the most majority of cases, palliative care does do the job and helps people in those final stages of life and does manage their pain quite well. But there will always be situations where someone has an illness where they don't respond to the painkillers. A family friend had pancreatic cancer recently and couldn't take morphine and was in unbearable pain, and that's how she passed away, unfortunately. So I think in best case scenario, yes, palliative care is it's a really important key part of the dying process, but it won't alleviate everyone's suffering, unfortunately.
And it's also a matter of choice, of personal choice. Do you want to go into palliative care and be subjected to whatever happens there, or do you want the opportunity to finish it now, die with your own, at your own time, in your own place? That's a matter of choice. That's dying with dignity. I hate to keep using that title, but it gives you the dignity of not having to know that you are wearing a nappy, or that you are unable to stand, or all of the things that are so embarrassing. And the things that impacted on my mother so badly was that she lost the capacity, and she couldn't bear the fact that she was then as she was as a baby, with no self-agency, no capacity to determine for herself. And she would have rather to have gone sooner than later in that situation. And I know my two friends, having been offered, when they get to the stage where they will be offered palliative care or some way of shuffling off, they'll take the shuffle, because that then allows them the agency and the control. Old people are treated like we're vulnerable old duffers, but we are strong, articulate, active people who have an illness that is going to kill them, and that is going to kill them painfully.
Ms.
All
Baker,
of that other stuff doesn't go away.
I think it's fair to say nobody's going to accuse you of that.
At your peril.
Happy to pass you to see if they've got questions.
Well, we only have a few minutes left. Just looking around, I do have one, but I want to. Well, I'm sure you do, Mr. Donnelly, but I do have one, and then I think that we will be at the end of time. So I appreciate your enthusiasm. However,
I've been trying all day. In fact, all 3 days.
This question's to all of you. We know that opinion polls and opinion group surveys and the like show that voluntary assisted dying has a approval of around about 80% of the population, give or take, plus or minus 5-10%. I wonder, having sat through now almost 3 days of this inquiry, I don't know how many of, I'll say, lay people, the average person on the street has really thought about their death and what it will mean. Yet we still see this high level of, I'll say, approval for VAD. And I guess I'm asking myself the question, why would that be, given that they haven't thought about, the horrible deaths that we've heard about, or, potential of abuse? Is it because people are scared of dying in pain, dying in agony, or, as Ms. Baker just indicated, the loss of faculty and the loss of dignity? Do you think, with the members that you've spoken to in your organisations, is that partly what it is, that we want the ability to not die in pain and to die with a level of dignity attached?
I don't know that people haven't thought about this. They've had mothers and fathers and grandparents die in the most horrible conditions, and even if they haven't thought about it deeply, when asked a question, they'll think, that's the trigger, it's kind of like, yep, okay, I never want to do that. I don't want to do that. And just because somebody's frail doesn't mean that they don't have capacity, that they don't have the right to choose, that they don't have the right to die with dignity. Just because you're frail doesn't take away all of your life and what you've lived and where you're at. Frail's just an annoying word, to be honest.
I think that people are more afraid of being forced to live in agony, in inhumane and debilitating surfaces than they are of being able of death itself. I mean, we've got to the stage, look around the room, most of us have got less of it left than we had to start with. Yep. I've got a lot less left. If I'm looking at was it 4 and 10 or 3 and 10 or something?
3 and 10.
3 and 10. Well, I'm already one over, so, you know, that's 1 foot in. I'm more terrified.
Hope not.
Baby.
Be a toe at most.
Well, you've got no idea what it's like to be 71, I can tell you.
That's far behind.
But it's just... It's not being forced to stay alive and be used to feel like you're an experiment, being prodded and poked and filled up and moved around and shuffled about. I would rather die than go through that dehumanisation. And I think that most people who you talk to are in the same boat. They're not afraid of dying. They're afraid of being forced to live in a way that they don't want to.
Well, on that note, I note that it's now 4 o'clock and we've hit the end of this session. For any questions that you've taken on notice, the Secretariat will be in contact with you to arrange the tabling of those. And I'd just like to say thank you to each and every one of you for making your submissions and making yourself available today. We'll take a short break while we switch witnesses, but thank you again for coming in, and we'll now conclude and be back shortly with the WebEx.
Thanks for having me.
Thank you.
Well, welcome back to our next session. I'm going to introduce our 3 witnesses via the digital system and ask them to provide their name and position, title, and swear either an oath or affirmation, starting with Dr. McLaren.
Thank you, Chair. My name is Dr. Cameron McLaren. I solemnly, sincerely and truly declare that and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Dr. McLaren. Dr. Mewett.
Hi, I'm Dr. Greg Mewett. I'm a specialist palliative care physician in Ballarat. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Associate Professor Cork.
And I'm Associate Professor Charlie Cork. I'm Acting Chair of the Voluntary Assisted Dying Board of Victoria. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now is the opportunity to provide opening statements. So, Dr. McLaren, can I invite you to make an opening statement?
Mr. Chair. I'm a medical oncologist in Victoria. As part of my diagnosis to death approach to supporting patients with cancer, I provide VAD assessments. I completed my VAD training on the 19th of June 2019, the day that the legislation became active in Victoria. I underwent the training for 2 reasons. I didn't want patients for whom I had cared throughout their journey with cancer to have to seek external providers if they chose to pursue this option. Secondly, having been educated in medicine with a strong focus on patient-centred care, I felt that my opinion on VAD was irrelevant to whether my patients should be able to access it. I naively expected that many of my colleagues would do the same. Through a combination of my willingness to support patient choice, the requirement in Victoria for one VAD assessing doctor to be a specialist in the area of the patient's illness,
The majority of patients applying an uptake of VAD amongst my colleagues.
Dr. McLaren,
they've been involved 136.
Apologies. So our system just had a slight dropout, and I don't know if it might be your connection or ours, but I'll just thank you. If you could try again to just maybe perhaps go at the start of the paragraph again and perhaps restart that paragraph with your opening statement, if that's okay.
Thank you, Mr. Chair. Can you hear me okay now?
We've got you. Thank you.
Like the cartoon too.
Through a combination of my willingness to support patient choice, the requirement in Victoria for one VAD assessing doctor to be a specialist in the area of patient's illness, the majority of patients applying for VAD having a malignant diagnosis, and the low uptake of VAD amongst my colleagues, I have to date been involved in 176 cases of application for VAD, which accounts for over 20% of the total number of VAD applicants to date. 70 of these cases have resulted in the administration of VAD medication by or to the patient, and I have been present at over 50 of these, including providing intravenous practitioner administration on 17 occasions. Along with Dr. Mewett, I am one of the clinical moderators of our state-based VAD community of practice, and I have founded an organisation to educate and support other practitioners as we work together to improve the quality of assessment provision and patient care in this field. I'm undertaking a PhD into the effect of VAD on the grief and bereavement experience in close contacts of patients who elect to pursue VAD, as anecdotally I witnessed a notably better acute grief response to VAD deaths than the many others that I've experienced. As part of this, I've coordinated an analysis of a case series of 344 patients who applied for VAD in the first activity of the legislation. I've submitted both my PowerPoint slides and the video recordings of my presentations of this data at a national oncology conference to the committee for your review. Through my work in Victoria, I've had to become intimately familiar with the Victorian VAD Act and the intersection between law, an often black and white field, and medicine, which I often describe as a highly scientific art form. There are many aspects of the Victorian Act which are simply not working. I am looking forward to the 5-year review to highlight several areas to target for amendments. Some may cry slippery slope when I mention this, others may see it as it truly is, as the application of the scientific method in observing outcomes and adapting practice. I hope that I can provide some insight into how I assess capacity, coercion, and the conversations I have with patients and their families when they choose to explore VAD as an end-of-life care option. When I meet someone for a VAD assessment, I start by talking about everything but VAD. Where were you born? Tell me about your parents. Tell me about your family. What did you do for work? What are you proud of? What do you still enjoy? These responses start to give structure to the psychosocial framework in which this person sits. Then I ask them around their illness. When were you diagnosed? What treatments have you had? Are you having any more treatments? What has been explained to you about further treatments? What are your expectations on your prognosis? Through my work in VAD, I've stopped asking patients about their pain and their nausea. I now ask patients, tell me about your suffering. When did you meet palliative care? If they haven't, I explore that further and encourage them to allow me to refer them. Only then do I move on to VAD specifically. What do you understand about VAD? Why does VAD appeal to you? These responses often convey much with regards to what they've been through and their insight into their own condition, which goes a long way towards establishing capacity. Next, what was it like when you first talked about this with your family? What would your family think if you changed your mind and you didn't want VAD? Responses, including non-verbal, that suggest hesitation or indicate something under the surface have been explored as well. Often I excuse family members from the room and ask the patient directly, does anyone want you to go through with VAD? I ask directly about their will and who may benefit and if they feel anyone is after their estate. I tell them that I will make up a reason that they are ineligible if this isn't something that they truly want to do. I often call GPs and other specialists, other family members, and ask them if they have any concerns. In my 176 cases, I have had but one case where concerns of coercion were raised.
It took 4 separate home visits in 1 week to explore this adequately. And it turned out the patient was educated about the existence of VAD by their family member, but as soon as they heard about it, knew that they wanted it. When I contrast this with my clinical experience in oncology, I would estimate every 2 to 3 weeks someone makes the decision to receive more chemotherapy, at least in part, for their family. I hope this gives some insight into the VAD assessments as in being no way a tick box exercise, and one I wish to hope to improve in the future through my organisation. Thank you.
Thank you very much for that, Dr. McLaren. And on the assumption that that was a written opening statement, and this goes for the other witnesses as well, it may just assist us if you're able to send that through to our Secretariat. Also, it assists Hansard in the transcribing, so if you wouldn't mind doing that, that would be much appreciated. Dr. Mewat, can I invite you to make an opening statement, please?
Thank you, Chair. I haven't got a written pre-prepared statement. I'm going to spend a couple of minutes explaining who I am, what I do, what my involvement with VAD has been, and hopefully allow plenty of time for questions from the committee about our experience here in Victoria. I was a GP in Central Victoria in a rural regional setting for 22 years. The latter 15 of those years was very involved in palliative care as a GP and supporting the Loddon Valley Palliative Care Service in our big region of Victoria there. I then left general practice, retrained as a palliative care specialist in Melbourne, and have been now as a specialist palliative care physician in Ballarat for the last 14 years. I've been a palliative care specialist for now 15 years. I was asked to be a member of the Voluntary Assisted Dying Implementation Task Force, which was appointed by the State Minister of Health in Victoria to oversee the introduction of VAD legislation into practice. I'm a conscientious provider. You've probably heard a lot of our conscientious objectives, but I'm a conscientious provider of voluntary assisted dying to those patients who are deemed eligible under the legislation, and I combine this with my usual palliative care, day-to-day palliative care practice. I've been involved with 42 patients, a lot less than Cameron, but I work in a smaller area. But 42 patients that have been involved in their assessment, mainly as the coordinating practitioner, the practitioner that does a lot of the grunt work, if you like, and supports the patient through the process. 15 of these patients have died before the completion of the VAD process, which therein lies another story. 19 of the deaths have been by self-administration. Most of those, 13, have been in private homes. 4 of them have been in our local palliative care unit, 1 in a regional hospital and 1 in a nursing home. I've not been involved in any practitioner-administered voluntary assisted dying, but I'm certainly prepared to do so should the necessity arise. And I have 8 pending cases that are still yet to be determined or to come to conclusion. One of the things that I really found interesting when I was involved in VAD, when I came to this work, I had a bit of a preconceived idea of what sort of people would these be that are requesting voluntary assisted dying, that actually want to take this control. And I thought to some extent, maybe a little bit flippantly, I thought maybe they're control freaks, maybe they're people who really want to take absolute control of being in control of everything over their life, and this is why I want to remain controlled here. But I've actually found it's all sorts of people. In the 42 patients I've met, they come from a wide variety of educational and socio-economic backgrounds. There's often this thought that the people are small L, liberal-minded, well-educated, university-educated people. This is not the case in my experience. Coercion is not an issue that I've come up against, and as Cameron has alluded to, I've seen many people being coerced into doing things by their family when they perhaps shouldn't be in healthcare generally. The other thing that's often thrown up is cognitive impairment and depression. And once again, over many years of medical practice, both as a GP and as a palliative care physician, these are things that are second nature to us. Sure, the stakes are higher in VAD requests, and it behoves us all to be more attentive to capacity assessment and to assessing whether a patient's mental health condition might be impacting on the decision making. But I can honestly say of those 43, outside that 43, I've excluded 1 patient on the grounds of serious mental illness, which required much further assessment and management. I'm surprised how these patients use humour in a dark and funny way in many ways that you wouldn't expect but perhaps I should expect, given that I deal with people who are close to death a lot of my life, patients use this and they use it as a way of coping. They've all of them are well supported by families and friends. That doesn't mean all their families agree with what they're doing. Most of these families don't want the patient to die. They're not, the coercion into making them die is in my opinion, must be exceedingly small. And Cameron's already alluded to that. These patients don't want to die. The families don't want them to die, but in fact, they are dying of their underlying disease. My final comments would be that I find this as a palliative care doctor, patient-centred care par excellence. This is really focusing on patient-centredness, really listening, leaning into these people and having a really good conversation. Not all of these patients will go on with VAD request. Some of them will be happy to continue with other options. But this leads to very meaningful conversations near the end of life. And these patients are often very grateful and their families very grateful afterwards that their wishes have been able to be honoured and acceded to. In my opinion, despite what you might have heard by some palliative care colleagues, I think VAD sits comfortably beside palliative care in my practice, in my opinion. We are supposed to be the experts on end-of-life care, on end-of-life conversations, and on ethical decision-making and assisting patients with decision-making options at the end of life. And therefore, VAD is not in opposition to palliative care. Palliative care is a style of care which, near the end of life, VAD is one type of choice in that care. They're not mutually exclusive. So with that, I will conclude and pass on to the next speaker, and then hopefully we'll have some good questions. Thank you.
Thank you very much, Dr. Mewat. Associate Professor Cork, could I invite you, please, to make an opening statement?
Yes, I'm Associate Professor Charlie Cork, and I'm here today to share the experience of the Victorian Voluntary Assisted Dying Review Board. The board is of the opinion that the Victorian Act is working, with overwhelming positive feedback from patients and families who've used the service. Our experience is documented in our reports of operation. The priority of the board is to ensure compliance with legislation. Detailed review of each and every case has identified no instance of clinical non-compliance and very few cases of administrative non-compliance. The second role of the board is to ensure that patients have reasonable access to voluntary assisted dying, and the board has identified significant issues in this regard. In many respects, greater safeguards result in more difficult access, and an appropriate balance needs to be found. In the light of these observations, I'd like to submit some specific comments on your draft legislation. While some medical practitioners are conscientious objectors, the overwhelming majority are reluctant to become involved because of the additional paperwork and other impositions of the process. Undue focus on the potential for criminal liability for non-compliance has the potential to exacerbate this reluctance. While I can appreciate the intent of the requirement in Section 23, I wonder if requiring all medical practitioners to submit a first request form whenever asked about voluntary assisted dying could benefit from further consideration. This form includes multiple fields, and I suspect compliance by practitioner may be low. Is it possible that providing resources for applicants to submit this data might more effectively satisfy this goal, which is admirable? I wonder about the need and efficacy of the consultation referral form as identified in Section 34. There are existing well-established practices for referral, and this introduces a new, different and additional process. Failure to comply with this requirement is criminalised, which may further antagonise practitioners. Should the medical practitioner need to refer for opinion in Section 27, then I presume that the 5-day limit outlined in Section 23 would not apply. Interpreted through a rigid lens, citizenship and permanent residency requirements can appear very insensitive and unfair. Addition of a common sense clause would assist in this regard. I note that the Act permits discretion in relation to residency, with the board empowered to interpret substantial connection to New South Wales, which I commend. Medical practitioners not noted for their comprehensive clinical record writing. The Act mandates very specific requirements for documentation in the medical record at numerous stages in the process. This requirement makes it virtually certain that non-compliance will occur with this aspect of the legislation. The implications of this merit consideration. Finally, I raised the legislated requirement that the chair and deputy chair of the review board must be lawyers, section 144. While a lawyer may well be the best person for each role, I question the need for this to be legislated. Strong medical leadership on the board may be very desirable under particular circumstances, as may skilled governance expertise, or an appointment that highlights the voice of the community. Legislation regarding these positions limits options. Thank you very much.
Thank you very much for that opening statement, Associate Professor Cork. I'll now open for questions. I'm just looking around the room to see if we've got some questions from members. No doubt the Deputy Chair is ready to kick off.
Just start off. So thank you, gentlemen, for making yourselves available today. Just for clarification, none of you have made a submission to the inquiry?
No, I have not.
No.
No.
So were you invited to participate by being sent an invitation to participate by giving oral evidence, just so I understand?
Yes.
Yep, okay, no, that's fine.
That's correct.
Yep. So you'll forward your opening statements to us, so they'll be incorporated as evidence? No, that's fine, thank you. Could start with this statement, and perhaps specifically with you, Associate Professor Cork. We've received a number of submissions to this inquiry. In terms of substantive ones, in terms of material content, probably around 110 or thereabouts. And with respect to a number of those submissions, and we'll include organisations like the Law Society of New South Wales or the Bar Council of New South Wales. I'll just use those as two examples. But this equally applies to a number of submissions. They express concerns with aspects of the bill, provisions within the bill, and actually propose amendments to the bill to deal with these as they see potential gaps or deficiencies or shortcomings of the bill. Perhaps around how the language is framed, or in fact they might see a gap in the bill they think to be filled. Now, I put it to you, Associate Professor, in the last piece of your evidence that you were giving just then. In a sense, you're proposing to go the other way, potentially. And what I mean by that is that this bill, at least this far, has passed through the Legislative Assembly with amendments. And the proponents of the bill in New South Wales are saying, that's fine, we're happy with that. In fact, we want it to pass through the Legislative Council with no amendments. So that's what's being said by the proponents of the bill here in New South Wales. And you're coming forth with proposals to, dare I say, either remove or dilute certain provisions, which I have to say have been considered as safeguards.
Mr Donnelly,
my question is...
Thank you.
No, it's in the context. So my question is that one person's safeguards are another person's set of obstacles as they judge them to be. So it's a matter of perspective. And I respect the fact that you're bringing your perspective to it, but there's also other perspectives that go beyond the medical perspective. I'd like you to comment on that. Associate Professor.
Yes, I accept your point that safeguards, and I, in my submission, made it clear that safeguards and access are in a way contradictory. That the more safeguards you have, the more you make it very difficult to access the the right to access voluntary assisted dying. And where that sweet point is a matter of judgment. I would say, in terms of some of the issues that we are dealing with in Victoria, a number of these so-called safeguards are that were put into the Act make it very difficult for patients to access to have timely access to the Act, and don't appear to add perhaps to the actual safety. So for somebody who doesn't actually perhaps see the value in patient choice and in this Act, then perhaps the biggest safeguard is never letting anybody get through and not having access to it. So this is a balance and a problem. And I'm not sure that because particular bodies that aren't aware, perhaps not involved in the actual process of medicine, making submissions, they might have good intent, but they may make the actual delivery of the service very frustrating for patients, and to the extent that the patients die without accessing something that's legal that they wish to access, and I'm not sure that's a good outcome for anybody.
Can I just follow on, Doctor, that, sorry, Associate Professor, I mean, if we just take today, for example, we've had appearances before the committee by the Australian Medical Association. And indeed...
not today.
Yes, we have this morning.
The AMA New South Wales.
Oh, sorry, yes, yeah.
The AMA New South Wales branch and the Australian College of Psychiatrists. Now, I presume you've read both of their submissions to this inquiry?
I have not.
Right, right. May I suggest to you, and I appreciate your answer, you haven't read them, but both of those submissions are actually replete with commentary and in certain aspects specific proposed amendments to deal with aspects that they see as potential concerns with the bill. So I put it to you that these aren't organisations that are anti-VAD. We're talking about the principal trade union that represents doctors in the state of New South Wales and the college that represents psychiatrists in Australia. So that's what they are saying. So how do you actually square that with, and I say this in the most respectful way, what might be a relatively small group of doctors involved in VAD who are arguing the case that these obstacles need to be pulled down or removed because they're safeguards?
Well, I think I can answer you in two ways. Firstly, to say that I'm not sure that I'm required to, I'm giving evidence to assist you. I'm not sure that I'm required to read all of your submissions to your inquiry. It's your inquiry, and I'm happy to help.
Well, I just simply make the point, these are medical colleges and...
Yes, if I can answer your question. The AMA in Victoria was not supportive of the Act in Victoria. The AMA is a body and is entitled to their view. They are perhaps a body, as you did say that they were the medical trade union.
Yeah, I use that too deliberately. Yep.
I think they used that term this morning, in a sense. Or the RACGP did.
And therefore, perhaps it's not a surprise that they might be taking the view of the doctors rather than the view of the patients. And I know that Cam and Greg both talked of patient-centred care. So we haven't, really the way in which we deliver healthcare can be considered as patient-centred care or medical-centred care, or perhaps legally centred care or religious-centred care. There are a whole load of different ways we can look at the way we deliver care. But fundamentally, I think patients are wanting patient-centred care rather than any of those other options.
Well, may I put it to you?
And the fact that a medical body has a view, I don't think is an overwhelming. Of course, it's something for you to consider, but I don't think it's an overwhelming surprise or an overwhelming opinion.
Well,
Mr. Deputy Chair, we've only got 15 minutes left. I know Mr. D'Adam's got a question.
Sorry, I think the witness still has something else to say.
Associate Professor Cork, did you want to elucidate on that?
Well, I mean, I think that my role is in overseeing the system, and I'm giving you information about how we are doing that. I think these questions would be better put to Greg and Cam, who are more clinically focused.
No, unfortunately, we've only got a little bit of time with you. So Mr. D'Adam has sought a ability to ask a question. But if you feel that there's perhaps some stuff that you'd like to address to the committee, by all means, noting that you haven't put a submission in.
I'd like to ask a question, and my question will be after Anthony. For Cam and Greg to comment on the question that Mr. Donnelly put. So
I love it when people foreshadow. I'll Mr. D'Adam, but also
a question about the geriatricians.
We are not going to descend into this afternoon. Mr. D'Adam, you have the call.
Yes, thank you. Dr. McLaren and Dr. Mewett, I wanted to, both of you have touched on, I suppose, access issues and the capacity limitations of the system in Victoria because of the uptake of medical professionals entering into the system and getting certified and trained. And I wanted to ask about the extent, is there a backlog in terms of people trying to access the system? I know, Dr. Mewett, you mentioned that a number of your patients had been applicants, had died before they were able to complete the process. Is that as a result of the, I suppose, the choke points in the system, not as a result of the capacity, I suppose?
I think there's a range of reasons why people don't make it through the process. One can be some of the bureaucratic impediments that have been mentioned already. For example, proving your citizenship, proving that you actually changed your name when you got married. There's a number of requirements that take time to set up. But also there are patients who clearly deteriorate more quickly than expected and will lose capacity or die prior to being able to access their voluntary assisted dying. A couple of other things, and maybe we'll come back to Mr. Donnelly's later, but I think from my point of view, people want to access, and we have a lot of discussions with people about the access, and they repeatedly have to request access to VAD. They don't have a right to die. People often talk about this right to VAD. They have a right to ask to be assessed for VAD. They have a right to ask a doctor who's trained or someone to talk to them about VAD. They don't have a right to die. That's a pejorative. It's misleading, and I've heard that many times. But these patients have a right to be assessed, to be taken seriously. Some of these patients will actually not endure with their request. Others will continue, but some of them will not make it through the process. Cam, have you got some comments on that?
Yeah, thank you, Greg. If I may, just to follow on from the previous points, I think not everything in this legislation is a safeguard. For example, the requirements for doctors to return first request notices within a period of time after receiving them, that's in no way a safeguard. That doesn't protect the patient or the access. That's to improve the access by making sure doctors don't delay the process and that the board gets the adequate information. So not everything in the legislation is a safeguard, therefore not all suggestions by Associate Professor Cork were about removing safeguards. The second point I'd make is that not everything that is intended to be a safeguard functions as a safeguard. And in our case series of 344 patients, we saw that 114 patients died during the process of application. 112 of those patients were due to death during the application process, with a median time to death of about 20 days. So if the process is taking 3 weeks or longer, there's a significant attrition rate. The greatest step of attrition along the process, which you'll be able to have a look at in one of those presentations I included in the submission this morning, email this morning that hopefully will be distributed, is that one of the greatest step of attrition is between the consulting medical assessment and the written declaration, final request and contact person appointment. Now, this is a point in time when our 9-day cooling off period is active, and not only in our case series but also in the VAD review board report, is that we have not seen a patient withdraw from the process due to preference within that 9-day period. So one may question whether that intended safeguard is actually functioning as a safeguard or whether it's functioning as a barrier.
Happy to hand to Mr. Khan.
Mr. Khan, you have the call, noting that we've only got about less than 10 minutes left.
I suppose I want to, and this is to Dr. McLaren, some clarification in terms of the timing of people making the applications. If I took your last answer to be people are making it very late in the journey, if I can describe it that way, we've talked about timeframes of a person being diagnosed as having an illness that will essentially kill them within 6 months or 12 months in terms of the subcategory. That time frame seems to allow a lot of time in which the application can be made. But do I take it that in fact patients are doing it much later after that diagnosis in which to make the application for the scheme?
Absolutely, and this really speaks to our ability to prognosticate accurately, and also in specifically the non-linear behaviour of prognoses. So some of my patients may have a prognosis of many months, and then in the space of one day when they've had a CT scan showing that their cancer has progressed, their prognosis is now 4 to 6 weeks. So it's not a linear regression of a predicted prognosis by any means. Things change very quickly. And then, people, they don't want to die. They don't want to think about dying. They don't want to think about how they're going to die. That's just human. But then when they're faced with something like that with a short prognosis, they suddenly think, well, I need to get this organised, and they scramble to get it organised in time. I think in terms of particularly my cases that contribute to that 344 cases, but they're not all of mine, I have functioned for the patient navigators in the state as a practitioner who will see patients within, I'm going tonight at 7 o'clock to see one patient, and I'm going on Wednesday night to see another patient at 6 o'clock in the evening, and this is because they can't attend rooms, they can't, often they're bedbound, and these are the patients with particularly short prognoses. So I do feel like I see a skewed proportion of that of VAD applicants, and that I see the very terminal patients who need an experienced VAD assessor to make sure that there are no administrative problems along the way, or as few administrative problems along the way for their application.
So also in terms of your patient set, if I describe it, I think you only had one patient who was in a nursing home. Is that correct?
I believe that was Greg's patient.
Oh, sorry.
Mr. Khan, one patient that actually self-administered her VAD medication in a nursing home. I have a small series of patients. I was just giving a flavour. Most of our patients wish to take their medication at home, but there are some people who the nursing home is their home, and that's where they elect to take their medication. Yep.
Right. I think it's fair to say that we've received a not inconsiderable amount of evidence from the religiously based nursing home operators with regards to a provision of the bill that would require the the nursing homes to accommodate the taking of the taking of the substance in the context of the nursing home. I wonder if you have a view as to whether that provision is a necessary provision, taking into account your evidence with regards to numbers.
Yeah, I certainly do. Particularly my perspective comes not from, my personal belief is that an institution is not sentient, and therefore its ability to have an objection is questionable in my mind, but I know that's not everyone's perspective. Corporations. What I feel is that my perspective lies with the staff and the individual nurses and carers looking after those patients. And these people who are supporting this process or this patient through this process need to be able to individualise their involvement. So people talk about forcing institutions and forcing staff to be complicit in this act. But when you have an institution that conscientiously objects, you're also precluding those patients from conscientious involvement. And that, in my mind, is a greater risk factor for issues such as moral injury, where nursing staff are exposed to situations that they find ethically conflicting and are having to act in one way that is not in accordance with their personal ethical framework. So, to me, that's a much greater risk for those individual nurses and carers. And that's why I prioritise the individualisation of involvement of staff and also individual right of access of the patients or people who are residents in those nursing homes. I think, again, talking about a patient-centred perspective is that, if they would like to take their medication there, then that's fine. And I have heard concerns raised about people who talk about, what about the resident next door? I mean, what struck me about that argument is that I don't understand why the resident next door is privy to the information of that resident and what business it is of theirs. And I've got issues with confidentiality in that case. There's no reason why someone in the next door needs to be aware of what's going on. So I don't feel anyone, I feel the risk of harm is much less when individualisation is allowed.
Can I just ask you, Doctor, are we to take from what you've just said that if I'll use the vernacular, Granny Smith in the nursing home, who's there at the end of life, she just, in effect, and she obviously has people around her in the nursing home, her community, her network of friends, that she, in effect, disappears, so to speak. She dies. That it's your evidence that people would not necessarily know that she has ended her life with VAD. Are you seriously saying that?
Yes, I am. That happens every day in nursing homes. That's where people die. And people disappear every day in nursing homes.
That's not what I said.
Regular occurrence.
No.
The room suddenly cleared, Greg.
No. Well, listen, I've been into nursing homes before as well. I'm talking about the circumstances around the person's death. And what we're talking about is a person committing suicide or being euthanised. Now, people don't like this language, and it's been contested over the course of today. But the point that I'm making is that if I understand what you're saying, the implications are there isn't and ought not be considered, and be surprised that there actually isn't an effect on other people. This is just something that happens, that people would be euthanised or commit assisted suicide. Is that your evidence?
I'm sorry, Mr. Donnelly. People do die in nursing homes, and it's.
No, I know they do.
Well, let him finish, Greg.
Can I answer the question, please?
They die in palliative care units as well. I do. 4 persons die.
And patient confidentiality, it precludes the disclosure of the terms of that death to any other individual. So it is not the business of the person next door what happened to that patient other than they passed away.
So I gather you've read the research overseas, and there's a fair bit of it, of the impact on residents of nursing home facilities whereby assisted suicide and euthanasia, or VAD, is introduced, and that impact on the residents of the nursing homes. You'd be familiar with that research, wouldn't you?
Yes, I am.
Yes. And the position is that there in fact is quite serious effect on the mental well-being of people when that's introduced, isn't it? That's the evidence, isn't it?
I think that evidence is quite dubious in how it's been conducted, Mr. Donnelly.
Okay. Yeah, well, that's what we'll get down to. So.
Order.
Okay.
Order. I want to thank the witnesses for appearing today. Very much for giving your time and sharing your experiences with us. Unfortunately, we have run out of time. For the questions that you've taken on notice, the Secretariat will be in contact with you to arrange the tabling of those answers. And again, I thank you, and we'll have a short break now while we set up for our last witness. Thank you very much. Welcome back to our final session for today, and our final witness. I'll ask for you to state your name and position title and swear the oath, please.
My name is Michael Stead. I'm the Anglican Bishop of South Sydney, and I swear this oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Bishop Stead. Could I trouble you to make an opening statement, please?
I'd be delighted to do so.
Thank you.
As I said, my name's Michael Stead. I'm the Anglican Bishop of South Sydney, and today I'm speaking on behalf of the Anglican Church in the Diocese of Sydney. I do thank you for the opportunity to speak to this inquiry about the provisions of the Voluntary Assisted Dying Bill. The legal adage that hard cases make bad law applies to this voluntary assisted dying legislation. It is legislation for those in extremis, for the terminally ill who are experiencing intolerable suffering. Our hearts rightly respond with compassion when we see others in distress, and the reflex is to want to do something to ease or take away that suffering. It's perfectly understandable. However, out of that reflex has come this particular legislation, the impact of which cannot be limited to those for whom it is primarily intended. This legislation would be better if voluntary assisted dying could only be accessed after a person had had the benefit of high quality palliative care, and out of that had come to the conclusion that the palliative care could not reduce pain to a tolerable level. And furthermore, that it was, if we could be sure that those who choose to bring their lives to an end were not acting under any kind of external influence, whose mental faculties were in no way impaired, and who are not making a decision in a depressive state. The problem is, of course, that the legislation cannot guarantee any of those things, and therefore will impact more people than those for whom it is intended. Our submission proposes a number of amendments to protect 4 classes of vulnerable people from the unintended consequences of the bill. They are those with limited or no access to high-quality palliative care, older Australians who might be subject to manipulation by unscrupulous family members, those who are subject to depression or other mental illnesses, and those who are living in residential aged care. I am aware that a number of amendments have been made to the bill since we tabled our submission, and at a number of levels, at least in 3 of those 4 cases, I'm pleased to see that there have been some amendments that go some small way to addressing the concerns that we've raised in each case. The very limited nature of these amendments not only signals the problem, but also signals that not enough steps have been taken. So I note that, and I'm happy to take specific questions on each of these topics, but there's been a minor amendment in the definition of Section 4 to include high quality palliative care and medical care, but not the other things that we've suggested. That there has been some clarifications by Minister Stokes around the issue of manipulation and assurances, the requirement to give statements about pressure and duress, but again, they don't go far enough. There have been some clarifications in relation to the eligibility criteria around dementia, but there's still no requirement of an objective psychological assessment, as we've recommended, and there have been no amendments around the issues related to residential aged care. So I'd be very happy to take, obviously, I realise my opening statement is limited, but I'd be very happy to take particular questions around those areas as to why I think the accepted amendments don't go far enough. Let me finish my opening statement by saying, that, and just to be clear, that even with those amendments, I would still have in principle opposition reasons for opposing the bill. But it would change from a bill that I would personally not recommend and counsel people against, as to or something that I think is in principle bad for our society. So I'm proposing these amendments because I want to make, if we're going to have a bill, it's got to be something that is actually that will work long term for our society. I am concerned about the long-term impacts of this bill and what it says to people who have diminished capacity, what it says about people who already feel like they are a burden and who might quite reasonably decide that they want to take their life, not because of intolerable pain, but because they don't want to be a burden to their family. I am concerned about what it means for the definition of what compassion looks like. I am concerned because of what it says about an apparent affirmation of a right to die. I don't believe there is a right to die. I'm happy to take questions on that, but this bill is taking us a step in that direction, and having taken that step, it inevitably leads to wider questions about when and where we will offer state-sanctioned support in the right to be killed, because that's what this legislation is providing. So for those kind of public policy reasons, I'm actually opposed to the bill in principle, but if we have to have a bill, then it needs to be one that safeguards the vulnerable. Thank you for the opportunity to make that opening statement.
Thank you. And now we will turn to questions, looking around the committee to see if I have somebody who...
I'm happy to start off.
The Honourable Scott Farlow.
Thanks very much. Bishop Stead, I might just invite from your opening statement there, you mentioned about you don't believe the right to die. I take you believe in the right to life. Do you want to maybe expand upon why you believe there's a right to life but not necessarily a right to die?
What I do mean is that it's not for society to determine it's not for society to support an individual's determination that they have the right to end their own life. I'm not saying we should criminalise suicide. People can choose to suicide, and there's nothing we can do to stop them. But as a society, we should be doing everything we can to counsel people against that, and therefore we should prevent suicide to whatever extent we possibly can. Therefore, as a state, there should not be, as a general rule, a state-sanctioned right to be killed. In other words, I want to die, and the state has to support me in that right and will provide me with the medical support to do so. That goes so much further. If that's the basis for this legislation, then we must not have this legislation, because there's no way that you can stop that at the point of the terminally ill. A perfectly healthy 41-year-old who's feeling depressed and feels that there's nothing left to live for, who decides, I want to end my life. I do not believe that we should, as a society, support them in that right. We should actively prevent them at the extent that we're able to do so. Now, if the case for euthanasia depends on an ethical right to die, then we should oppose it for that reason. I realise that's not the reason why it is being promoted, but that's my fundamental objection to this bill, is that it's actually opening the door to that very idea that an individual can decide, okay, I'm fed up with the life, I want to kill myself, and it's not just I want to do that, but that the states should support me in doing that.
Bishop, can I then ask you, following on from that, if somebody elects that they want to not suffer through pain, we've heard testimony throughout the past 3 days that people are taking their own life in circumstances where they are facing or are in intolerable pain, and they do so alone with means or methods that perhaps aren't as humane or as...
well, some of them are just straight out violent.
Yes. And so while I accept your position that we shouldn't do this because of a number of reasons with which you've articulated, the reality is that we know that people are doing it. And so...
I perhaps haven't made my point clearly enough. I'm saying the philosophical underpinning for the reason why we act must not be because we believe individuals have a right to die. If the reason we're acting is we believe an individual is in intolerable suffering and it's out of compassion to limit that suffering, that's very different to the autonomous individual deciding I can end my life at any time I choose.
That is in so many cases of which the testimony has been over the last 3 days, the position with which the bill is being put forward.
And I'm saying that is a terrible philosophical basis, because if that is the reason why we're approving this bill, then there is no reason why we shouldn't apply it to the 21-year-old who suffers from depression. Why shouldn't we allow them their autonomy? They've chosen that they want out, and I'm saying as a society we've never done that. We've actually said to the 21-year-old who says I want to die, we want to help you.
I feel like we're going down a very huge philosophical discussion, but I guess there are marked differences in that this bill is related to people with a terminal illness who are perhaps... Whereas the 21-year-old may, elect to do it through a number of means because they have the faculties and ability and movement and the like. We are talking about people who are perhaps terminally ill, maybe bedridden, in insufferable pain.
The bill is only in the event of terminal illness.
I think there are some marked differences between the two people that you are drawing parallels to, and I guess you're drawing the parallel that this is a slippery slope. But
point of order. I'm not actually making a slippery slope argument. I'm actually saying it's the philosophical underpinning. So if you say the reason for the bill is because we are addressing the terminally ill, and I understand that is exactly what the bill is saying, that could be morally, philosophically justified. I'm not persuaded by it, but I can see the justification there. What I'm saying is we should not pass the bill if the only justification is based on individual autonomy and a right to die.
I think that's fair. Yeah. I think that's fair. Yeah. You got me on that one.
Yeah. And Bishop Stout, I might just continue in terms of some of the substantive issues you've raised with respect to the bill as well. You mentioned in your opening address that you believed that the amendments moved with respect to duress by Minister Stokes in the Legislative Assembly didn't go far enough. Is there any substantive position you want to put before the committee as to what could be further amendments to address your concerns in that regard?
Yeah. So the amendments put by Minister Stokes and passed were effectively notification provisions. They didn't change the definition of pressure or duress, other than adding a clarification that elder abuse could be an example of that. But that's kind of already contained within the definition because the word abuse is there.
But this effectively goes to your modification that you proposed with respect to the definition in Schedule 1, is that correct?
That's correct, because there will be lots of activities that will occur in families behind closed doors that will not amount to pressure or duress understood legally, but nonetheless will be manipulative, that are designed to induce elderly, frail relatives to exit more quickly than they otherwise might have chosen. And I'm saying we need to go wider than that.
Can I ask a follow-up question?
Sure.
We just heard, Bishop, from the last witnesses, and it's something that had troubled me, the assumption that seems to be made with regards to coercion and duress is that the coercion and duress is all aimed one way. That is, coercion and duress, or coercion in some sense, for a patient, in brackets, who is dying within a relatively short period of time, close brackets, to end their life even quicker. But what I want to suggest to you is that family members may in fact be coercing the patient actually not to end their life, and nobody seems to worry about the fact that the patient may be being directed in a course of conduct that the patient actively doesn't wish to pursue. That is, to stay alive. Do you worry about that prospect? And if not, why not?
In my profession as a minister, I visit palliative care units and nursing homes on a very frequent basis. Over and over again, I speak to older people who say, "Oh, I don't want to be a burden, and I wish I could go home." And these are Christian people who we're not afraid of dying.
But that's not only a comment that's made by Christian people; it's made by a lot of elderly people.
That's right. Yeah. And I'm not aware of. Because it's never been a choice that people have had to make at this point in time. I'm not aware in any circumstances of the family saying the only coercion, if there is that, is family members saying to their parents, "No, you are not a burden. This is not a burden. This is an act of love as we come in and visit you, and we are not burdened." And they need the reassurance to know that they are loved, and this is how their family will show that love.
Well, Bishop, let me just suggest to you that the evidence that we received from one of the last witnesses, was patients who are effectively coerced into continuing with a course of chemotherapy which the patient may not wish to persist with. Now, I could think of a number of other circumstances. I'll suggest another one. Patients who choose to give up eating because they want to die and are then pressured by the family to eat. Now, I know that's an extremist one, but the coercion doesn't have to be one way. And indeed, if you talk about subtle coercion, such as that, it may be for the best of intentions. That is, in a sense, if we talk in, as some of our submissions have, talk in terms of transference, what the family member thinks is the right thing to do may be quite different from what the patient wishes to do, or the dying patient member. But I don't think you can necessarily say it's all bad.
I can only speak from my experience. I haven't seen any coercion going the wrong way, as you would put it.
Really?
Of that kind. And my follow-up point would be to say, and even if there was, the consequences of that are not permanent, whereas the consequences of coercion into voluntary ending of life is irreversible. So even if there was that kind of coercion going on, it's not beyond the possibility that other medical staff can intervene and say, actually, there's no point continuing this hopeless treatment of chemo. It's only just making them sick. It's addressable and reversible. But the very problem with the issue that we're dealing with here is that terminating a life is terminal, and if it's irreversible.
Of a patient who is dying.
Yes.
Of a patient who is dying. Yeah. Like we're dealing with a class of people where there is an identifiable outcome, that is death. The question is the quality, in a sense, of that death from the perspective of the patient. Isn't that right?
I would put the focus on the quality of the last stages of their life rather than the quality of their death.
Well, Bishop, I don't really want to read to you parts of the transcript as I've done with other witnesses, but some of the evidence that we've received in this inquiry is the quality of the passing has been appalling. And that's